Is this okay? Good morning, ladies and gentlemen, land friends, colleagues. Welcome to the Young Lawyers Symposium 2025. The long awaited day is finally here. Um, to the people that are online, that are converging online, we see you and we just want to welcome you, settle in, and please pardon us for the delayed start. We had some glitches here and there, but we are now here. And we just want to let you know that you're not alone out there. We are right here, and we have some people physically here in the room at Praxis Conflict Center. And if you have some time, please make sure that you fall in. My name is Joy E. Mbabazi. I am a lawyer as well, and I'm privileged and honored to be hosting this event, the Young Lawyer Symposium. And I am a young lawyer myself. There's been a bit of a debate out there asking who is a young lawyer and what does it mean? Is it by age? Is it by the number of years somebody has spent in practice? Like, what exactly is that? Probably we'll figure that out, and at the end of today or tomorrow, we shall have known who that young lawyer is. Or maybe it's going to be like that conversation also on the street, like, should a lawyer buy land first or a Benz? A car, okay? So there's also that bit of debate. And somebody said last time at the tech summit that if you have a car that's not a Benz, a car is specific to a Benz. So that is A or B. I just want to say you're very welcome. I do quite a number of things, but for this particular one, I am the team lead of Dear Young Lawyer series. Probably some of you have seen some of our work on X, and it was founded by Counsel Miyaka Alfred, and we have a team of young guys there. We do mentorship for the young lawyers. Now, this is going to be a different bracket. We normally do like mentorship for universities. We partner with the law faculties and get on there and talk to those young people. And then there are those who are in between crossing from university to get into LDC, the preparations, and then those at LDC, and then how to get out there, what happens, that bridge between after classroom, and how to get into the field, ground. Yeah, so we do that kind of mentorship. And I also contribute to more like a podcast of sorts, Judicial Service Conversations with Counsel Elson Karhanga every Wednesday, where we talk about matters that affect us as lawyers and how to get better. And I also do some charity work, yeah, empowering communities, legal literacy, etc., etc. But for the benefit of this symposium, let's go with Team Lead, the Young Lawyer series. And I look forward to interacting with you, learning, refocusing and all that, because, hey, this is a very, very opportune moment where we get to mentor, to get access to mentorship, get to hear stories, because I think the biggest platform that any person has is their story. So we're going to hear stories from different people, those who have gone ahead of us, those who are doing good in the field. And it's going to be an all-round. Counsel Zubeda right here, who has forcefully picked me up as a mentor and is doing some good work with me, has called it 360. It's a 360 angle. You see, I'm learning, yeah. So we are trying to get ourselves to that level where we are all round, be it financially, be it personal life, be it family, and for the bit, because we said we were going to figure out what that young lawyer bit means, but sometimes you find that you're torn between starting a family and trying to make money, which is not, the math is not mathing, but you need to make things work. So how do you do that balance? And there's also that bit of, okay, now the family has started, then the kids are coming, and am I not going crazy? So all that is something we're going to get into. There are different panels. We have amazing people who are just going to take us through that. So I can assure you that the money invested in this is going to turn your life around. That is, if you put it to work. And I just want to just quickly run us through the program today. I'm still here with you. I'm just getting some communication in the room. So today in particular, we're just going to be talking about the future of legal profession in our hands. And then we're going to be also talking about law, leadership, and legacy, or positioning yourself for lasting relevance. I'm looking forward to that particular one. And then we're also going to have some bit of legal writing for young lawyers. And I know that when they talk of legal writing, we've done a little bit of it at LDC. And some people feel like it's just about the pleadings that you get into, how to write. But then I am learning lately that it's more than that. So make sure you don't miss that out. And then after that, we're going to be talking about mastering the human side of legal practice, talking about soft skills and how soft skills that move the needle. I like that. That's how they coined it. So it's okay, you have your degree, you went to LDC, but now what? Is that enough? Because you see, there's several thousands that are getting out, that are being released into the field. But then how do you set yourself apart? How are the people who are doing good getting there? What are they doing? What is different? What is special? And when we try to take a little bit of a picture into a leap into the future, what does it look like? And I believe this is what is going to do for you today. And then later we'll have courtroom communication, talking about presence and advocacy skills or trial experience. This is something you're also going to need. For some people, I think the last they did this was the moot experience at LDC. So this is going to be something that you need, because then you get to hear from the people that are doing that. And I believe it's not going to leave you the same. And then we're going to wind it up with a panel discussion from registry to resolution, the full spectrum of ADR in Uganda, that is alternative dispute resolution. So you can see it's beautifully packed together, and it's going to be insightful. So I don't know if you have a pen with you like I do, and a notebook right here. I think a good lawyer is one who is always moving with a notebook and a pen, because you just can't be there. Now that is me who has coined it, okay? Okay, so I think we have done a little bit of the introductions, and we just want to let you know that this symposium is brought together by different groups of people who have sat together, thought about us, and said, hey, let's put this together. And so I want to recognize Bluebell Advocates, recognize Praxis Conflict Center, which is actually hosting this space. And then there's the Uganda Law Society. Definitely, we do appreciate you. And then there is MAMC, which is the Muslim Arbitration and Mediation Center, Uganda. So these are the partners that are making this very, very possible. And then right now, I just want to take it up to give it back to the ULS Vice President, Council Anthony Asimwe, to give us the opening remarks, and then we get going. Thank you. I think as our Vice President gets ready, I just want to take this opportunity to recognize.
Hello.
Oh yeah, he's right here.
Good morning. Can you hear me before I proceed?
Hear you. We do hear you.
Right. Thank you very much. The Honorable Chief Justice Emeritus Justice Bat Katereve, our distinguished speakers and panelists for today, esteemed members of the bar, dear young lawyers present today, a good morning to you all. I bring you warm greetings from the President, the Executive Council of the Radical New Bar. And for us, it is both an honor and a privilege to welcome all of you to this 2025 Young Lawyers Symposium held under the theme, Legally Balanced, Mastering Practice, Purpose, and Personal Life. This year's theme it directly speaks to the heart of the modern legal professional, one who must skillfully navigate the demands of legal practice while staying grounded in personal purpose and fulfilling life beyond the courtroom. It's not just about what happens in the courtroom. I look at the structure of the discussions, and it goes beyond that. It's all round. Over the course of this symposium, we shall delve into a range of topics like it's been explained, and these are really essential to building a well-rounded legal career, including legal writing for young lawyers, in mastering the human side of legal practice, courtroom presence and advocacy skills, financial planning and investment. For me, this is the most important for all of us as lawyers, because we tend to focus more on practice and making money and so many other things, but focus less on investing and personal life, which I think for the organizers, really, this is a brilliant idea. Personal branding for lawyers is another exciting area for me, especially for a young lawyer who's beginning practice. How have you branded yourself? What do you stand for, and what should people expect? What do you sell out there to the public? They're really exciting, topics and areas for today. And I believe this platform is not only about learning, but also about mentorship, which is the most important aspect of a young lawyer's life. A young lawyer who's beginning practice, mentorship is one of the most important aspects. The Young Lawyer Symposium is really a space created to give you, our emerging leaders in the legal field, direct access to those who have walked the path before us, those who have been there before us, those who have been tested, those who have seen it all. And I urge each and every one of you to listen keenly, engage actively, and take to heart the insights that will be shared here. Also, allow me extend our heartfelt gratitude to the Honorable Chief Justice Emeritus Justice Bart Katurebe for honoring us with his presence today. Sir, my Lord, your continued commitment to guiding and inspiring the next generation of lawyers is deeply appreciated. We do not take it for granted. When we called upon you, you responded, you are available, you are committed to supporting the young lawyers back on the line. Colleagues, let us approach today with openness, curiosity, and purpose. Ask questions, take notes, as all of you have pens and paper, or you have where to type in this digital era. And above all, let this be a moment of growth, not just in your legal skills, but in your vision for the kind of lawyer and the person you want to become. Also, as I conclude, allow me to thank our partners who have come in to support, as earlier alluded to, take this for granted. We believe committing to this kind of growth is one of the most important aspects anyone can contribute to. I thank all, and I wish reaching symposium. Thank you very much. Over to you.
Thank you. Thank you very much, our most perpendicular Vice President, Council Anthony Asimwe. That was very insightful. And yes, pen and paper or digital, have notebooks somewhere and there to note. And yes, we want to take a moment as well to recognize the presence of Chief Justice Emeritus Bat Katerebe. Thank you very much, sir, for honoring us with your presence. Somebody was looking at your desk and the books before you, and they said, hey, look at that whole material and the wisdom that the man moves with. So we look forward to downloading all of that, sir. And I think without wasting any further time, because I understand that people online have been waiting and waiting and waiting. Specifically, I just am recognizing there's Agri, there is Emmanuel, we have Jeffy, we have John, we have Gerald, we have Francis. Yes. Pardon me if I murder your names. I'm trying. I don't have my glasses here, but yes. So thank you very much, colleagues and land friends, for just being there. And Job Matovo, I see you as well. Good morning. So keep us up there. Send the messages. Let us know that you're there with us, as we also let you know we are right here. So without wasting any time, ladies and gentlemen, the very first item on our program for today is talking about the future of the legal profession in our hands. Sorry, a keynote address, sorry. We're talking about law, leadership, and legacy, positioning yourself for lasting relevance. And I can assure you that the Chief Justice has a lot of material that we're going to get from, so get yourselves ready. And I just want to give you a little bit of information about him before I can ask him to get on, just in case, you know, this is a young lawyer symposium. You never know, you're saying, who is that? Who is that person? But he is a co-founder of Praxis Conflict Center Limited, which is the space that is hosting us today physically. And he's the Chief Justice Emeritus of the Republic of Uganda from 2015 to 2020. He began his career as a state attorney at the Attorney General's Chambers in 1975, having completed his LLB and diploma in legal practice in Makerere University and Law Development Center, respectively. He rose to the rank of principal state attorney, and then in 1983, he went into private legal practice for 5 years before being appointed a government minister in 1988, where he held various portfolios, including the Minister of Justice and the Attorney General. In 2001, after his service in government, he went back to private legal practice until 2005, when he was appointed a Justice of the Supreme Court of Uganda. In 2015, he was appointed the Chief Justice of the Republic of Uganda, a position he held until his retirement in June 2020. And since his retirement, he has been appointed a member of the Committee of Experts of the International Commercial Court of China. He is also a member of the London-based steering committee of the Standing International Forum of Commercial Courts. And he also currently spends a lot of his time as an arbitrator and mediator, including as a court annex mediator of the High Court of Uganda. He has 6 children and many grandchildren, and he enjoys farming and hospitality. Ladies and gentlemen, if you would clap right there on screen for those that are out there and those here. Yes, thank you very much. I would like to take it to our guest of honor, Chief Justice Bat Katerebe. Over to you, sir.
Thank you very much. The President and leadership of the Uganda Law Society and all the members, thank you very much for inviting me to participate in this symposium. When I received your invitation 2 or 3 days ago, my first inclination was to refuse. I didn't think that it was fair to invite me to give a keynote address 2 days from the event, because I think normally you need time to prepare and make something presentable. But on second thought, I thought talking to young lawyers, basing on my own experiences, might be beneficial even if I don't have a formal paper to present. So I thought I would speak from just prepared notes illustrating a few things from my own experiences. As you have been told, I have been through a lot of things. I think they say a jack of all trades and a master of none. From humble beginnings to life as a state attorney, as a private practitioner, as a minister in various ministries, and a member of parliament, member of the Constituent Assembly, and later Supreme Court judge, and over 10 years and 5 years as Chief Justice, and now 5 years in retirement. I think it gives you an idea of what goes on in the life of, from being a young lawyer to reaching where you have reached. So I thought on that score I will come and help you to look at my own life in the context of your own lives as they are coming up now. I don't know where you are in my life because it's now 50 years since I left Law Development Center and joined government. So many of you were not even thought of yet at that time. I have made some references, which I will cite a few passages from, but I brought these books just to help you to go and search for them. Maybe you can get them online. One book is called Winning with Honor. In relationships, family, organization, leadership, and life. It is by Professor Seong Guan Lim. This was a book given to me when I was attending a course at the Lee Kuan Yew School of Public Policy in Singapore. And I think it would be useful for you to read. The other book I would make reference to is a book entitled The Safest Shield by the Lord Judge. The Lord Judge Igor was the former Chief Justice of England and Wales. And this is lectures, speeches, and essays that he wrote or gave after his retirement as Chief Justice. I think you will find many of these very relevant and very instructive. I'll just quote from one or two. The other one is a book recently sent to me by a former Prime Minister of England, Tony Blair. It's entitled Tony Blair on Leadership. Since you asked me to talk on the theme of law, leadership, and legacy, positioning yourself for lasting relevance, I really thought Tony Blair, as a former Prime Minister of England and Wales for a period of 10 years, and from his experiences of interacting with other international leaders, I saw in the news that he has even been put on the board that hopefully will govern Gaza. His insights into leadership, I think, should help us in shaping our own. He's a lawyer from a very well-grounded legal family. His wife is a QC or KC now. His brother, who was a personal friend, Sir William Blair, has just retired as a judge at the head of the commercial court in London. So someone from those experiences, I think, will have a few things to read. I've also got this one. I haven't. I'm not quoting from it. This is my own personal experiences. It's available in the bookshops. Anybody who is interested in it, you can have it. But it will also give you an idea of how you come from Law Development Center, join the Attorney General's chambers, end up going back to the Attorney General's chambers, the Attorney General, join the judiciary, and end up heading the judiciary. I think it's an experience maybe some of you may wish to look at. So those are some of the resource materials I looked at very quickly in the last 2 days. So I thought a few passages I would quote from these will give you an illustration of what we are saying. Now, you have given me the theme, law, leadership, and legacy, positioning yourself for lasting relevance. Let's first ask ourselves, why did you go to study law? Each one of you, if you could look into yourself, your inner self, why did you go to law school? There are some of you who may have gone to law school not because you wanted to study law, but because that's what your parents wanted. I think those of us who are parents have gone through that. We have seen that. I know of very close family relatives of mine. The gentleman was an engineer, and he really wished his boys to be engineers. Now, neither of his three boys was interested in the engineering field. Actually, one who went there, spent there 1 year and told him, "Daddy, I am not interested in engineering. He wants to do accounting." And the father was very cross, but he had his little daughter, the young one, whom he really doted on. So she said, "Daddy, I will do engineering for you." So he sponsored her abroad, the University of Birmingham. She did very well, got a first-class honors, did a master's in civil engineering within no time, and finished it. Then she came back home, and I attended the graduation party when she was celebrating her graduation with very high distinctions. And in her speech, she said, "Daddy, you've got your engineer now, but I didn't think I would ever go into engineering as a woman." And she was giving him information. She had branched into financial services. And she's still in London doing very, very well in financial services. She did the law degree for her father. So I don't know how many of you did law for your parents, not because you are interested in law. There must be many of you who did law because you wanted to practice law. When we read the old books, there were stories of a lawyer called Perry Mason and a series of books. You read that and you see yourself in court arguing a case, solving things, and and I want to be a lawyer. I want to be like this. So there must be some of you who did that. So you have a keen interest, you want to be a lawyer, and you study law and you want to practice it. There are those of you, sadly, I hope they are not the many, who want to make money. You see lawyers as very rich people. And we used to have a lecturer at the Law Development Center called Mr. Rizu. He was a Nigerian. And he would tell us, a lawyer, even if you are broke, you don't bend your head. You must walk straight up. And even if you are broke, you must drive a nice car so that you give the impression of, well-to-do and well-being, and that attracts your clients. So there must be some people who went to law because lawyers give that image of being well-to-do, nice cars, nice homes, good fat bank accounts, and so on. We'll talk about that as well. Those are there. How do you make the money? By legal practice, obviously. But don't we know of lawyers who make money by legal practice, which includes coaching witnesses, hiding exhibits, bribing judicial officers, bribing the police, and you have a society who say, we want a lawyer who is effective. No matter how he gets his results, but he's effective. I remember when I was Attorney General, a name came up of a lawyer that was earmarked to be appointed to some office. And I was given the assignment to consult some lawyers about him. And one senior lawyer said, yes, this man, very effective. But if you ask his ethics of how he gets his effectiveness, you have to be very careful. So that is a reputation that you may establish. Remember, our theme takes us to legacy and positioning yourself for relevance. If you want to grow up and be known as a successful lawyer who made a lot of money, but don't ask how he made his money. Again, you have to make that question. Now, the training of a lawyer makes you versatile. You can end up in politics as I did. You can end up in international organizations. You can end up in charitable organizations. You can end up even in religious ministries. Archbishop Sentamu, who became Archbishop of York in the United States, was 1 year ahead of me in Makerere Law School. And he ended up a very high church person. So the training of a lawyer makes you versatile, and you can fit in so many aspects of society. Or you can end up as a judicial officer. Now, we are having many judges and magistrates and registrars being appointed today. It's actually, I think, the golden period of the judiciary in Uganda today. Because when I was Chief Justice, I think the High Court had a total of 45 or 50 judges. And our quarrel was always with the Parliament and the Executive, how you could be increasing the number of members of Parliament without increasing the number of judicial officers, and yet we are all the time being criticized for not not reducing case backlog. How do you reduce case backlog without the personnel to do it, the budget to do it? But at least now there is a budget, and many people are being appointed to being a judicial officer. The question now is, when you are getting to be appointed a judicial officer, are you going in there to serve the ends of justice, or you see it because judges and judicial officers now have slightly better terms than were in place, slightly better terms than maybe many lawyers in private practice make on a monthly basis, and then you say, well, I'm not really interested in being a judge, but I think I can make ends meet better by becoming a judge, and you apply and you get it. How well you do as a judge remains to be seen, because that's not your driving. I recall a personal experience when we had just come out of the Law Development Center in 1975. I was, touched upon to get interested in teaching at the Law Development Center. And I said I was not interested in teaching. As you can see, I'm having difficulties even making this lecture because I'm not a good teacher. So I told them I didn't want to teach. And they put my name. At that time, you must remember, we were not looking for jobs. We were bound to serve in the government for 5 years. So there was a decree to that effect. As soon as you get out of university, you must serve. So the jobs were there. Many people had abandoned jobs as magistrates and lawyers and principal state attorneys. So I was put on the list of the people to become a magistrate. And I didn't want to become a magistrate. So I turned up at the High Court for an official interview, and I was given a form to fill. So I didn't fill my form. So when my turn came to go into the office of the Chief Justice Said at that time, I had a form, but I had not filled it. So the Chief Registrar said, but Mr. Katurebe, how would you expect to be appointed if you have not filled an application form? And I said, I have not filled it because I don't want to be a magistrate. So the Chief just said, why don't you want to become a magistrate? And the Chief Registrar said, Mr. Katurebe, if you don't want to be a judicial officer now, then even in the future you should not be hard to say you want to become one. And the Chief just said, no, leave him alone. If he doesn't want to become now, maybe in the future he'll change his mind. So he said, what do you want to be? I said, I want to learn to be a lawyer first, then I can become a judicial officer. So he said, where do you want to learn to be a lawyer? I said, in the DPP's department, because I had applied there. He said, okay, you go. So I missed out becoming a judicial officer at that time. I was clear what I wanted to be. I wanted to learn to be a lawyer. So I went to the DPP's office. And in the DPP's office, for 2 days, actually, exactly 2 days. And then there was a meeting at the Law Development Center of the Management Committee. And the Solicitor General was a member of the Management Committee, the late Matthias Matov. So they were talking about us, our class, which was quite a distinguished class, both from Makera and LDC. So they said that there is this stubborn man. We wanted to keep him, he refused. We tried to send him to become a magistrate, he refused. So the Solicitor General said, so where is he? They said, he has gone to the DPP's office. Then he said, I want him. The next day I was sent to the office of the Solicitor General, and that's where I stayed for the next 8 years. So you get some of the successes that you'll make in life are a bit of luck, because I think for me that was, luck. And 8 years in the Attorney General's chambers, I think helped shape me and my outlook on things. So having discussed this, the various reasons that attracted you to go and study law. Let me quote the words of what the Lord Judge Igor said about a similar question when he was addressing, giving a lecture to law students at the Faculty of Law at King's College London in April 2014. And the lecture was, why study law? Which is the same thing that I started with here. I think his words, I'm going to read them verbatim from this book. Quote, the study of law gives you huge additional opportunities to learn much more than the law. If you take advantages of them, you will learn about your fellow human beings. You will think about your fellow human beings, the wonderful things they do, the dreadful things they do, the stupid things they do, the courageous things they do. If you are blind to the people whose cases will form part of your daily studies, blind to the stark fact that leading cases, however exciting for academic study, are or were about real people who at the time of these cases, even if 100 years ago, would have felt that their whole life turned on what has become a legal exercise for you. If you do not occasionally pause to think about them, you will, when you qualify, be a less sensitive, dry lawyer, and I respectively suggest that you'll be less in touch with the common humanity which we all should share. I thought those were very challenging words to these students, and they should challenge us also when you reflect on them. That being a lawyer helps you to look at a larger perspective on society. The case you are handling is not just a number, it's about real people with real problems. I have been trying to do some mediation for the family division, and I have actually had to give it up because you end up being more of a counselor than, you know. But these are real situations. I had a case recently where a mother with her 4 children, a mother with not stepchildren, her real children from the same father, fighting over the estate of their father, which the mother had taken administration of, and the children were not satisfied with her administration, and they were challenging. And so they went to court. The matter is in court. I don't know whether it has now been resolved, but it was in court. And for 4 years, that family had not been talking together. The children were not talking to the mother for 4 years. So when they came to me, I had the first difficulty was the woman did not want to sit in the same room with her children. Here, in these offices here. So we had to advise, put them in one of our mediation rooms as I sat with that lady for 2 hours trying to persuade her to talk to her children in the same room. And then the boys, she was referring to them as Ebyana. You know, Ebyana, I think in Uganda, it's derogatory. You'd say Umwana or Abana, but Ebyana is the, you know. And they were also referring to her as Omukazo Yomuzibu, that woman. So, but at the end of the day, I spent up to 4. Normally, I don't work beyond 1 o'clock myself, but that day I was here up to 4, trying to. Eventually, they sat together, and the next day, it was so pleasing to have those 4 children. It was 3 women and 3. They were not small children. They were women in their 40s and early 50s, with their younger brother who was in his late 30s, I think. Those 3 women knelt down in front of the mother and said, "Mama tusenywe." This was the human aspect of the dispute that would be lost to us in the courts. Because in the courts, I will look at the evidence, I will look at the arguments by the lawyers and make a decision. You will make the decision, but these people will go back home and still not talk to each other. So you may have resolved the legal problem, but you have not resolved the human aspect of the law. So this is what I think this judge is talking about here, that when we study law and we are handling a case, let's not look at it in numbers. Case number this, out. Case number this, dismissed. Case number this, allowed. Let's remember, these are human beings with the real human issues, and sometimes in the court, we may not give them justice. We may administer the law, but sometimes we may not reach the core of the dispute. And this is what he's talking about. And when we are in the other aspects where we may go as a lawyer, as a politician, as a leader, as a leader of your law firm, I am told that even in law firms, a lot of unethical things happen there. You cheat each other. You don't know. You know, you are practicing, someone gives you a place to work as an associate, and then you use that office to do your own legal business. So you're actually running your own firm within a firm. And your partners, your senior partners may never know what you're doing. Now, all that is not what builds you to leave a legacy of being a lawyer and having studied law to do justice and be an ethical lawyer. The Chief Justice continues and says, the second opportunity that the study of law will give you is that it will test your attitudes to life, your prejudices, and your preconceptions. And the third area of opportunity provided by studying the law is that you are given the opportunity to contribute to the civic life in our country. Now, we see a lot happening in our country. And what do the lawyers do? Do you become part of the problem, or do you offer yourselves to be a part of the solution? If we have issues of corruption in our community, in our society, do you, as a lawyer, become part of the solution by pointing out, by living the ethical life that we learned in law school about ethical conduct and so on, or do you also cheat clients? How many cases do we see now before the Law Council of lawyers accused of cheating clients? If you are cheating clients, that is the way you make your money. And tomorrow they make you a minister. Tomorrow they make you a judge. How are you going to give up that habit? This is what this judge is talking about. How are we going to carry our legacy as lawyers into society, in the various aspects of society where we may serve, and still leave a legacy that we can say, this man was indeed a true lawyer. I remember someone telling a story that they were in a cemetery, they had gone to bury somebody, and then they saw an epitaph which said, so and so, a lawyer and a good man. And then somebody remarked, said, they must have buried the wrong person. Is that what we want? Is that what we want? We have got to challenge ourselves. Now, I remember when I was practicing law, this must have been around 1986, I think, 86 or 87. I had my chambers on Plot 2A, Kampala Road. And on the opposite side was the Ajip House. I think it is still there. I don't know whether it's still called Ajip House. There was a lawyer who had been my classmate, and he was having a very successful legal practice. So one day I received a client who came to see me. He's not my client. There's a gentleman who walked in and said, they have told me you can help me. I said, what is the problem? He said, I have a problem with your colleague, the lawyer in the opposite side. I gave him my money to represent me, but now I have noticed he's also taking money from my opponent, so I want him to return my money, and he's asking for more money. I didn't know whether that was true, so I suppose stupidly I walked across, and my colleague was there. So I said, what's happening? This man is telling me this. The man says, but me, I'm in this business to make money. If you want to be an angel, that's your problem. You go and tell that man to bring my money. You know, just like that. Now, where do you want to go? Where do you want to fall? These are things that we know are happening. You give so much money, you get what you want. Sadly, even some judicial officers have come to be known. If the consideration is right, you get a judgment. This is not helping us. Now, we have to realize as lawyers, more than anybody else, that this law and the rule of law protects all of us and as well as it protects society. The Chief Judge gives an example of one of his long-term predecessors, Chief Justice Edward Coke, who became Chief Justice in 1606 in England. And he fell out with King James I. The king didn't agree with the views that this judge was holding, so the Chief Judge was arrested and thrown into the Tower of London. Have we not had that before? The other day we were celebrating Benchuan Day. That's something that happened there. But this gentleman wrote a treatise called the Institutes of the Laws of England. And in there, Chief Justice Edward Coke wrote the following: "The law is the safest sanctuary that a man can take, and the strongest fortress to protect the weakest of all. In summary, the law is the safest shield," which is the title of this book. That's where the book comes from. So this is a challenge to all of us as lawyers. When the law is being trampled upon and is being questioned and is, I spent a long time, 5 years as Attorney General and 5 years as Chief Justice, with many battles. There was a time when someone says, "Kature, this constitution of yours," and I'd say, "Your Excellency, it's not my constitution. My job as Attorney General is to tell you what the constitution says and advise you on how it's not mine. I may not necessarily like what it says, but my job is to tell you what the constitution says." And so how many of you, you get challenged? Those of you who have tried to go into politics, you get challenged. Those of you who are in civic positions, you go to court, you are representing a client, he has been rearrested, the judiciary is under attack for giving bail and so on. All these are challenges to the shield which is supposed to be protecting all of us. And sometimes these attacks are made by lawyers. I have had, there was a time when I had a very bitter argument in a cabinet meeting over a decision that had been made by the Constitutional Court, and I was saying I wanted to appeal to the Supreme Court. And I gave the case remember the case of Tinyefuza, where I had appealed and gone personally and argued the case in the Supreme Court. So one of the lawyer friends stood up and says, "If this Attorney General still has faith in the judiciary, I want to say I have lost faith in the judges. I want us to move politically. Let us move politically and show them who has power." Now, this was a statement being made by a judge, a lawyer. And I had been warned by a friend of mine who was Attorney General of Kenya at that time, Honorable Wako, when we had our first meeting as Attorney Generals here in Kampala together with the Honorable Chengo of Tanzania. And he said, "But you are a young man, you have just been made Attorney General. I want to warn you that many of the bitter opponents you are going to face in the cabinet will be fellow lawyers who will want to show that they know the law better than you, and maybe they're the ones who should have been appointed." So you end up in those contradictions, okay? You end up in those contradictions. But I thought the biggest contradiction I faced in real life, you remember when Joan Kagezi, the former prosecutor, was murdered? I had just been appointed Chief Justice. I think it was actually the same week. I had just been appointed Chief Justice, and I'm at home about 8 o'clock, and I get a call from Judge, now Chief Justice Owindolo, who was presiding over that case. He says, "Mr. Chief Justice, the prosecutor, Joan Kagezi, has just been murdered on our way home. I am still in chambers, and I need extra protection." So that was a crisis. The first crisis that meets you, have just been appointed Chief Justice, and that was a crisis. So we rang around. Now, we go for the funeral service of Joan Kagezi at the church at Intinda. And many people gave speeches, eulogies. And one of the interesting speeches was made by the then Inspector General of Police, who chose to direct his anger and frustrations to the judiciary. So he said, you see these things are happening, people are dying. Mr. Chief Justice, it's because you judges and your courts, you are giving bail and releasing criminals. And then he quoted from a man from All Seasons about what was said about Sir Thomas More and so on, but he quoted someone else. And I didn't know how to respond to that. So when I was asked to speak, I said, you see, since you quoted from Sir Thomas More, the band for All Seasons, you should have quoted about his argument he had with his son-in-law, Roper. When Roper, son-in-law to Sir Thomas More, was trying to persuade him to change his mind and to do what the king wanted. And he said, for me, if it was for the sake of the devil, I would even cut down the forest of laws. Because Sir Thomas More was saying England is planted with forest of laws. If you cut them, the wind which will come, you will have nowhere to hide. Then he said, no, for the sake of the devil, I would cut it. Then the man said, if you cut down the forest of laws for the sake of the devil, and then the devil turned against you, where would you hide without a forest to protect you? So I told this, and everybody in the church were murmuring and so on. The ambassador of the EU told me later they all went back to look for the copies of A Man of All Seasons to look for those quotations. But the truth of the matter is, 1 or 2 years later, that same officer himself got into trouble, asking the one who wanted bail, who was looking for fair hearing, which brings forward this, that the law is a shield for all of us. It doesn't matter where you are today. You may be the Chief Justice like Sir Edward Coke, who disagreed with the king and he was put in the tower. You may be like Benedicto Chwanaka, who disagreed with the president and we have never seen what. It doesn't matter where you are. The moment the law ceases to protect us, then even you who is breaking the law, you must understand that sooner or later, that devil or that wind, without a forest to break it, may catch up with you. And I thought these are very interesting things that you should hear about, real experiences that we have seen, and we keep seeing them every day. We keep seeing them every day. When we were making the Constitution, and I was a member of the Legal and Drafting Committee in the Constituent Assembly, under the chairmanship of the late Justice Kanyamba, one of the common phrases that you got from people when they moved amendments was, never again should our country go to this. Never again. Never again should someone disappear. And I even saw the president saying the other day, nobody in Uganda should disappear without a trace. Because we are coming out of what had happened over 9 years with Idi Amin, what had happened over the next 5 years of the war, people disappearing without a trace, people being charged and they spend years in court without so we were all saying, never again should this happen. That is why you saw the provisions we had, that when you are arrested, you are produced before a court of law within, I think, 48 hours. You are produced before a court of law. You are informed of the offense you have committed. Your family is informed, your lawyer is informed, and you are entitled to apply for bail. And this application for bail had a background because before that we had in the law offenses which were described as non-bailable. Once someone charged you with this offense, then you could go to reserve for 365 days and they might as well forget about your file. And I had a live example. At that time, I was still a deputy minister, but in the CA, someone I know claimed he had found his wife in bed with somebody else. So he went to the police and wanted this man charged with rape. And the police made the investigations. I met the former director of CID. He said, but for us, our investigations are that these people knew each other. Even long before they married, they had their own relationship. And they have continued. It's only that the husband doesn't like it. So the police were having difficulties charging this man with rape. So they had him charged, not with rape, but there was some other offense, and he was given a bond. We went to these women lawyers at that time, and they really took on the CID. How do you release this man? The man says he's committed rape and so on. Okay. The man was rearrested, charged with rape, which was a non-bailable offense. So he went to reserve and was forgotten there. Later, I met the director of CID. He said, but for us, this is what happened. Now, the man is charged with rape. We don't have the evidence. All we have is that it seemed to be consensual. Later, I think it was about after a year later, I met the husband. And I said, by the way, what happened to your case? And he just laughed. He said, I'm glad at least he spent 1 year there. Why did he sleep with my wife? So in other words, the state had been used to abuse the law to satisfy the ego of someone. And we as lawyers and as judges and judicial officers, as part of society, these are things we must resist. That actually, so that's when we're making the Constitution. We put those provisions there because of the background that we had. Never again should this happen. Apply for bail, let the judicial office at least exercise discretion in granting or not granting the bail, according to the law and so on. And I remember when I was Chief Justice, we were in I think it was in the conference center, and again, His Excellency the President came out very strongly about the judges and releasing bail, releasing people on bail and so on. And so everybody was looking at the Chief Justice. And when I was asked, I said, judicial officers shall continue to give bail in accordance with the Constitution and the law. I think some of you may remember that. And I remember my predecessor, Chief Justice Wam, was ringing me and saying, congratulations, you well done, well put. Because that's really what it has to be. If it is not, then we shall remain at the mercy of individual officers. Someone sees you, you slept with my wife, okay, charge you with bail, or I have you arrested. There are many people who disappeared in this country for offenses that we shall never know, for personal prejudices. If you fight over business, someone who is well connected connects you and so on. We have people whom we have to protect, despite the inadequacies of our system. Because when we say you have to be produced in court within 48 hours, practically, many of our areas, there is not even a court in the vicinity. There is not even a police post in the vicinity. But you put that there, it is, I think, a standard of achievement that you struggle to work towards it. Even when you read the United Nations Universal Declaration of Human Rights, all those things which were put there, I think there is a sentence there which says this was as a common standard of achievement, that all nations will work towards achieving that. So some of those things we put there, yes, we know there were impediments in the way, inadequacies of the system, inadequacies of the government, and so on. And I remember when I was Minister of Justice and Attorney General, I was also a member of Parliament for Bunyaruguru. I went home one weekend, Friday, and the next morning, a woman woke me up at 6 in the morning. I remember I was still asleep. Someone was knocking on my door. So I came, I opened, there was this lady holding a child, maybe about 2 years old or less. So when she saw me, she burst out crying. So I said, what's the problem? I didn't know her, she was coming from another village. And she said, this child, I'd gone to a field to dig, and she had left the child. Then she heard the child cry. She came, she said, I found a man on top of my child. And she was very graphic, said he had even already put sperms on her hand, and she really cried. Said, then she raised an alarm, people came, and the man was arrested. When he was arrested, he was taken to a police station which was about 2 miles away, 2 or 3 miles away. That police station had 2 policemen. They had no communication, they had nothing. They said this is a case which should go to Shenyi. They asked the lady to produce transport, 40,000 shillings to take the person to Shenyi. And the poor woman did not have the 40,000 shillings. So what did the policemen do? They released the man. So she had now a member of parliament who was also Minister of Justice, and the Attorney General was at home, so she came. Now, that case brought to me the problems that we have. We have a constitution, it says this, there are practical difficulties, but what do we do? Do we just, in fact, when I was Attorney General, I was under pressure by some group wanting advice to change this provision about the 48-hour rule. And I said, no. I said, no, we can't. This is not the time to change such a fundamental provision. They even went and reported me to the president, I was summoned up here in Nakasero. So I went and I defended my position, and this time the president even agreed with me. So the provisions remain, and I think they are still there. So these battles are battles that all of you are going to fight as lawyers. The law being our shield, a shield which we must defend. And those of us who have been given the advantage of studying the law should be at the forefront of defending the law. Now, I want to go to the next question of leadership, because the two things transition. Today you are a lawyer practicing, suddenly you may become a minister, and a different kettle of fish altogether. And let me tell you my personal experience in this. I was in private practice, and this was in February, I think February 23rd, 1988. I go to the Kampala club to have a drink. And then, as I was still at the counter having my first beer, a friend of mine, the late James Garuga Msingus, who died recently, comes in and says, "But congratulations, I have a beer on me." And I say, "Congratulations for what?" Says, "No, you have a beer." So I said, "For what?" Then he tells the people whether he said, "You see, unless there is another Katurebe in town, this man has been appointed a minister." I had no idea about it whatsoever. A minister, I had no connection with politics. I was not involved in politics. How? So I thought it must be a joke. But then somebody else comes in and says, "No, it's on TV." So I quietly left them, got in my car and drove home. I used to live down here in Lumumba Avenue. When I got home, I found my children now excited because they had seen it on TV. Said, "Oh, Daddy, there was something, what was it? A video? There was something they used, a decoder video that people used to buy at that time, and we hadn't bought it." So one of the kids says, "Now, Dad, I think we are going to buy this thing." Because in his own mind, being a minister means everything that you didn't have now suddenly will come there. So that was Tuesday night. So Wednesday, people who, of course, from home were saying, you must accept. My wife and I were already decided I am not going to accept an appointment. I am not interested in politics. But people said, "No, you must do it for your home. Your home has never produced a minister." The day passed. I remember calling Justice Mulenga, who was then Attorney General, and a friend. So, and I called him, and he said, "Has anybody called you?" I said, "Nobody has called me." He said, "Okay, you stay put, do your own things, and if they want you, they will call you." The day passed, then the next day was Thursday, and I had a case in the High Court. So I went to my chambers and started robbing. As I was putting on the gown, my desk phone rang, and it was secretary to the cabinet. Said, "Are you Mr. Katurebe?" I said, "Yes, I am. You are required at State House for swearing in at 10 o'clock. And this was 8:45. And I didn't even have time to go tell my wife what was happening. They sent a vehicle which drove me straight to State House, and I became a minister. And that was to remain for the next 13 years as a minister. So my life suddenly changed from somebody who was going to court to argue a case to now a minister in a different. So this can change for you as well, and suddenly you find yourself in position of leadership. Are you going to forget your law? In my view, you shouldn't forget the law. You are going to carry that, and we remember the words we got from Justice Eagle, that you have got that opportunity that has made you versatile by studying the law, and you are going to carry it in your new responsibilities. Now, what is a leader? Tony Blair, who should know more about leadership than many people, this is what he starts his book by saying, and I quote, "No leader I have ever met who succeeded did so just by being a leader. They did it by hard work, by application, by poring over the detail, by organizing before deciding, by harnessing their self-doubt as well as their self-confidence, and by curiosity, by a willingness to learn, by a relentless pursuit of the right answer, burrowing all the way down to the core if necessary to get it." When you have become a member of parliament and you have become a minister, and legislation is going to be brought to parliament, don't you have a duty to study it, to look at scores and pros? In my experience in parliament, I have seen a minister bring an amendment bill to amend a principal legislation. And you have people debating on the basis of what other people have said, and they have never read the principal legislation that is being, let alone reading the amendment. Now, when you become in a position of responsibility, it is your duty to study a problem that has come. Study it, internalize it, make informed decisions about it, because many times we make mistakes by making decisions that are not informed. If you are a judge and you are a leader, a case has become before you, study it, make decisions that are based on research and the law and your own conscience of what you think is right. You may be adjudged wrong. Your case may be upset on appeal if you are on the lower decision, or if you are in the Supreme Court, it may be departed from in the future. But it should be what you believed was right at the time. Don't make a decision without properly thinking about it, without reading the evidence, without reading the decisions. So this is one thing that Tony Blair is saying, you must have a willingness to learn. And then he says, I quote, "I have come to the conclusion that the attributes of leadership are the same, whatever the leadership position, from running a country to managing a football team, to heading a company, or indeed any type of organization, be it a shop or a community center. A leader steps up when others step back. The mantle of responsibility is being passed around, and the leader willingly takes it upon their shoulders. Okay, sometimes they drape it graciously around them, and sometimes they snatch it before anyone else can get near. But in either case, or somewhere in between, they are prepared to wear it. But that merely gets you the position of leader. Being a leader means something different. Leaders have the courage not to go with the flow. They speak up when others stay silent. They act when others hesitate. They take the risk, not because they fail to identify it as risk, but because they believe a higher purpose means the risk should be taken. They are prepared to say what needs to be said, including to their own supporters." Now, I have been a member of parliament, and I have participated in campaigns. And I remember, where I come from, Bunyaruguru is a fishing and cultivating community. We depend on those big lakes of Lake Edward and Lake George and Kazinga Channel. So there are 4 fishing villages there which constitute a Gomborora. So I went to one of them, and there was rampant illegal fishing. You had many people who didn't have licensed canoes. They just fished anyhow. They put in undersized nets. They caught underage fish, which was all illegal. So I went there. I was not only a candidate for office, but I was also a government minister. So I went in and argued against illegal fishing, the impact it is having on the local economy, because once the lake runs short of fish, which it was already becoming, then we are all going to be affected. And my opponent sensed that. He's a lawyer. And he said, this lake was given to you by God. It's yours for fishing. Now, for him, he's already aware of the money he's a minister, he's aware of. How can he come and tell you that you can't catch fish and so on? You go ahead and fish. I lost the election on that place, that fishing village. Later, the government started the program of this controlling fishing and so on. And actually, many of those people were kicked out and so on, and people started fishing properly. When I went back years later, when I was no longer minister, the people came to me and said, you are right. Since the time the government started enforcing what you were saying, our fish has become bigger and we even now get more fish. But I lost the election because I didn't want to say what my people wanted me to hear. And many times my supporters would say, you are going to make us lose the election. Why don't you also tell some lies? I said, no, I'm not going to tell lies, And I witnessed a bitter argument between two good friends, very senior people when I was a cabinet minister at the time, when in the run-up to the amendment of the Constitution to remove term limits. So, and we were at a dinner in a private home. So the minister said, and of course the argument, the conversation turned around the proposed amendments at that time. I had already left government, I was in private practice. So the minister said, for me, I don't mind if that's what the peasants want. I will go with the peasants. And the other gentleman really lost his temper. And he said, then what sort of leaders are we? We are the ones who went to Ruwero and asked people to follow us. We gave them the vision, they followed us. We gave them leadership. Now you are saying we should look for the peasants to be the ones to lead us. So then what said the man was very busy, said, my two brothers died in that war, and we had now to stop the conversation and hold, because it was nearly getting very, very hot. So Tony Blair says, a leader must not go with what people want. You must identify what people need and live by that. That's what people need. Sometimes it may not work for you. You may actually lose an election, as I said, as I did. But you must be a leader who gives your word and sticks to it. Now, I also remember a man called Shimon Peres. You remember Shimon Peres was the prime minister of Israel for a long time. When he died a few years ago, literally the whole world, all the world leaders attended his funeral service. Last week I was watching a documentary about his life. So there was a time he had become so unpopular. Then Israel politics, today you are popular, another day something happens and you're not. Then he became popular again, and they did a coalition government, under which they agreed he was going to be prime minister for the time. Somebody else from the opposition would be his deputy, and then after that time they would change over and the other one would be prime minister. And he gave his word, and that was agreed. In Israel today, you may be prime minister, when there is a reshuffle, you become a minister of foreign affairs and so on, and it keeps their country going. So he became very popular, and his top senior advisor went to him and said, now is the time. You don't have to go to honor that agreement. Let's have a general election, because you are so popular now. You are going to win a general election and you continue as prime minister. Perez said, I cannot do that. I gave my word, and I will keep my word. Said, a person who can't keep his word is not a leader. You go and look it up, it's on Netflix, Shimon Peres. I was really, touched by seeing this gentleman, an old man and so on, but he said, I gave my word, and I must keep my word. So one of the attributes of leadership, I think, must include honoring our word. Now, that takes me to the third book I brought to you to look at. You should look it up, Winning with Honor, winning with honor in relationships, family, organizations, leadership, and life. I've already more or less touched on it. When you become a successful lawyer, when you become a successful member of parliament, when you become a successful minister, a successful judge, a successful chief executive, many of you lawyers will end up in the corporate world as chief executives, corporation secretaries, and so on. Are you going to serve there with honor, with integrity, to be an example to others? Because if you don't serve with honor, then you may not have the legacy that you are talking about, the relevance. Because if you serve with honor, like we are now citing people like Shimon Peres, they are long dead. Sir Edward Coke lived in the 17th century, but we are still citing them because, in other words, they remain relevant today. Sir Thomas More, we quote him, but is still relevant today. So this book defines honor. He says, and I'm going to quote, honor defines our humanity. It is a universally recognized and esteemed value, not defined or confined by religious or cultural mores. We have our honor because we are. Deep within each of us, there is a sense of something that makes us worthy as a human being, and that something is honor. It is like a muscle. We are born with it, but whether it maintains its functionality and grows depends on whether we choose to exercise and train it. Honor is ours to lose. When you are honorable, you keep your word. You do the right thing regardless of what other people are saying. In order to build honorable and healthy relationships in every area of our lives, we need to honor our word and honor each other. Leaders have to be clear about what kind of organization they want to leave for the next generation to inherit, and what kind of values the next generation will need to ensure the continued success and survival of the organization. Leaders cannot avoid making the moral judgments as to what would be good for the people because they have to create the future and not simply follow what people want today. On the lack of thinking, this has become more serious with the advent of the internet. In the age of the internet, information is so easily searchable that people need not think for themselves, but simply look for a website or blog site that offers information and opinions that they find agreeable. But in such a convenience lies the danger of not bothering to think. If we are to be responsible members of society, each one of us must think for ourselves as to what would be good for the generations to come. Think about the internet. There are many ideas available from all kinds of people. The internet is neutral, but the views and perspectives are not. People have virtual personalities with multiple avatars. We often have a hard time figuring out what is real and what is not, especially if it does not come from a known or credible source. If you don't live by the praise of men, you won't die by their criticism. Leaders make good things happen, but on their own would not happen. In a world of too much information and too little conviction, the world requires people with clear convictions in their lives. Seek to serve and not to be served. Seek to serve the needs of society and to make a positive difference in your spheres of influence. These are not my words. These are words I've taken from this book, and I thought they are relevant. And those of you who will have the time, get on the internet, look for these books, and read them when you are in your. I know lawyers, you are too busy making money, you may not find the time to read these books, but I think you come out richer by enriching yourself with some of these books. So in leadership, and you want to create a legacy, you have to decide a legacy over what. There is a Greek man, I have even forgotten his name, in Greek mythology. He grew up and everybody was talking about the famous Greeks, Aristotle, Socrates, Plato, and the others. And this man says, everybody talks about Aristotle, Socrates. Me, what shall I be remembered for? And there was a beautiful temple in Athens. He went and set fire to it. So he's remembered for that. He's remembered for that. That's his legacy. People like Adolf Hitler are remembered for bringing destruction to this world. To be remembered, and some of Hitler's people who were prosecuted and convicted at Nuremberg and executed were lawyers. Hans Frank, who was governor of Poland, was a lawyer. Sessinquant, who was governor of the Netherlands and actually participated in deportations and killing of Jews, he was a lawyer, and they were all executed at Nuremberg. Now, when you are talking of your legacy, do you want the legacy of Justice Koch, or the legacy of Hans Frank, or the legacy of Sessinquant, or the legacy of Hitler? But we have the legacy of leaders that we are talking about, like Shimon Peres and others, the Kennedys of this world, who by their words, by their actions, changed the world. You remember, for example, President Kennedy, when at his inauguration, when he talked of don't ask what you can do for what your country can do for you, but ask what you can do for your country. And you as citizens of the world, what we can do together for the betterment of mankind. Now, President Kennedy started the Peace Corps movement. You remember the Peace Corps movement? I think there are still a few around, which brought here hundreds of teachers at the time when government had started new secondary schools in Uganda in 1965. I am a product of those. When we started Chitunga High School, I was one of the first class, 1965. And we had 3 teachers. The headmaster was British and 2 American Peace Corps. Imagine if those Peace Corps had not been there, some of us may not be here today. And they are multiplied all over the world. So we read about such a people who say, yes, they left a legacy that touched not only the Americans, but touched the world. And when you touch the world, you can bring peace. And when you bring peace, we can all develop. So these are things that I think we should... Now let me summarize what this man says. We live in a world where we have too much information, too little conviction. Even though we are technologically connected, our souls are disconnected from each other and from our work. The future is one in which the unseen becomes more important than the seen. Hence, it is important for us to address the scarcity on the inside and not focus on the abundance on the outside. The world craves leaders who seek to serve the good of the many. The world needs people who think for themselves, not of themselves. The world awaits leaders who have their own convictions of good and bad, right and wrong, and who are not content to follow the crowd in the wrong direction. Success is never certain and the path is not predefined. If you are simply following others, you can use their maps and their tools, but your possibilities are then limited. But what have been done in the circumstances that they will never be the same as yours. While we can refer to what has been done by those who have gone before us, what we need is a compass of values, principles, and beliefs of what can and should be. We also need energy and stamina to keep going despite detractors and distractions. If we were to become a society where what is legal is right and what is illegal is wrong, we would have subjugated morality to the law, and the whole moral fiber of society would be left directionless. The laws of the land are basically there to protect the weak and to assure fairness and justice for society as a whole. While congruent with the morals of society, they are not there to define morals. This is a summary that this gentleman ends up with. Now, we have to each go and put it in our own perspectives, our work we are doing as lawyers, our work we are doing as corporate executives, our work we are doing as ministers in government, in church, in private life, whether we are really focusing on our proper role as human beings based on high ideas of value, of ethical behavior, of honor and integrity. Let me end up with a quote from, again, Sir Thomas More. And this is called the lawyer's prayer. It is in my office there. We hang it out there. It's called the lawyer's prayer. And it says, Lord, grant that I may be able in argument, accurate in analysis, strict in study, candid with clients, and honest with adversaries. Sit with me at my desk and listen with me to my clients' complaints. Read with me in my library and stand beside me in court, so that today I shall not, in order to win a point, lose my soul. That's the lawyer's prayer, and with that, thank you for listening to me.
Wow, isn't that amazing? Thank you very, very much. I hope you're standing where you are. To the online audience, thank you very, very much, sir. That was amazing. I think we can take our seats now. There was so much to take away. You can send in the claps, the messages. The Chief Justice will definitely see them running off the screen. That was a lot to take in. And at the start, remember, I asked you to have your pen and paper because, I mean, what is a lawyer without a pen and a paper or the digital beat to write something, lest you miss something? So just briefly, a little bit of the things that I have noted. First of all, I heard him say he was at LDC in 1975.
74, actually. 74, 75, yeah.
Wow.
I started working the Attorney General in the Department of DPP on 1st April 1975.
Yeah, we are young lawyers. I wasn't born, sir. But yes, so that goes to tell the richness and the depth of this kind of information that you have shared with us. He was talking about law, leadership, and legacy, positioning yourself for lasting relevance. And I think the biggest question he said for us was, why did you go to law school in the first place? Because maybe that's a very good start, and we're very glad that you started us off there. So because we've said this space is basically to give us a mentorship, to make us lawyers that stand out, to be holistic, not just one angle, but 360. That is the word I've learned and I'm really using. Be clear about what you want. Look at these people who you want to be like. See the stupid things they do. That is not my words I'm quoting. And of course, the good things, okay? Don't look at cases as just numbers. These are people. These are real human beings with real human issues. So remember to have that heart and apply that touch to it. Be ethical, uphold integrity. And on leadership, I think I love that quote. I think I will call it a phrase. A leader must not go with what people want. He has to go with what they need, and you must stick to it. Because at the end of the day, we are leaders, and we are guardians. I think it's a movie, Guardians of the Galaxy. So we are definitely guardians of the law. And of course, he also had material, the books he has mentioned for us to check out. And remember at the end of the day that you have to be a person who keeps your word, because then that is honor. And I think I'd like that highlight that honor is born, we're born with it, and it is ours to lose. I don't think I'd looked at it that way. And I hope that this, for me, is what I've taken out. I don't know what it is. I think I'm getting some, so those are some of your ululations digitally. The members that are listening in, the colleagues are appreciating you, and I think there's that particular message from Martin, who's saying that was simply nobility, and there's some more claps on the screen for you. So this was really, really amazing. Thank you very much again. Thank you, Uganda Law Society, MAMSI, Praxis, and Bluebell Legal for organizing this and putting us together, because indeed this is something that we need. Thank you again, sir.
Thank you. So these books, take the references and look for them. They are available on the
Yes,
internet.
yes, sir. We'll definitely do.
This one of mine is available. If anybody wants it, you get in touch with me. Okay. But they're also, I think, in the bookshops.
I will definitely.
All right. Thank you very much. I will leave you for now to go on with your symposium. What's the next program?
we're going to hear another. We're going to have legal writing for young lawyers, the 360 angle. With Council Sevambo, who is right here.
All right, thank you very much.
Thank you,
You
sir.
deprived me of a chance to host you in Ugolobi.
Oh yeah.
Because I was preparing, because it's my house is the next house.
Oh, we were told, but there was just a little bit of change towards the end.
I was told, no, I was preparing to walk across the road, and then I was told to come back here.
But thank you very much,
It
sir.
enables me, now I can go back to my office and do something.
Okay.
Help me with this. Okay, ladies and gentlemen, thank you very much.
I don't know if there is a time for a photo moment. Some people are asking. You have a photo moment with the CJ? Yes, please. Yes. The members are requesting for a photo moment with you. I think here, right there. Yes, sir. Okay, to those who are online, we are taking a photo, please. I don't know. We will share it with you. Thank you very much, ladies and gentlemen, land colleagues. We are still going. This is our first day of the Young Lawyers Symposium 2025, and we are convening at Praxis Conflict Center. You can still drop by and I'll read some of the comments. I see Samuel, you're saying thank you so much. Honorable CJ, Andrew, you said we shall have a virtual photo moment with the esteemed CJ Emeritus. Please make sure you share. We want to see. And you say that he has had an illustrious career with distinction. He is the typical example and yardstick of what a CJ should be, or a judicial officer. Thank you, Viola. I see all that. So to our online audience, thank you very, very much. Again, my name is Joy E, and it is an honor to be hosting or emceeing this event today. Now, as we get into our next session, please, I hope you're taking some tea, some coffee as you're drafting some pleadings there. I don't know what it is you're doing. Right about now, we want to get into legal writing for young lawyers, and I believe that as a lawyer, there's no way any of us can escape legal writing. And we want to take it back to the original settings and learn how to do it. Is it just something we ignore? Is there more to what we got at LDC and probably we got out and forgot? I don't know, but thankfully we have Counsel Semambo Rashid, the managing partner at Semambo and Semambo Advocates. And he is also the president of the Uganda Muslim Lawyers Association, UMLAS. He is an advocate of over 20 years of private he has 20 years of private practice, and in 2006 he established the law firm Semambo and Semambo Advocates, and then he has lectured the law over the years, which later culminated into lecturing at the Law Development Center, where he taught corporate and commercial practice and civil litigation. He currently serves as the board chairman of the Speak Resort Convention Center in Munyonyo, which hosted the NAM conference, and it was attended by over 100 heads of state of government. He's also a council member of the Victoria University Council, where he's also the chairman of the Appointments Committee. He has spoken in various fora and symposia. For example, he was the commencement speaker at the latest African Rural University graduation ceremony. He was the keynote speaker at the recently concluded China-Africa Symposium 2025 under the theme Global Order, Transformation and Development Paradigm Innovation from the perspective of African civilizational diversity. Mr. Semambo is a thinker and a writer who has authored several papers on positive socioeconomic transformation of Uganda and Africa. Ladies and gentlemen, this is the wealth of knowledge, of wisdom, of experience that I bring to you. Please sit right there and continue letting us know that you're there on the screen, because he can see you. And maybe us who are in the room, we can clap, and welcome Counsel Semambo. Over to you, Counsel.
I thank you very, very much for this invitation. And I thank you very much for the entire membership for allowing me to be part of the esteemed discussants for the day. The Vice President of the Uganda Law Society, my brother, Mr. Asimwe, Chief Justice Emeritus, Honorable Justice Bart Katurebe, members of the Uganda Law Society Secretariat, our distinguished collaborators in today's event, alongside Uganda Law Society, that is Bluebell Legal Advocates, Praxis Conflict Center Limited, Muslim Arbitration and Mediation Center Uganda. Esteemed ladies and gentlemen, both physically present and those online, very good morning to all of you. Again, want to express my gratitude and happiness in being invited here. The topic of which I speak today concerns legal writing for young advocates, a 360-degree angle. So when I thought of what to say today, I am an ardent reader, and therefore, as you've heard in the brief presentation of who I may be, I oftentimes say that if I were not an advocate, I would actually be a writer, quite interestingly. One of the writers that I have keenly been reading is somebody who's called the King of Horror, an American writer called Stephen King. But in one of his famous quotations, he says that if you don't have time to read, then you don't have the time nor the tools to write. Simple as that. So the basis upon which we can have effective writing starts with keen reading. Because, as you heard from the presentation of the previous speaker, Honorable Justice Emeritus Katurebe, he kept on quoting various books. And to me, I was a bit in a fright and also worried for many of the young lawyers today, because as you've heard, I've also had the opportunity to lecture over the years. And I realized from the outset that the culture of reading is long gone in the legal profession. And as I asked earlier from the quotation of Stephen King, how can you then write if you cannot even read? Back in the day when we used to be admitted, for example, in Makerere, some of you know that we had a segment in the library called The Cage. And in The Cage is where any serious lawyer, not even only serious ones, even the slightly unserious ones, but who knew why they had gone there, would go to read. Case reports of old would contain about maybe 50, 100 pages, in which a judge would state the facts as they understood them or presented to them, the legal issues, the law, and then the analysis of the same before coming to the judgment. And then the judgment will have various levels. In today's legal scholarship, the unfortunate reality is you have many lawyers who go through law school at a graduate level, escalate, go to the LDC for the bar course, but have never read a case report of even 5 pages. That's the unfortunate reality. So what we have is things are simplified. They're on everybody's phones and computers and tablets, and they read case summaries of half pages, and then they somehow become experts in the law. This appalling situation, unfortunately, does not fit in well in transforming into a better advocate, and more specifically and relevant to this topic, a better legal writer. Legal writing, as you shall see in my presentation, involves 3 major aspects. It starts with the art of listening. You should recall as advocates that the story you tell is not your story. The arguments, the claim you're going to present, or the defense you shall set up is not your defense. It belongs to a client. How then will you be able to posit? How then will you be able to present? How then would you be able to set up a claim, a reply, a defense, if you've not listened keenly to your client? It starts with the art of listening. And the art of listening is closely married to something called the art of solicitation. Because whereas a client may have a problem, theirs is to generally state what their problem is. in layman's terms. So they come and say, my land is being stolen, or somebody wants to take my wife, or somebody has breached my employment contract. They will not go into the legal terms because they don't know them, but they have a story. But whilst telling this story, you realize that some of the key information that would inform the course of action to be taken is lost along the way. And it is incumbent upon you as a practitioner to somehow solicit this information. From experience, I will tell you that whereas clients have complaints, the complaints are usually covered in various layers of not necessarily the primary information that you're concerned with. Somebody comes to you and tells you about their chibanja being stolen, and the chibanja is in Gayaza, but before you know it, they're telling you about their aunt who doesn't love them and who is bewitching them in Bale. Now, if you have not mastered the skill of listening, you end up cutting short such an interview by always bringing them back to where you want them to be. In the art of listening, one of the most important aspects is giving things time. Not only listening, actually, it's an art in life. Giving things time. Listen to a client while they're presenting their problem to you. That is very, very important, and that is very, very key. That while they present, it is incumbent upon you now to discern what I usually call to sift the wheat from the chaff. How do you get the details that are relevant to this person's complaint for you now to be able to establish the best course of action? So I said, as you listen to them in the art of listening, you also now perfect it through solicitation. You use subtle gestures, you use suggestions, language, and body language that encourages people to now share with you more and more of the information that will help you to help them. Imagine, as a practitioner, if somebody came to you and made this presentation, gave you a story, and all you do is you have a bewildered look. So as they're talking to you, they realize you have your hands on your head and your eyes are popping out and your mouth is gaping. And you're saying, I cannot believe that this actually happened to you. And in the next minute, you're calling your associates in the law firm, telling them, Mzee, you stop here with your story. Let me call this person. Can you imagine, Mr. Nabara, what this one is saying? Joy, just listen to what this man is saying. It's just incredible. Such actions do not in any way help you as an advocate to prepare for what you're going to draft. Because what it does is it makes the client coil inward and avoid further interaction with you, and they maybe also now end up editing the stories here and there. Again, from experience, I'll tell you that clients will naturally never ever be willing to concede where they are at fault. Because whereas we are, I think she said that we're supposed to be, do you say protectors of the galaxy? I don't recall what it is. Guardians of the galaxy. The reality is the public perceives us as being a bit sinister. And they think that anytime advocates are easy to double cross them. And also people who usually have a guilty conscience tend to create this shield. So what the human psyche, I usually say, does to you is it encourages you to have a version of the truth that comforts your soul and your mind. So what they do is they come up with a version which is not necessarily true, but it is upon you as the advocate who's listening to this client to now solicit the information to the best of your ability to ensure that you get the truth as far as possible, and therefore now offer a course of action. There has to be something I called here the art of comprehension. Whenever you have information, information in itself is not an end. Information is the stepping stone towards the ultimate goal of offering solutions, not any solutions, but legal solutions. So you need to have comprehension. Comprehension is understanding. Understanding not from the point of view of just an ordinary person. This is an ordinary person giving you the version of the story, but you need to understand these facts from the point of view of a qualified advocate. You listen to them. But as they are speaking, your brain must be wandering from left to right, north to south, in the middle, the center, and everywhere about, searching for the right, relevant legal recourse and procedure that would most efficiently and effectively serve your client. So you need to comprehend, to understand. And as soon as you understand, then the next one becomes the art of persuasion. Before you write, understand that the law at the end of the day is a combination of a set of facts that have been presented to you, your understanding of them, but now you ultimately have to offer legal solution. And legal solutions are oftentimes offered through persuasion. Persuasion is not bare knuckle argument, but rather it's the use of language. It's the use of tone. It's the use of grammar and punctuation to effectively communicate a position such that the opposite party or an independent arbiter can sit down and understand and agree with your point of view. That is very, very, very important. That never ever get lost as to why you're offering your services to a client. There is a problem that we usually tend to have as advocates. So when somebody comes, I oftentimes give as an example. A client comes to you and tells you how their husband is very disrespectful, he beats them up, he gets drunk, doesn't take care of the home, the man is a womanizer. You cannot be, and it's not available to you, as your first response to say, you know, divorce proceedings are provided for under the law, and we're going to commence these divorce proceedings, don't worry, madam. A simple question that is lost on most advocates is to ask the client, we've understood, we've listened to you, what do you want? Because a client may shock you by saying, you know, I have known Paul here for a very, very long time. And you people have had also called counsel. Could you please counsel him? Just talk to him. I truly love this man and I want him to reform. Do not assume what the client wants. The intervention, yours is to offer technical expertise to achieve what the client ultimately wants. But it is incumbent upon you to first seek directly from the client through a simple question. I've understood where you're coming from, Mr. Mukasa. Now, what do you want? And let them tell you what they want. Sometimes we think as advocates, and I think it goes back to the motivation, what Justice Katurebe was talking about. The motivation, the reason why people join legal practice in the first place. Sometimes we think that when we go into direct litigation, we make money easier. Or sometimes we think that when we do things in a particular way that satisfies us individually, is how you also satisfy your client. It is important to understand that your client is separate from you, and what they have come to achieve from you is solution. It is not to participate in any legal adventure that you may have, some legal fantasy that you may have. It's finally an opportunity for me to be seen in the commercial court, so I'm going to sue. It's finally an opportunity for me to be seen on TV because such a matter will naturally attract media attention. That is not the role of an advocate. Your role, before you even make any legal drafting, is to understand what the client wants and how best to achieve what the client wants. And this is done, as I said, through listening to them, understanding what they want, and also mastering the art of persuasion. I want to say to you, ladies and gentlemen, that as an advocate who has trained, you need to discern the relevant law. Now, we live in an era of what I usually call acquisitiveness, the people who usually listen to me. And it is quite absurd. So you have people who are highly qualified, but they are qualified in terms of the certificates, papers, but not in terms of quality output. So people have degrees and these postgraduate diplomas and more degrees and postgraduate degrees, but I don't think what enables you to be a good legal practitioner, whether you're in-house counsel, whether you are a judicial officer, whether you're a private practitioner, whether you're a prosecutor, what drives you is offering legal solutions. So can we somehow transform our education, our skilling, our training into applying relevant laws to the facts at hand? This is very, very paramount. It's not available to you, again, ladies and gentlemen, to just guess, because when you're at LDC, some people were a bit tough on you and you did not understand a thing. It is incumbent upon you that, therefore, legal scholarship that you undertake should not have been wasted by now meeting a dead end by you getting a qualification, but you now lacking the understanding of how to apply relevant laws. Without understanding, you cannot even apply relevant laws, and it won't be helpful when you're going to draft whatever legal documents you're going to draft. Finally, in that regard, you have to identify the pragmatic, most efficient procedure. There is no legal recourse without procedure, and the procedure is usually derived from statute. And not all procedure is the most efficient procedure. The problem with most advocates, from my experience, is, again, as I said, with a lot of respect, especially the years that are now what we're talking to the young lawyers, is it's a bit hard for you to tell your to tell your left foot from your right foot, and it becomes a challenge for you to even adopt the easiest procedure simply because your motivation to join the law was primarily just to make money. Or there is this confusion that you are entitled to compensation, that is remuneration, pay. I oftentimes, since I have this opportunity now to say, your value is what dictates compensation, remuneration. You're not entitled to anything. You don't have a birthright to anything. If you are so invaluable to the system, you will get compensation. And these things take a long time. I understand, when Justice Katureba was speaking here, I was reminded of one of the leaders I usually admire a lot, Lee Kuan Yew, who was talking about leaders and was saying leaders are not there to, sell ice cream and carry people's babies and just say what you want to hear. And that's not even what a friend does. A friend is the one who tells you what you need to hear and not one who just says anything to please you for the moment. So now, ladies and gentlemen, now when we go to the actual legal writing, as I said, legal work, and when we offer legal solutions, you should remember that when clients come to us, they've not come for legal scholarship. A client does not come to an advocate's office. Neither are you required as a corporation secretary or a legal manager or a legal officer in a corporation or in the DPP's office to offer legal scholarship. It's a difficulty that most advocates suffer from. And my advice to you as young lawyers is inculcate in yourselves ways of delivery to your client in very clear, concise words, the approach you are going to adopt in the simplest way. Let not a client come to you, Mr. Musinguzi comes to you, you look at them and tell them, sir, and then you start flipping pages of the CPR, and you tell them, according to Order 6, Rule 3, the moment you start such, the client will switch off because you're giving them headache. They've come with a problem and they want a solution to their problem. You're becoming a bigger problem by quoting to them the law. Nobody cares about the law. They care about solutions, not so any solutions. You're not a broker. They want legal solutions. And you must be the embodiment of the law in action. You as an advocate must be the embodiment of the law in action. You talk to your client, you talk to your principals, the bosses in corporations, in such a way that you make what is so complicated. Do not come and start saying, you know, the Latin maxim, quick quid, solo solo, sedi plata. This is as ridiculous as it gets. It will only make you lose clients. Just explain to them in very, very simple, palatable terms. You know, in the art of communication, whether speaking as I am now or writing, always be mindful of as to whom your audience is. If it is a client is not qualified in the law. Even if it is your legal principals, the senior partners in the law firm, as I will show you here, when you're writing a legal brief, how do you go about a legal brief? You'll understand that a legal brief is not meant for you to persuade anybody, but rather to state the facts as they are, as you've understood them from your interview with the client, and then marry them with the relevant legal principles as you've understood them over the years, and then offer, in no uncertain terms, the direction that you think as the law firm or as the corporation, as the DPP's office, as the judicial officer, you're supposed now to take. It is as simple as that. You need, therefore, to have understood the facts. I oftentimes say, how are you going to offer a solution, write an opinion, if you've not understood the facts? And the client is reminding you, no, sir. I did not say that my child's name is Peter. I actually said he's Paul. What is this about? It's because you're being very, very impatient when you're listening to them. And as you're listening to them, your brain is going like, I don't remember, did we say how much money this person is supposed to pay us? Is he paying us now a deposit? Now you're getting confused. I oftentimes say, and this is, I think, important since I'm talking to young lawyers, that in life there are two things that usually bother all of us. We chase fame, we chase fortune. So we want to be known. And in this era of social media, everybody wants to be all over the place. You want to have a big name. And then you want to have a very big car, you want to have a lot of money. But I will also advise you, they've told you I've been practicing now, my law firm has been around for 20 years now, that when you go out and your principal target is to chase fortune and fame, you will get neither. Your focus should always be in building capacity, in building character. Once you better yourself at what you do, in terms of acquiring knowledge, in terms of understanding, and in terms of discipline, how you behave around colleagues, your seniors, your juniors, clients, trust you me, then you will get the fame, you will get the fortune. You will not need to chase them around. That's a fact of life. So now, as I said, when now you're done with drafting a legal memo, a legal brief, which is internal to your senior partners, As I said, you only state the facts without coloring them. In English, you see, again, I have to say from the beginning, and it's unfortunate that I don't know how many legislators are listening to us. During my time, we used to have something called essential subjects. How are you going to effectively write a legal memorandum, legal pleading, if there is a challenge in the language in which you're supposed to communicate? The books that Justice Katurebe was referring to showed two things. They showed the art of reading and writing. Because whoever writes them, it naturally means they sat down, had ideas, thoughts, and put them in writing. But also Justice Katurebe read them, and they were quite big. As I said, if you want to perfect yourself, please just inculcate in yourself the art of reading first. And then you will naturally pick some skill here and there, and then you also become a better writer yourself. So having written, and you agree, for example, that now we're going to write a notice, a legal notice. You should understand that the purpose of the legal notice primarily is to notify the opposite party of an intention to sue. We are intending to undertake this legal avenue for legal redress for our client. I will tell you that at this moment, you should be very, very careful. Do not write a legal notice while going native. Do not suddenly go ballistic. And then you say, this is my opportunity to show the world that I also know some bombastic words. That's a word. So you say, you choose very, very big words. I've edited them out. So you choose words where the other person reads them and is lost as to what you're trying to say. I oftentimes ask my clients, what is the quality, what is the nature of the opposite party? There are some people to whom having received a legal notice will just say, let us resolve it, because of how you have presented it. It is clear, it is concise, the law is also clear, and what you seek to achieve, the legal redress, is also clear. And when they consult an advocate who has a reputation, the advocate will just naturally tell them, let us sit down and settle this. It's not worth escalating into litigation, which may also lead us to incur costs. But it is how you present it. But also remember, ladies and gentlemen, that while writing these legal notices, they will one day form part of the pleadings as annexures. If you read, if anything is to go by, you read the CPR, something called Judgment on Admission, Order 13, maybe Rule 6. All these communications you keep on throwing around can be used to prove that actually the other party's claim has been admitted in previous communications. So whereas you're writing these communications, avoid sharing everything that is at your disposal. At this time, I oftentimes advise, attach only those annexures that prima facie bring out your client's claim. Do not go into the entire, because this is not a trial bundle. You're just notifying the other party sufficiently that there is a claim. Because as a tactic, as we go along, your mind may change a little bit as to how you may want to present your case from when you're writing the legal notice to when now you're presenting your pleadings. But if you have exposed your client by sharing every and anything that is available to you, then the problem may be that now these documents may be returned to you as a defense. So just utilize only those that prima facie bring out the claim, and that will be sufficient to bring the notice. And again, at that level, it's not about persuasion, really. It's really more of assertion. You are asserting to the opposite party, you did A, B, C, D, as you're aware, and it has these consequences, and by law, my client is entitled to recover, and we shall exercise our legal right. And that is sufficient in that regard. Now we escalate it to the level of pleadings. When we talk about pleadings, I usually say it's called the art of storytelling. For those whom I used to lecture at LDC, I was telling them that it's called the art of storytelling. And if you know how we begin our stories, in English, when it's time to start a story, we say, once upon a time. Here in Luganda, they say, awolwatuuka. There is something common between the two. You see, it has past tense. Once upon a time. Awo olwatuuka. In Kiswahili, if you know Kiswahili, ukiwa unaelewa Kiswahili, they say hadithi hadithi, and you say hadithi njo. There is a reason why we start once upon a time. And the reason is because you cannot raise a claim by saying, now Mr. Peter Mukasa wants to divorce his wife. What are you talking about? What happened? Once upon a time, in the year 2005, Peter Mukasa met Olivia Namirimu. That is how it begins. Then what happened? Then they fell deeply, madly, truly in love. Okay, then what happened? And then they went and celebrated a marriage ceremony. They had a marriage ceremony in Christ the King Church. Okay, then what happened? And then they had kids together. The first kid was born in 2006. The other one, 2009. The other one was born in 2011. They bought a chibanja together. They built a house, and this house was registered in both their names. Along the way, whereas this man kept on supporting, in the year 2020, he realized that in the night she would receive phone calls and she would go to the bathroom. You see how the art of storytelling is? Remember, as you're telling this story, it is guided by one legal principle that we all know. Auto garage versus motor cove. So there is a right. Okay? This man clearly owns this house. He has a proprietary interest. And is actually registered on the title. So it is a legal interest. Okay? And this man is in possession of the house. Okay. Possession is also very, very important. So if you're talking about status quo, it means he's the person who has the status quo now. Okay? And then he says, 3 men came with guns, told him, get out of the house. What is happening to his right? It's being violated. And then he says, having talked to them, I realized that it was some lady called Olivia who had sent them. So the allegation is Olivia is responsible for the violation of my right. So now when you're writing your pleadings, if you all know 1, 2, 3 paragraphs where you state who these people are and their addresses, and then you say, these are our prayers. Okay, what are the prayers you want? You have to be clear as to what you want. You want a declaration. A declaration that what? That your client, that is the plaintiff, is the legal owner of property comprised in this. Clear. You want a declaration that the actions of the defendant amounted to violation of their constitutional right to property. Whatever it is. This has to be clear. And then you say the cause of action arose as hereunder, once upon a time. Then you tell the story. So as you're telling the story, you're setting out the facts, but you're stating the facts in such a way that you're fitting within the parameters set by Auto Garage versus Motokov. Order 7, pleadings generally. It's a statement of claim. Your client stood for Member of Parliament, Busiro South constituency. He's a registered voter in the constituency. He was nominated. Now you see, you're establishing, this is very, very, very important. And while doing this, it is also important that you present it, I usually say, in very small, legible, in my view, 3 to 4 lined maximum paragraphs, one by one by one by one. I oftentimes say, do you know posho and rice are all foods, but when you look at them, whereas they're white, when they're cooked, the rice is one by one and the posho is together. In the art of communication, especially while writing, it is important that you bring out paragraph by paragraph, bringing out one fact leading to the other in chronological order, such that as soon as somebody reads, they understand where you're coming from and where you're heading. But remember, these pleadings are not a statement of evidence per se. Pleadings are not submissions. Pleadings are just a statement of claim. It is an assertion. It is a factual assertion. So break down the paragraphs slowly by slowly. Don't tire. Do not clamp them together. Because once you clamp them together, then what happens is your message gets lost in translation. There used to be a movie called Lost in Translation. So you say something and everybody who's reading it is not sure as to what you're saying. And I oftentimes say that, remember, it's you who had the opportunity to interview your client. We were not there. The independent arbiter, who is the judicial officer, was not there. So do not make the assumption that they know what you're talking about. So you go into each paragraph with granular detail. Give every detail that is required to bring out your client's story. Otherwise, that is how you see that along the way somebody says, I beg your pardon, my lord, under this provision of the law, I beg now to amend my pleadings. But you're the one who drafted the pleadings in the first place. What was the hurry for? So I usually say that take a lot of time in interviewing the client, understanding the client, and most especially in drafting the pleadings. Mr. Namara here, Collins, will tell you, in our offices, okay, mine is a bit extreme. I may have OCD. But I call all the lawyers that are involved on a file, I'm not joking, God is my witness, at least 8 different times, 8 different days. We have to go through them. And again, and again, and again. Nobody ever died because they did the same thing over and over. Me, I'm a perfectionist. A paragraph has to be in clear grammar. Punctuation has to be clear. A comma has to be where it's supposed to be. A semicolon has to be where it's supposed to be. Do not say this is something small. There is nothing small to me. Perfection. Because what usually happens at the end of the day, I will tell you, so when we sit in our chambers, you get pleadings and the first thing is, or clients. So clients usually say, we've received here some paperwork, somebody's suing us. And who's the lawyer? As soon as you hear, you say, don't worry, just send those things. And here you just know this one is just a very, very unserious law firm. We shall raise a PO. And I'm not joking, I'm being very, very serious about it. And others, you are a bit careful. Even where they make a mistake, you think, no, maybe they knew what they were doing. So I'm the kind of person who always encourages. Read through the first time, the second time. I don't know why, but mine is 8 times. You have to come and sit there in front of me. And I ask one of you to read, and they will tell you. And me, I'm standing half of the time. And I dictate from my head. And everything has to be done meticulously. You see? And there is this other challenge as we're talking about drafting, especially with the young lawyers. You know, the English say, if it ain't broke, don't fix it. There is this new language that you people use, and I usually ask my lawyers, because most of them I taught them at LDC, what is this language that you're using? The social media language, in my humble view, has no place in pleadings. That is available in a WhatsApp. You send to whoever you want WhatsApp, and you use ROFL. Even if you gave me all the money in the world, now I'm broke, I don't even know what it means. But you use terms that, So while drafting pleadings, it's important that you try to your level best to perfect them. So I usually give an analogy in my office of the issue is he's there, I cannot speak, but I usually give an analogy of a sugar cane. You get this sugar cane and squeeze it. Even if it goes to a sugar factory, they cannot squeeze anything anymore. Repeat it and repeat it and repeat it and perfect it. Nowadays, of course, we have AI, but remember, pleadings have to be tailor-made to your client, to your client's claim, to your client's remedy, the one that they seek. So it is important that you have this human touch, this input. I usually tell these guys that AI cannot replace somebody like me. How? Because you see, life is very, very nuanced. AI will replace everybody that does something in a robotic way. So if you've heard of somebody called Charlie Chaplin, he has a very, very old movie. Don't worry about it. It's called Modern Times. And to me, Modern Times is exactly a reflection of AI. So when you do something that everybody else does the same way, then AI will replace you. But if you have an ingenious way of doing things, a smart way, a practical way, how is it going to know that now this time I'm talking about facts that are tilted in this way or the other way? So I encourage all of you, as I said, to read, comprehend, and do the right thing for your clients. Because this is what saves you. It helps you in creating reputation from amongst your peers, judicial officers, and also from the clients. And that is how you build a solid base to get more and more clients. Now, never forget at the end of your claim to restate what you seek from the independent arbiter. So whenever you're making this claim, remember you're not making it, as I said, as an insult. You're not just abusing the other person. No, you're making a presentation because there is something you want to achieve. And how now do you achieve it? By keeping on restating it in very, very clear language, in very, very simple language. Now, then you have a reply to a claim. So you have a written statement of defense and a affidavit in reply. I don't know, there is this habit that people have and has developed over the years, which in my very, very humble view is wrong. A reply to a claim is exactly that. It's just a reply. Go to those paragraphs that make an assertion and rebut them. And your option is very, very clear. You either deny, you may admit, you may qualify your admission, but it's not even available to you in the law, the CPR, to evade, to avoid, as in to deflect. That is not even available to you. These things, many of them pass because of also now, with a lot of respect, I'm talking to the Uganda Law Society, so I don't mind speaking the truth, nothing but the truth, with also the quality caliber of judicial officers that we have today. It is one of those very, very appalling things that we have. The quality of judicial officers in allowing such lousily written pleadings, because themselves, many of them are incompetent, is why we are in this mess that we are in. It should not be available to a defendant to set up an alternative storyline that does not respond to what the plaintiff is saying. That is not the purpose of the defense. If you want to set up a counter claim, it is there in the law. You set up a counter claim. But somebody cannot be saying this against your client, and you as an advocate forget about it, and then you start talking about something else altogether, and somehow that defeats the rules, and such a defense cannot be sustained in law. So now we escalate again and go to something called, for example, now submissions. Submissions are legal arguments. Now, this is where the art of persuasion now comes in. The law is ordinarily a very, very civil vocation, profession, nature of trade. So it's meant to present you in a way that you're always humble. And that's why before judicial officers, you go like, "My Lord, your worship." And you even stand up and bow. So while writing in submissions, remember to be courteous. It's not a time to take a swipe at opposite counsel by using, again, colorful language or hidden language to call them stupid, but in maybe using fancy language. That's not your opportunity. If you want to defame them, that is a different matter. Do not use your client's matter to abuse opposite party or even opposite counsel. Now you use the art of persuasion. In the art of persuasion, language matters. What we call diction, choice of words. What words are you using? When you use the right diction, you will realize that you use words that are easy to read, easy to comprehend. You don't want somebody reading your submissions or even pleadings, and half of the time they're using a dictionary to understand what you're saying. There used to be a great journalist, I don't know, many of you young lawyers may not know him, called John Nagenda. But every time he would write an article, especially abusing the people in Monitor, I'm sure 90% of all readers of New Vision would not understand what he was saying, because he was a great student of literature and he knew all of these things. But no, as I said, choose your audience wisely. While now writing submissions, it is now time to show your legal prowess. But your legal prowess should not be exhibited in such a way that your client's arguments are lost. Only refer to the relevant laws that enable your client's case and claim to come out or your client's defense to come out. Remember, while drafting pleadings, the principle in the Evidence Act is he who alleges, he who asserts must prove. So even if you're writing a defense and then you come up with defense of limitation, it is you who's now making a positive assertion. You defend it. If fraud is your defense, it is you again to particularize and show that you did not comply with the contract because it was fraudulent. That is again up to you. Now, as I was saying, while writing these submissions, break them down in two segments. This is the issue that I'm resolving. But under this issue, there are these elements, and these elements have to be brought out. Remember again, the guiding principle is auto garage motokov. That is what will inform what a judicial officer has to do. They have to understand that there was this right which was violated by the defendant. So now you go ahead and, as I said, choose the right words, diction. Your punctuation must be right. You must use the right grammar. You must, in terms of grammar, things like subject. What is the subject? Who is the subject? What is the object? All of these are very, very important. Your tense must be right. You can't be using present tense when talking about something that happened 5 years ago. Your tone is important, because you see the choice of words and your punctuation will bring out your tone. I usually say, back in the day when I used to be taught English, there used to be a gentleman called the SPO, Mr. Simon Peter Angodia. God bless his soul. I don't know where he is now. But he used to teach us something called tone. And he says now, even if you choose the right words, so you meet this beautiful girl and tell her, and now your word is, I'm going to tell her, I actually love her. And then the first thing you go like is, I love you! And you're screaming. Haven't you lost whatever message you're trying to project to her? Tone matters. And tone is suggested even when you're reading, how you're choosing your words, how you're punctuating. You're using an exclamation mark, and it is bold and in capital letters, and it's in italics, and it is underlined. What do you want the judicial officer to think? Now you're being combative. You have to use a tone that persuades. There is a fable called Aesop's. There's somebody called Aesop. He used to write fables. The story of the north wind and the sun, which talks about the art of persuasion. Maybe I will interest you to read it. It will teach you something about persuasion. Aesop is written Aesope. The story of the north wind and the sun, how you persuade people. That is very, very important. It's very, very small, but it's important. And then you also use something called intonation. So while doing all of these things, in your pleadings, you now establish at least a solid background, solid foundation for your client's claim to be understood and for the redress to be availed by the independent arbiter, who in this case now is a judge. I usually say there are four. In English, there is something they say, different strokes for different folks. So it depends on what you're writing. How you write, as I said, a legal memo is not necessarily how you may write a legal notice, and how you write a plaint is not necessarily how you write a defense. And these have to be distinguished. Ladies and gentlemen, as I am concluding, I want to again emphasize that always remember that it is only you who knows the story best because you got the story directly from the horse's mouth, your client. Do not clamp up paragraphs together, information together, because you will be lost. Your information, the gist of your story will be lost in translation. As counsel, finally, I implore all of us to encourage ourselves to read more. Because I said the beginning of writing, the culture of writing, is best enabled by the culture of reading. When we used to read back in the day, they used to teach us something called to contextualize. So if, for you who studied the things some of us studied, in the exam what they will do is they will just bring a random paragraph and say, place it in context. And then you were supposed to remember that this sits here after this event, and immediately proceeding after it was this. In brief, ladies and gentlemen, you have a duty as an advocate, in whatever state that you may be in, to encourage yourself, to propel yourself to read more. Because in reading more, then you become more proficient in the language in which you're going to communicate. In this case, it's English. We do not submit, unfortunately, in any other language. So we need to create proficiency in the English language, whether we like it or not. And in that way, you become a better advocate. But my parting words again are, yours is not to lecture clients in either the law, in English, or anything else. But yours is always to come out as clearly as possible as to what you're trying to communicate in language that is easy to understand and where the principle is glaring and easy. The same will apply. I saw they will talk about, legal arguments, but also in terms of cross-examination. It comes back to the same thing, precise to the point. There is something called Occam's razor in philosophy. Once you start over-explaining something, know that whatever you're explaining has been lost. With those few remarks, ladies and gentlemen, I want again to thank you very, very much for, one, the invitation, but also listening to me. I oftentimes say that I don't speak in a very orthodox way, but I really hope that this interaction has added whatever small contribution it may have to your legal writing, The law is the law. I'm not going to amend the law, but I think it's the practice and approach to writing that we need to focus on in order to better ourselves as legal practitioners. Thank you very much, ladies and gentlemen, and have a very good day.
Wow, what an amazing, insightful, what do we call it? Now that I'm coming in after you, I'm even very careful what I say, just in case. But ladies and gentlemen, colleagues, land friends, please help me. Even online, you can clap. We can see the claps on the screen. Help me once again appreciate Council Semambo Rashid for this very insightful session. Thank you very much. And somebody was saying, I don't want to be the person, I don't know, like probably the ones that he works with, because you have to read the pleadings. You said 8 times, 8 different days. I don't know if it's in 8 different ways as well, but wow. That goes to show, I think you speak with passion, and I can only imagine what it must feel like, being against you in court. I don't know, because you've said some clients send that and you say, okay, who is the lawyer? And you're like, don't worry about that. So these are some of the things that I've picked out. I just like to reiterate just in case you missed something. And probably I'll just check in with the team that is online. I think there was somebody who started saying, I entirely agree with Senior Counsel Semambo. Clients do not care about your brilliance in law. Oh, could you please take it back up? The comment that comes in after Chenga Emmanuel. Before, rather. I don't know who is scrolling for me, but as he does that, there was a bigger chunk of a comment that was sent. Thank you, Land Council, for that very enriching submission. Bravo, Council Semambo. Thank you, Council Rashid. Thanks for the insights, and thank you. So I don't know who is scrolling for me on the screen. There's a bigger check. Could you please go back? There's that comment which you've cut. Because we need our people to know that they're actually present with us. So thank you, Irene. Thank you, Patrick. Thank you, Elisha. Thank you. I might murder that one, that big comment, you've passed by it. Okay. So you can leave it on the screen. I'll get to it, but we want to observe time. I think that the highlight of this was that if you don't have time to read, you do not have time to write, which is a challenge, I think, like you say. If you're not reading, then you're not writing. And I feel like sometimes after LDC, LDC just makes you feel like your brain is wobbly. So you don't want to do any other reading. But if we are to get better, if we are to become the kind of 360 angled lawyers, then we definitely have to immerse ourselves in reading. And thankfully, even right before Council Semambo, we had Chief Justice Bat Katurebe, who also encouraged us. He actually came in carrying books and recommended. So if such a person who has spent years and years in practice is still reading up to now, what about you, young lawyer? That's a challenge. And he says, how can you then write if you cannot read? Master the skill of listening, give things time. Listen to your client. And sometimes people come in with a version of the truth that comforts their soul and mind. So it is your responsibility to sieve through the wall your client might come in with and extract accurate information. So that comprehension comes in through listening. And he says that not all procedure is the most efficient procedure. So definitely it's upon you to sieve and see what really is working. And remember I think that the repetitive bit is perfection. As you repeat, then you learn. As you repeat, you get better and better. So I think I don't have to go all of that. I think for me, that was the highlight. But most importantly, that if you want to be a very good legal writer, you have to read. I hope I've represented this very well, sir. Thank you. Once again, can we appreciate him? All right, so to our online viewers, again, we want to thank you. This is the first day of the Lawyers Symposium 2025 program, which is talking about legally balanced mastering practice, purpose, and personal life. This is for young lawyers, and my name is Joy E, and I am happy to be hosting this for the 2 days. So we just completed our second session of the day. and I'll be guided on whether to continue or what happens next. But as we get into that, if there are any questions, comments out there, please let us know. We have a team that is monitoring, and let the people know. And in case you want to jump in and join us, you might even catch lunch if you come in early, you know. We are at Praxis Conflict Center. And this has been brought together by Bluebell Legal Advocates, Uganda Law Society, and MAMC, which is Muslim Arbitration and Mediation Center, Uganda, and of course, all of you that are listening in. So thank you very, very much. Okay, so right about now, I think I didn't get this. Okay. So we're going to go into the session on winning beyond the law books, right? So that is mastering the human side of legal practice, soft skills that move the needle. And I like this bit as well because you see we have talked about reading, we've talked about writing. So this feels like it's the perfect flow. And ladies and gentlemen, in the house, I want to call it the house, we have Mr. Batanda, and he is the managing partner at Signum Advocates. So we'll just request him to get up there, and please let's clap for him. The ones who are here, you're going to. Thank you very much. And even those who are online, I see you, Martin. I see you, Juliet, Rosemary, Kenneth, Samuel. If you send me messages, I'll send shout outs, okay? That is how you let me know that you're here. Thank you very much, sir, for sparing your time. I know it is very busy, but thank you for taking off time to come and talk to young lawyers out there. So maybe as a start, before you dig in, you could just talk to us about yourself and probably what motivates you, and then you can dig in there. Thank you very much, ladies and gentlemen. Over to you, sir.
Thank you. Every day you learn something. Okay. As I was saying, I'm Batanda Gerald, and I'm the managing partner of Signum Advocates, by God's grace. And I want to thank you so much for this opportunity to add a voice to the effort that is ongoing concerning the retooling of the young lawyers. Learning never ends. If you stop learning, just know you're dying. Firstly, I want to thank Bluebell Advocates. I've interfaced with some of them, mostly in court matters. I want to thank Praxis Conflict Center, Uganda Law Society, the Muslim Arbitration and Mediation Center of Uganda. It is very hard to avoid the Muslim Arbitration and Mediation Center of Uganda. I don't know whether it's me, but thank you so much for the work you're doing. It is really great. Then I want to first give a disclaimer that I am not the patron saint of soft skills, and that whatever I am going to share, it is going to be, most of the points are going to be anecdotal, because the temptation was to Google and find what soft skills lawyers need to practice. But that's the easy part. I thought that for the time that I've been in practice, what are those soft skills that have worked for me as an individual, that have worked for us as a law firm? I thought I would share those with the young lawyers so that you can pick up some of them, and if you have those skills already, how you can improve them. Maybe for a brief background, I have been in practice, this year will be the 16th year. I began my craft with Okalang Law Chambers, then I went to Attorney General's Law Chambers for 7 years. I was in the Directorate to Civil Litigation. I enjoyed my 7 years. Then in 2018, I joined Signum Advocates, and that's where I've been to date. From a young age, I was so passionate about litigating, and that's the only thing I want to do in life. I don't enjoy drafting agreements, but if I must, I draft them. My thing is mostly litigation. But of course, as you grow in the firm, you realize that the practice has to widen, and you may do more than the requirements of litigation. So, the first thing I would like to share with you is that soft skills are not a preserve of senior lawyers, neither are they a preserve of young lawyers. You will be shocked during our interaction that I personally have picked up soft skills from young lawyers. I find it shocking to say, but it does happen. I'll begin with the very first that has worked for me from the day I resigned my first job. I discovered the day I resigned my first job that I was the lowest paid advocate in the firm. And I asked everyone that, how come I'm the lowest paid advocate in the firm? The question they asked me, did you negotiate? A few months later, I stumbled across a book, and I don't remember the title off cuff. And the phrase that captivated me was, life doesn't give you what you deserve. It gives you what you negotiate for. That has stuck, it stuck with me all through my entire career. So whichever room I walk into, I never assume anything. And I know, much as I may have the experience, much as I may have the qualifications, they're not going to give me what I deserve. I can only walk out with what I negotiate for. I will give you a trick about how recruitments are done and how terms are negotiated when we are recruiting some of the staff. Whenever young lawyers come into an interview room, normally the last question is, what are your salary expectations? And of course, the young lawyer will say, I think I will, my beginning salary, I would want 5 million net. Now, the trick is not to counter offer. What we tell them is that, someone more experienced than you has just walked out of this room and he was willing to take 2 million. You don't even have a PC. Why would you ask for 5? Then they say, okay, maybe I can settle for 1.5. You say, but 1.5, you have just begun, you have no experience, we are going to train you, you're going to make so many mistakes, and we're going to carry your load along the way. Don't you think that that's too ambitious? They say, okay, I think I'll take 1. I don't know whether you've realized the trick behind that narration. That trick is called force the other side to negotiate with themselves. They have made an offer, but you make them negotiate with themselves. Meanwhile, we have not made any counter offer. All we have done is to force you to negotiate with yourself to a position of our financial comfort. Make sure that you always give the other side a chance to counter offer. Never negotiate with yourself. Just remember that. And clients do it all the time. You have submitted a quote, and they will call you for a formal meeting, and they will say, look here, there are 4 bigger law firms that have given us lower quotes. But we want to work with you because we want a firm that is so versatile. We want young blood on our team, so we think we should give you this opportunity. Is there a chance you can reduce your quote? Then you begin making calculations in your mind, and you reduce your quote, let's say, by 40%. And they will say, you see, our budget is still so low. Is there a chance you can touch it down a bit? By the time you walk out of that meeting, you have taken a 70% cut on your quote. But you see, I can read that from a mile away nowadays. And this comes after very many years of that trick being played on me. So be very careful when you're dealing with negotiations. And when employers or when a client pulls that on you, don't throw your hands in the air. It's very important that you put on a poker face. I know it's hard in that circumstance, but it's very important that you do it. Never negotiate with yourself. If you've made an offer, if you've submitted a quote, let them make a counter offer. That's how it plays. And if they make a counter offer that's not comfortable, that's when you make it known to them that, by the way, our official discount rate is 30%. So we can only do 30. But that means you're very sure about your product, you're very sure about your chances. But if you're not very sure, you must begin now getting into the rough and tumble of a real negotiation. So don't make the mistake we made. The reason as to why we, in a sense, they colloquially refer to us as senior counsel, though I'm not that senior, is that we have made so many mistakes. Please benefit from them. If you want to make a mistake, make a new mistake. Don't make the mistakes we made. So that is a skill you'll have to hone as you move on. Unfortunately, you're not going to master it in a day. You're going to make so many mistakes. You're going to be fleeced. You're going to be strong-armed on the negotiation table. But I thought I would give you that from the onset. If you are to remember anything from what I'm going to say, at least remember this: never negotiate with yourself. Once an offer is made, the only discussion that can be had after that is only if a counter offer has been made. Don't fall for the trick of your quote is out of this world. You see, we have many other people on our panel. They were smarter lawyers, etc. Never fall for that. Don't blame us for using it, because it's business and there's nothing personal about it. But now that I've leaked the secret, I think I have I've armed you in that regard. By the way, this trick works both in legal practice and out of practice. It works, it's just like clockwork. And some people inadvertently implement this trick. So don't get caught flat-footed on that front. But please never do it to us. We still want to use it. Yeah, so just give us the opportunity to continue using it. I will, the second thing that I think is extremely important, and I must thank God that I am so blessed. I have, I think, some of the best partners in the world. One of our partners is called Mr. Matovu Alex. Mr. Matovu can negotiate anything under the sun. And if you ever meet him, run. He is a very good negotiator. But on top of that, he has what we would call impeccable networking skills. And I think you have heard this being thrown around for a very long time. Oh, you have to be a very good networker. Attend all manner of functions. Throw your business cards to whoever cares to receive them. You know, nowadays there is a company that normally distributes business cards whenever you're caught up in traffic. As a lawyer, is that what you're going to do to enhance your networking? I don't think that's the case. I will tell you what we did as a firm, and I'm not saying that we are the gold standard of networking, but I'm just sharing with you what has worked for us for the time that we have been around and for the time that we have practiced. The first level of networking is with your colleagues. 90% of the business that we get as a law firm are referrals from fellow lawyers. One of our biggest invoices that we have ever issued arose out of a referral by a fellow lawyer. It is extremely important that you network with your colleagues. Your colleagues must know your skill set. They must know that you are dependable. They must know that you will have the time and the expertise to attend to the client they are referring you to. That's number one. Number two, I'll give another example of networking. We have a culture in the firm where every quarter we host a senior lawyer. We have a long list of senior lawyers, but we host them every quarter. And we only ask them one question. If you are to do this again, how would you do it? It is amazing the information you'll get from senior lawyers. Now, I want to caution young lawyers. By the way, I think in a sense I'm also a young lawyer, because there are some lawyers who call us boys. We find it insulting, but I mean, they call you boys. When we host these senior lawyers, and you talk about most of these things, what they could do different, what has worked for them, what has not worked, what you should watch out for, we came to realize that there was an increase in volume of business as a result of these interactions with senior lawyers. Most of the senior lawyers don't have time to attend to some cases. The cases may be good, but they may not be the cases they want. The question is, when this senior lawyer is conflicted, whom does he think about? You want to be the person they think about. Unfortunately, now we are so many. LDC releases, I think, 1,500 students every year. Think about the time you left LDC to date. If you left, let's say in the last 2 years, 3,000 lawyers are now on the street. So if the people who are getting the big work are conflicted, will they think about you? Why would they think about you? Now, the trick we have learned is that senior lawyers are one of the most friendly people you'll ever meet. And I have never approached a senior lawyer for help and they decline to extend a helping hand. It has never happened. I always tell myself, I will not make a mistake with my eyes wide open. So whenever you host them, I'm sorry, I'm going to mention some names. I don't know, I know they may not approve of it, but we came to help each other. There's a time we hosted Mr. Philip Karugaba. Of course, he doesn't know some of us, so you have to go and introduce yourself as, so, you know, Mr. Philip Karugaba, I admire what you do, which is true, and we really look to tapping from your experience. And we say, could you please come to your offices so that we can have a 1 hour meeting? Just spare us 1 hour. What Mr. Karugaba did, he said, no, I will actually come to your law firm. We said, no, you're senior, you can't come to our law firm. He said, I am coming to your law firm. Oh gosh. He came, and first we had to figure out, does he love coffee, tea, where will he sit? So all that happened, and he came. Instead of 1 hour, we had a 3 hour meeting. At the end of the meeting, he said, by the way, guys, I am willing to give you an IT system for your filing, free of charge. Have we ever given him anything? No. For free. We asked for a meeting, we had a long meeting, and guess what? I'm not saying it's going to give you the same IT system, but I'm just showing you what you're missing when you decide not to interact with senior lawyers. Then, whenever we do articles in the papers and you make a mistake, he will pick up the phone and call you and say, by the way, I think you made a mistake. Please next time don't do it. So what we learned is that before we publish, we share articles with him. He reviews them in record time for no charge and even gives you thoughts on how you can improve it. How many people can do that for you? The beauty about publishing is that it improves your visibility and also helps you to bolster on your thought leadership in a particular practice area. So there are not many of your peers who can do that for you. If they can do it, they may not have the relevant expertise you need to bear upon what you're doing. So it's very important that you have interactions with these senior lawyers. I know the climate is not conducive for senior lawyers, but they are the ones who are attracting the biggest business in the country as we are talking. It is very hard to find a lawyer who has 5 pieces doing mergers and acquisitions. It's really hard. But when you attach yourself to the people who have gone before you, there is a very good chance they will have you at the back of their mind. Then I'll never forget, and then one time, of course, we have hosted Miss Ruth Sebatindira. Mention most of the senior lawyers, we have hosted them. Then there's another notable one I'll give you. It is Mr. Mpanga, Daudi Mpanga. Very nice man. You host him, he will give you all the advice that you need, everything that you need. But the icing on the cake is that he's the one lawyer who has ever referred to us a very big case. It was so mind-boggling that he said, don't worry, I've already vouched for you. It was so strange that we said, did you seriously vouch for us? Because the case was so big. And indeed, we submitted the quotation, but I told you, they call us boys. They said, but these boys, they are young. So we didn't get it, but the fact that he thought about us when he was making the reference just shows you how much these senior lawyers are willing to help you. I'll tell you another one. There's a senior lawyer called, it's called, I think, Atenyi Tibaijuka. If you want to know anything to do with appeals, he knows it. He has argued, I think, a very good number of appeals in the Supreme Court, etc. Whenever I go to consult him on any appeal, even if he has a client, he will tell the client, first get out, and then he attends to me. One time I even told him, but I'm not paying. He said, no, you are my fellow counsel. So I had a very tricky question to ask. He picked a file, he picked an appeal he argued in 1997 and gave me the document. He said, by the way, in case you want me to review your draft, send them to me, I will review them. Just because I asked. I can go on and on about the lawyers who have really been instrumental in our growth. There is another senior lawyer. There's a client who wanted to give us work, but he was not sure because we had pitched, but he didn't know us. So he called Mr. Chaze Joseph and said, Mr. Chaze, do you know these boys? The problem with the people who have the money in town, any person my age, they look at you as their son. He said, do you know these boys? At the end of the call, the client, not only did the client give us work, but said, please send your invoices for payment. And he gave us work. So when I met Charles said, did you get the work? I said, which work? He said, someone called me, called so-and-so, and I told him that he will never get better lawyers than you, that even I cannot handle his work. It is extremely important that you engage senior lawyers. And by the way, don't even, you ask them for a coffee and pay for the coffee. We would even say, let's meet at Sheraton, we shall pay for the coffee. And they will give you invaluable information. So the first realm of networking is with your professional colleagues. Please network with them. The other biggest instruction we got this year is in arbitration. It was a referral from a fellow lawyer. He was conflicted. Who's the first person he thought about? He thought about us. So it's very important that you engage senior lawyers. And I'm not saying that now all of you should now begin running after them and say, oh, we heard that you people, you have goodies. No. You reach out to tap from their experience. They have a lot to offer. There is another realm of networking. And I'm sorry, it may be a little, it's going to be controversial, but let me just state it. Networking with a bench. How do you network with a bench? Number one, I am not saying that you should bribe judges or judicial officers. Whenever you hear that there is a function organized by the judiciary, never miss it. Attend it, and please reach out to the judges and greet them. Don't go beyond that. Say, greet them and interact professionally. I must say, the next time you appear before them, you will be a familiar face. These things, they have small benefits they bring. That day, on that rainy day when you need an adjournment, you will be a familiar face. So it's very important to have a network with the judges. And not in the sense that I can bribe them or I can call them, but become a familiar face to them. Some of you may never get a chance to appear before those judges so many times. So since you can't score on the frequency in terms of appearance, try to score on the frequency in terms of engagements whenever the judiciary calls for such engagements. It's very important. The other level of networking is for networking with clients. There is a client we have in the firm. We have represented 4 generations in their family. And it is very simple. The client lost a loved one, and we attended the funeral. From that point, this client keeps saying, I'm not your client. You people are actually my relatives. That's a client you bill and they will never negotiate the invoice. It's because we have connected at a level that is beyond professional, but yet you must remain professional. So in a sense, they think we are a part of their family. And we have failed to fit into the family because we have different races. We say, okay, now how do we fit into this family? So from the grandfather to the daughter, granddaughter to the great-granddaughter, or children, we have represented all of them. So look at multi-generational representation. But how do you do that? You do that by networking with the clients you already have. Now, the other level of networking is for those clients you don't have. We don't approach clients to take them away from their lawyers. We even tell them, by the way, retain your lawyers. Your lawyers are very good. Retain them. But we would like to share you. Simple. Try us out. If it doesn't work, it's okay. But please retain your lawyers. There's a time where we had joint instructions to handle a matter with a certain law firm. And I must say they were young lawyers. They were representing a certain white man, unfortunately he passed away. They wrote an email to him saying, you know, these Signam people are these are young boys. They don't know what they are doing. They wrote a missive that was in very bad taste. So some clients are so open, he forwarded the email to us. Now we meet at court and exchange very uncomfortable looks with our colleague in the profession. But instead of throwing tantrums, we told him that, look here, next time we would advise you not to do this because you wrote this missive, but here we are. So it is not good to go behind your colleague's back and either write such emails or malign them. you may end up maligning yourself in the process. So in this profession, we are colleagues. And if you treat your fellow colleague like your next instruction, I can assure you, you're going to enjoy practice. That's one thing I've learned. The previous speaker, Mr. Why am I forgetting his name? Mr. Semambo, thank you. I was about to say Magambo. Mr. Semambo talked about being polite. Nowadays it's very fashionable to trade insults, to hurl insults at each other, and social media has not made it any easy. I am asking you, you may want to desist on trading insults. Why is this the case? If you're treating your counsel as your potential client, I mean your colleague as your potential client, that is not something you want to do. We have, I think I'm leaking so many secrets from the firm. We have a rule in the firm that whenever you're going to court, you're addressing 5 constituents: the judge, opposite counsel, opposite counsel's client, your client, and whoever may be in court. You want at the end of the hearing for any of those people to want to be your client. So, by extension, there are some things we just can never do in court, full stop. So, it may be fashionable to shout at judges, and as Mr. Semambo said, to abuse your fellow colleague, even cynically or sarcastically, but in the long term, it just won't work. It won't help your business. The question you should ask yourself, how does this even put food on my table? Or how does it increase on my revenues in my practice? It just doesn't help. I'll give another example of networking. We have been blessed in a sense. Even for the employees we have dismissed in very acrimonious circumstances, they end up referring work to us. Some of them become in-house and they become our bosses, but we have still maintained a professional relationship. So this should tell you that, whatever you do, even if we are dismissing staff, we tell them, by the way, we're not dismissing you because you're a bad person. We are dismissing you because this is not the right soil for you to grow. That means you can grow elsewhere, but this may not be the right soil for you to grow. There's a reason as to why. Let me see. Which fruits? There are some fruits that grow in Europe and can never grow in Africa, and vice versa. So just because someone didn't perform in your farm doesn't mean they are bad lawyers. Maybe they can thrive elsewhere. So even in cutting loose personnel, we have come to discover that you have to do it in a collegial manner. If you miss out on that window of opportunity, this person may become a company secretary, and you are on their panel. Do you think you'll ever get work? I can assure you, you'll be the first person they will starve, and you leave that panel. So you want to maintain those networks across the entire chain. And for us, they have worked for us immensely. Then, of course, I'll go to the issue of humility. Young lawyers, I want to encourage you. You may want to see how to work on this thing called humility. I'm not saying that you are proud, but for you to learn in a work environment, you must have a certain level of humility, because you are going to meet Mr. Semambo, who has OCD. If you don't have patience, and if you're not humble, you're going to resign on the first day. I can assure you, whatever he said, he is not out to kick you out of his practice. He wants to get the best out of you. But if you're not humble enough to see what he's trying to achieve, even in pushing you to go through pleadings 8 times, you are going to miss the lesson at the end of the day. I want to, and this will come in, especially for people who practice, who litigate a lot. One thing I've always told myself is that judges are gods. And for those of you who have litigated in our courts, you'll get to realize that indeed they are gods. And for some of them, you'll struggle for an eternity to even get their attention. But one thing I've learned is never raise your voice at a judge. Nowadays there are so many litigants who appear in court and they appear with the press, and those clips make rounds on social media of someone yelling at a judge, giving them a dress down. It has very good cinematic effect. But in terms of retaining clientele or attracting clientele, you will never get clients who pay real, big invoices. Of course, you'll enjoy the momentary applause, but I want to tell you there are some clients who will never come within a mile of your vicinity because, in a sense, they deem you as a risk to them and their business. So whatever things you do in court, please remain humble. Let me share with you an experience, and I will tie humility with civility. One of the last cases I did before I left the Attorney General was British American Tobacco versus Attorney General. That's BAT versus Attorney General. When we appeared in court, I encountered a gentleman called James Mukasa Sebugenyi. You will excuse me if that's not the arrangement of the name. You know, by then I was a ruffian. I didn't have any refinements to me, and go to court, argue the case, get done, move out. So when Mr. Sebugenyi got up to address court, he was so smooth, my God. Even he sought leave to make an opening statement. Now, in my mind, the last time I had of an opening statement was at LDC Moot. I said, who does opening statements? He gave an opening statement, and you could see all the judges nodding in agreement. I said, oh my God, what is happening? And having given the opening statement, he introduced me so well. You know, it was so disarming. He presented his application. After that, the first thing I'll tell the judges is that I hope you have not been bribed by Mr. Sebugenyi. No, in that his demeanor and his elocution was just impeccable. He was extremely smooth. And it was to the point I said, my lords, I almost believed what he said. It was that bad. In that his work was just so good. He was so smooth that I said, what did I just walk into? So I'll tell the panel that, please, I know he's so diplomatic. For me, that's not who I am. And I'm sorry I can't pull it off. So the judges laughed and they said, yes, we agree with you, but we shall be fair. Now, that should show you that even the judges were on board regarding he was so civil. It was so annoying. And I really feel for you, young lawyers. I pray for you that you never meet him. Because even if he has a bad case, he will win. But I also can't explain how I won that case. But there are some lawyers, and there's another one called George Omnyokol. Those people are so polite to the bench. You know, I didn't know that it's a thing to even greet judges. When the judges came in, they even greet, they say, oh, my lord, it's a nice day, blah, blah, blah. They get to, and you're saying, what on earth are you doing? We came to argue a case. So, one thing, instead of railing against them, I decided to pick some of those lessons. So, there is a lot in terms of humility and civility that senior lawyers bring on board. And I want to encourage you, even if you have a case in court, first try to listen and how these people conduct themselves. They are so good at it. But I have never recovered from that Sebugenyi experience. Never. And years later, okay, whenever I meet him, I even just laugh about it. It was so strange. You know these things you see in movies, how lawyers comport themselves in court. That is what happened. Textbook experience. So I want to encourage you. The people you're going against have honed their skill that if you come in court or for a negotiation and you're not polished, you are going to lose on day one. These people are only getting better. Please, don't deceive yourself that just because you've learned the latest laws, you're going to beat them. No, they are just getting better at it. You know, the challenge with lawyers, we are like wine. The older you grow, the better you become. That's the challenge with our profession. So I want to encourage you, please look out for senior lawyers. But if you ever say, Mr. Mukasa Sebugenyi, run. Because he will, I don't know how to call it, he has a way of handling the judge or the judges. He speaks in a very nice way that he will even, he may sell you your own hand. So learn some of these skills from the senior lawyers. I learned a lot from that brief experience, and it has helped me moving forward. I can assure you, he had a very bad constitutional petition, but his presentation was something to write about. And I keep joking about it all the time. And I even encourage the staff that, please, if you ever hear that Mr. Mukasogin has a case, just go and attend court. You will learn one or two things from the way he does his cases. So please do not shun senior lawyers. They have a lot to offer us or to offer you as young lawyers. And one of them is humility and civility. Then I'll draw another experience. I was doing a case. There's another lawyer called, senior lawyer called Didas Nkurunziza. You know, when I was a young lawyer, I was extremely cocky. It is strange what age can do to people. Now, I served him with my pleadings, and he told his clerk that, tell Mr. Batanda to call me. I said, who is it to tell me to call him? I told the clerk, tell him that I said that. I don't think that he remembers this story. But he picked up his phone and called me and said, Mr. Batanda, I request you to amend your pleadings. I said, why would I amend my pleadings? He began pointing to what had gotten wrong in my pleadings. And said, by the way, I don't want to throw out your pleadings, just amend and I will consent to late filing. I cannot do that for anyone, but on that day, I learned that, in this profession, it's not about winning, but it's also about extending a hand of grace to your colleague. I had really messed up those pleadings. I don't know what I was thinking. Was I even thinking anyway? So you'll find that the issue of or the matters to do with humility are extremely critical to us as advocates, and even for you young advocates. I can tell you, and I can't blame you. You're young, you're full of life, and you have a whole lifetime ahead of you. What can go wrong? But please, I just want to urge you, just be humble and keep your feet to the ground. Mr. Semamo talked about so many fables. There is one of there's one of those Greek fables of the gentleman who flew close to the sun, and the wings melted and fell down. You don't want to fly so close to the sun. Keep your feet to the ground. Yeah. Even the senior lawyers we keep castigating, they were once also young lawyers. So you are just a senior lawyer in waiting. It's a matter of years. Then I'll come to the issue of politeness. Mr. Semambo also hinted on it. When you're in litigation, you see so many strange things. There is a lawyer who drafted pleadings abusing us. You will not believe it, but the pleadings were dripping with insults. And there are emails, but there are so many emails and so many demand notices. Mr. Mambo talked about it. You can read a demand notice and you really wonder, is this my colleague who wrote this demand notice? Or is this my colleague who wrote this email? Is this my colleague who drafted these submissions? In the moment, it is exciting. But you should always ask yourself that in 5 years' time, will this matter? This insult that I put in print, will it matter in 5 years' time? This demand letter that I've written in such a manner, will it even matter in 5 years' time from now? And that takes me back to the issue of politeness. And I'll point out another lawyer. It's called Mr. Nerima. I also had the misfortune of appearing with him in court. Oh my God. Extremely humble, soft-spoken. Even when he's cross-examining, he will never shout. But I can assure you he gets the work done. So it's not about who shouts the loudest, who bangs the tables the most. I know we're in the era of banging tables. But in the arena of court, that may not work. So I want to encourage you, and maybe let me even draw from my own experience. There's a time I was cross-examining a witness. I was before Justice Kabito, he's now with the Judicial Service Commission. The judge got concerned, and he summoned us to go to to chambers. He asked me, Batanda, what is wrong with you? I said, my lord, it was, I don't know whether you people were alive by then. There is a time when maternity Ingrid was tear gassed at CPS with a group of FDC rioters. So they brought that case to court and we were on the other side. But my cross-examination was not, it was not civil. It was so aggressive. So he called me and told me, Batanda, I don't know what your brief is, but I kindly request you to be civil to the witness. You're making your point and I'm taking it. You don't need to be so aggressive. And in that moment, that's when I realized that even judges, by the way, they take note of the way we behave in court. So, to cut the long story short, we won the case. But it's not a win I enjoyed because of the feedback from the judge. You know, at times you get carried away. There's one time I went to commercial court, and this young lawyer, he almost threw the book to the witness. He was really pushing and pushing. I said, my God, this witness is about to collapse. And you know, young lawyers at times, they come and say, I really did it to that witness. But there are no points for that in business terms. So I want to encourage us that there is so much you can score, even just by being polite, not only to your colleague, not only to court, but even to a witness. I have had instances where the other side have ended up instructing the firm, and I said, we cannot take on instructions until we conclude the case with our client. But it has happened. But that's just because of the way you conduct yourself in court. Then there's the issue of empathy. Now, empathy is not sympathy. Empathy is associating with one's feelings. And I'll explain how this works. There are two young lawyers who redefined my practice. I will even name them anyway. One of them, I think, is called Kajubi Brian, and the other one is Marvin Sebugwao. You know, we had matters in the commercial court, different matters. And you know, when you're transiting from one court to the other, you may lose time, and that means you're going to arrive late. So they would call me and say, Mr. Watana, aware of this matter? Are you aware of it? I would say, yes, I'm aware of it. They say, I want to stand over it. How much time will you need to come to court? By the way, both of them did it for more than 3 times for the time those cases were before court. Now, for me, I wouldn't do that for you. I'm sorry, I have to confess that. Up to that point, I will never do that. I will just dismiss your case, and I wait for you to do whatever you want to do. But from that day they did that for me, I stopped dismissing people's cases. I even call you and say, by the way, are you going to make it to court? I no longer take joy, unless you fail to pick your call, or you refuse to pick your call, or I just fail to get in touch with you, and the judge hints that they want to dismiss the case. That's when I will dismiss. But these are young lawyers, meanwhile, but they call and they wait. When they come in, they will even apologize on your behalf. That did a lot in redefining my practice, especially in court. And the point I'm trying to make that soft skills are not only learned from senior lawyers, but even from junior lawyers. It is amazing how someone who's junior to you can have an impact on the way you conduct yourself professionally. So the question is, did I have to wait for young lawyers to do that for me? Well, here I am. So some of these things, you may look at them as doing it out of, let's say, the goodness of your heart, but that soft skill will go a long way if you're going to handle any other matter with such a person. So do you think I'll ever dismiss Mr. Kajubi's case? I can never. And the funny thing is that this may even trickle down to the firm they come from. I can never dismiss Marvin Semugwawo's case. That's the challenge. It's more like an emotional bribe. I just can't dismiss. So it shows that whatever you do for other people, there is a chance that it's going to be done for you. So this goes back to what one of the senior lawyers told us in a similar forum. He said that to be a good lawyer, you must be a good person. It's that simple. Even as we work on honing our skills, drafting pleadings like Mr. Sisemambo was guiding, please make sure you're working on some of your rough edges. I know lawyers who are very good technically, and I believe some of you know of them, but when it comes to issues to do with character, they are deeply flawed. And for me, that hurts me. It hurts me so much. Someone is extremely talented, but yet they are deeply flawed character-wise. So even as we work on being good technically, we must also remember that we must work on our character. I want to bring this to a close by talking on an issue of communication skills. And I will begin with a very interesting scenario we had at the firm. We interviewed a lawyer. That lawyer is known to us. So, of course, we went through the negotiations. We made her negotiate with herself, and we came to a comfortable spot. We wrote to her an email saying that, you know what, we have given you the position. Her reply can be summarized in an expletive. And I want to caution you against it. While you may not agree with someone's position or even with an offer, please, there is such a thing as politely declining. You write an email that is loaded, and one day you may find me in a decision-making position. What exactly will you do? So, as I told you, try to ask yourself, will this matter 5 years from now? Even as you're engaging, someone has declined an offer, or someone has communicated an offer that you're not agreeable with. How are you going to communicate that I will have to decline the offer you've made to me? So it's very important that you hone your communication skills. Then secondly, even, I talked about Mr. Mukasa Sebugenyi, Mr. Omnyokol, when it comes to presentation of matters in court. What those two gentlemen, among others, by the way, taught me about advocacy, because I researched about Mr. Sebugenyi later. And one thing that these people do is that they work hard to improve on their skill. It is not something that you're born with, it's something you can work upon to ensure that you improve on your communication skills. Communication skills via email, even in the manner in which you speak, it is extremely important. How do you address court? And the other issue is, are you audible enough? Do you understand your case? I remember when Mr. Sebugenyi was giving his introduction remarks, he disarmed me in that he even mentioned the weak points of his case. To the point I said, but that's what I was going to say. But in a sense, he used a trick of disarming. So when my turn came, he had diluted my points because he went ahead of me and just worked it out. So learn and train on the skill of elocution, especially when you're in court. It's very important. And even when it comes to presentation, elocution is key. And there are some jokes you may not want to tell in court. Be very careful even on what jokes you tell and how well timed they are. Jokes are good, but you must gauge how you tell those jokes and when you tell those jokes. Some judges just don't like jokes. They are a matter-of-fact judges. So be very careful. I've been in courts where lawyers want to begin their presentation with a joke and it backfires on them. Please, you're better off not telling the joke and get to business. Then, still related to that, I remember the first and last criminal session I did. Trust me, in my second year, I did a criminal session. I appeared before a judge, is now retired, it's called Justice Mwangusia. And unfortunately for me, the files that were given to me included, were meant to do a voir dire and a trial within a trial. Now imagine you're just 1 year out of LDC. These are things you just learnt about. Even in the moot that maybe they were conducted, you dodge the moot. Nowadays you could dodge a moot and get away with it. So when we were proceeding, the judge sensed that I was walking in the woods regarding a trial within a trial. What the judge did is said that, you know what, let's stand over this matter. He called me to his chambers and he taught me how to do a trial within a trial and how to do a voir dire. And, and that's how I got through that criminal session. What point am I making? As a young lawyer, it is okay to interface with a judge in chambers. If you don't know, it's okay. For me, if I don't know a position of the law, I will never come up with it. I'll just tell the judge, if you just give me 2-3 minutes, I will come back and address you in that portion of the law. There is this mantra of you must learn to think on your feet. But the problem is that in the process, don't make a fool of yourself. So rather than making a fool of yourself, you tell the judge, just give me a few minutes, I will address you on that, or I'll provide the authority at a later point. But there are some judges, and nowadays there are extremely few, who are willing to take you aside and tell you, by the way, I think on this issue, you should have gone about it in a different way. That group of judges has since left the bench. Now the judges we have may not have the patience for that. So, which goes back to the networking issue I told you about. If your face is familiar and they know you, they may extend you that grace and say, I think you should be doing A, B, C, D, E. So, in sum, if you are to forget everything I've said, remember this: never negotiate with yourself. I have seen very many lawyers fall prey to that one. And It's not that I derive a lot of joy to it. My main objective is to ensure that I get the best deal possible. And unfortunately, if I'm going to use that negotiating tactic, I'm going to use it. So please, as a young lawyer, I don't want you to be the one who earns the least salary in the firm without knowing it. Always be ready to negotiate and know how to negotiate. I want to recommend a book to you. It's titled Never Split the Difference. It is a very good book. I think that's the title. Never Split the Difference. It is a very good book on negotiating. Please read that book, because as a lawyer, we negotiate every day. We negotiate every day. So please read that book. You're going to negotiate with clients. You're going to negotiate with staff. You're going to negotiate even with the court. You're going to negotiate with your colleagues. You are going to even with your spouse. So just get to read that book. It's very important and it's very informative. Otherwise, I look forward to interacting with you, with the young lawyers. Don't get stuck. I want to promise you, and I think you can even take this to the bank, there is no senior lawyer who will refuse to extend a hand of help to you. Even if it means referring clients, even if it means proofreading, maybe, or peer reviewing your article which you want to publish, even if it means giving a recommendation or putting in a word for you, we have seen them do it for us all the time. So before I say that I have failed to do something, just know I have called most of the senior lawyers and they also didn't have a solution for me. So we have so many people willing to help, and let us make the most of that. Then I want to caution you, much as senior lawyers are being pushed aside, in a sense, don't be part of the people who are pushing aside. Be part of the people who are running to them to get help. We also do it up to now. It is amazing how much help you will get. That is my clarion call for you, even as I come to the tail end of this presentation. Please reach out. There is a lot of help out there, but if you don't reach out, you will never get it. Before I even forget, I will go back to one of the young lawyers whom I told you about. I think it's Kajubi. When we were doing this case, we agreed to withdraw an appeal with each party bearing its costs. The judge went ahead and wrote a ruling awarding his client's costs. He called me and told me, Mr. Batanda, I know in principle we agree that each party will bear its own costs. Rest assured, I will not file a bill claiming for the cost that the judge awarded. I don't know why the judge wrote a ruling after we withdrew the appeal, and even awarded costs that parties stated that each party would bear. But that shows you the caliber of some young lawyers we have. For me, I'm not among the people who say that all hope is lost, because I've interacted with young lawyers and I've seen the courtesies, I have seen the professionalism they have exhibited, but I just want to tell you that there is more, and you might miss out on that more if you don't reach out to interact with the senior lawyers. Others, you're doing with them cases and they say, by the way, I have so many cases that I don't have time for some of my clients. Can I refer some of them to you? And that's how we have ended up getting work. So it's extremely important that you reach out to the senior lawyers. There are many, they are available, and they are willing to help. Okay, otherwise, from me to you, thank you so much.
Thank you very, very much, Council. Can we give him another round of applause in the room? And those online, you can also clap. I see you. Thank you so very much. Yes, 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 we see the hand claps. Remember, this is, in case you've just joined us, this is the very, very first day of the Young Lawyers Symposium. And we're talking about legally balanced. That is mastering practice, purpose, and personal life. And I think this is what exactly we are doing. We have had amazing sessions today. This has been the third one. Already we talked about law, leadership, and legacy, positioning yourself for lasting relevance. That was by Chief Justice Emeritus Bat Katurebe. You missed it. If you're nice to me, I might give you a summary. And then we also talked about legal writing for young lawyers, a 360 angle that was given to us by Counsel Semambo Rashid, the managing partner at Semambo and Semambo Advocates. And then right now, we just had something amazing about winning beyond the law books, mastering the human side of legal practice. That is soft skills that move the needle. by Counsel Batanda Gerald, the managing partner at Signum Advocates. And I think that was very, very amazing. I like that you gave us examples, so you humanized it, because sometimes when that is gotten out of the story, it might feel like, okay, this is another lecture and all that, but you gave us real live examples. And honestly, if you were listening in and you're taking notes and you're not just signing in and zoning out because the CLE points, then I believe you're going to be better. I think you have highlighted something about negotiation, and I think that is something that we're struggling with quite a bit. And I find that sometimes it's something that is just brushed over, and yet it is the core, because we bargain with people every day, we bargain with ourselves. So thank you for highlighting it and giving us live examples. You've talked about soft skills, and you say life doesn't give you what you deserve, it gives you what you negotiate for. That's very amazing. And if you want to make a mistake, you better make a new mistake, not a repetitive mistake. Never negotiate with yourself. Stand solidly for you. And yes, it is very, very key. I've experienced that myself, and I know even people online and people in this room have sat before a panel on job interviews, and even with partners and clients, and they keep taking you down, and you think, okay, because I need this opportunity, if I say this, then they might take it away, So you sell yourself short, and then you go to bed sad, beating yourself up, because you're thinking, how would I know? Because they kept saying this. But now that you've given us these tools, especially that you are the person that sits on the other end of the table, so I think this has been really insightful. Thank you for giving us the hacks. Surprisingly, you might find somebody who has listened to this and it has just passed their ears, and they'll find you and you pull out the same card, and they will fall for it.
I pray.
You pray. And so you also mentioned, sir, that the first level of networking is with colleagues. Let them know your skill set, that you have the time and expertise to attend to clients. And I think this is also something we ignore. I find that it's mostly more of competitive. You just feel like I have to shove you on the side, step over you, show that I can do this, and yet this is what we need. So thank you for also grounding us in integrity, grounding us in there's enough room for everybody, and reminding us to not fly so high close to the sun. We need to stay grounded. So those are some of my takeaways. And of course, the book, someone was very, very quick to send me the soft copy. I thought, okay, that was so fast.
Oh,
so,
okay.
so definitely I am going to read it, and I will give a report, because the person who has sent it has been listening in, and they just immediately forwarded it to me. And I just wanted to read the writing on the cover, because once again, like I say, I think from the start of this year, what has been resounding over and over and over is how much we need to learn negotiation. So the book says it's by a former FBI top hostage negotiators, field tested tools for talking anyone into or out of just about anything. I love that. Never Split the Difference, Negotiating as If Your Life Depended on It, by Chris Voss. And Voss is VOSS. So I hope we do better. So ladies and gentlemen, please help me. Let us appreciate this amazing, wonderful, insightful, I don't know how else to call it, because we had Mr. Sembambo saying we need to be careful what we say. So I'm very cautious about it, but thank you very, very much, Counsel Mr. Batanda, for sparing your time and investing in the young lawyer. Please appreciate him for me. Thank you very, very much. Yeah. Okay. So, and we still, of course, want to appreciate Uganda Law Society for making this very, very accessible. I think there are comments down. Somebody who is controlling the screen, please help me so I can. The remote is technologies. Okay. Okay, so I want to appreciate Uganda Law Society for making this possible. I want to appreciate Bluebell Legal, and we want to appreciate Praxis Conflict Center, especially for hosting us today physically. And of course, MAMC, Muslim Arbitration and Mediation Center, Uganda. The remote is remoting, but I will come back to you. It's a touch screen. We're in an age of technology. Yeah. maybe as they do that, I'll just resound another thing that I wrote down. The art of storytelling, not that, that was before. He talked about examples of, respecting the seniors. And sometimes we just come off because we have this energy. We feel like these old guys have nothing to say to us, and you just want to go and unleash everything you have on them. But we have been asked, to just tone it down. And instead, if someone is better, they are not a rival, walk up to them and ask them for help. And all it takes is asking, because he has also shared examples of things that have broken because he just asked. So let us also be humble enough to ask, but also to know who to ask, because that is very important. And while we are at it, I think also the how matters. So that is why he talked about humility. Yeah, humility and civility. Okay. So somebody saying, can you please share the soft copy of the book with us as well? Thank you, Gloria. You might have to pay me. It's at a fee. We are lawyers. I'm practicing my negotiation on you. Okay. Francis is clapping. We've had several claps for you, sir. Robert Amake. Oh, that was my PA. Greetings to you, sir. Naka and Jaco Nora, I see you. Patrick, I think that's a Simwe or something. I see you too. Do we have more people down? Okay. You should see that the screen is working by motion. But that's a lot of clapping. So, ladies and gentlemen, I will definitely pass on the soft copy to, alternatively, you could message me, Joy Imbabazi, on my X, on my LinkedIn, on my social media, really, and then I'll be able to avail you this copy. And I'll also pass it on to Ruth, who is at ULS, and then we'll see how to get it to you. I'll be kind, okay? Because knowledge is for sharing. So I was waiting on direction on what next, because I see it's 13:35. But thank you very much for keeping it there. We see you, online people. Okay. So right about now, we are just going to continue and keep running. We're going to go into a panel. That's going to be the family panel. Where is Ruth? Okay, I'll wait on her. Okay, ladies and gentlemen, we're still on. I hope you're there. And now I have I have the bargaining power. If you need the book, you make sure you let me know that you're on, and then I will send it to you. But you're still with us on the very first day of the Young Lawyer Symposium as we talk about legally balanced mastering practice, purpose, and personal life. And my name is Joy. So yes. Just share the soft copy on our emails at Afi. Okay, so ladies and gentlemen, I don't want to waste any more of our time. We're going to move into the next session, and that is courtroom communication, courtroom presence, and advocacy skills or trial experience. And this is going to be none other than Counsel Julius Ojok from Ojok Advocates, and he has 19 years of legal practice. He's a member of ULS and East Africa Law Society, part-time lecturer at LDC, and he was among the pioneer court accredited mediator attached to the commercial court from 2010. He's been an arbitrator with the Center for Arbitration and Dispute Resolution since 2012 and has presided over several high-profile arbitrations. Mr. Ojok is an instructor for arbitration, mediation, and trial advocacy. He has trained many of the tax appeal tribunal and hundreds of lawyers who have ended up in the different areas of the legal field. He's skilled and experienced in litigation and dispute resolution. And he has facilitated trial advocacy trainings for Tax Appeal Tribunal, LDC, Uganda Law Society, Society of Botswana, International Law Center, Uganda Revenue Authority, FIDA, Justice Centers, Legal Aid Service Providers Network. And he has also facilitated trainings in South Africa, Nigeria, Ghana, Botswana, Kenya, and Uganda. And he's also teaching income tax law at East African School of Taxation. Ladies and gentlemen, in the room we clap, and online we send some claps as well. We see them. Yeah. Thank you very much, sir. I don't know if you're ready. Can you hear us? We can't
Can you hear me?
Yes, sir. We hear you. So over to you.
Thank you very much, Joy. The book you're sending out, I think besides my guide on mediation, which I wrote for Caseta, it's the book I've given out most. If you want to find a hard copy, just next door in stock, you will find them. Thank you very much. I hope you can share my presentation. I will now put off my video and share the presentation so that we can engage fully. Listening this morning to Joy introduce the day and the program, and listening to CJ Emeritus, with whom I've had many trainings, and I also train for Practice Center, listening to Mr. Semambo, whom I was with at law school, and our colleague, Mr. Batanda. You could see the communication styles and skills that they exhibited. And each had a different style. And that is where I want to start off this afternoon, especially concerning courtroom communication and presence. So we start off with what is effective communication? That should be on the second slide. Effective communication means sending out information to a recipient who should be able to understand what you are talking about and give you feedback. And so it's a two-way communication. It is you sending out information whether you getting feedback. If you don't get feedback, then you need to question whether you've effectively communicated. And for us trial lawyers, this is very important. And I get the sorry about the internet. Can you hear me? Please, Joy, confirm.
Loud and clear, sir.
Thank you. So for us trial lawyers, there is this quote that we usually use. Don't tell me the moon is shining. Show me the glint of light on broken glass. If I asked one of you in the room at Praxis Center to tell me what the room looks like, what would you say, Joy? Where you are seated right now?
I would say there's a little bit of sunshine. I'm trying to be as poetic at that thing, but the sunshine coming through the windows, those books have better words, but yeah, I see the light, sir.
What else?
From where I am, there's a little bit of shadows in one corner of the room. The blinds are drawn to the extreme end outside where the window is a little bit wide open. Yeah, some light entering. My poetry is limited, sir. But there's no broken glass.
Is there anybody else who can speak to me and describe the room?
Yes, sir. Bridget is here.
Can I hear his or her description of the room?
She's coming on, sir.
Great.
It's cloudy and kind of some.
Cloudy and?
There's no room in this room. There's no light in this room, and it's a dull room. It's cold, and it looks like it's going to rain outside. That's all I can say. Thank you.
Thank you very much, both of you. I will now tell you where I am. I'm speaking from the city of Gulu. It's cloudy. The blue sky is covered by the white cloud. Where I'm seated, it's a grass thatched. The grass is low. There's some light coming to my face. I'm seated on a plastic chair. My table is glass. My computer is on the glass table. There's no one else in the room. I can hear my sound. The grass is neatly made, knit together over a bamboo sticks, and you can hardly see the light. Much as it's hot out, it's cold inside. I can feel the breeze from where I am seated. Is there a difference from our three description of where we are?
Wow, sir. A teacher is a teacher. That was fantastic. Probably the colleagues online would want to give it a shot after your example.
Okay. And so just to save time, I will go now to, and so when we use this quote, don't tell me the moon is shining, show me its glare. I mean, its glint on a broken glass. we ask you to demonstrate to the judge or the magistrate what happened. Mr. Batanda and Mr. Semambo talk about your story. Do not tell your story in trial advocacy. Show your story. Let the judge feel your story. We, in most cases, talk about accidents and we don't describe what happened, who was in the wrong, how did it happen. All these are communication aspects that we need to master. And don't tell me it is an art of advocacy. Tell me exactly what you want. How did your client feel? What did your client see? What did your client say? That is what the judge would like to hear. The judge is a human being. And we can now move to the third slide, and we go through the pillars of communication, as I prefer to call them. And that will demonstrate to us or show us how we can effectively communicate. IT, please, can we move to the next one? Can somebody help us?
Working on it. The third slide.
Okay, great.
Yeah. Oh, sir, you may
So
yes, please. You may continue on your end as we roll to it.
in communication, there are three pillars of communication. We have the speaker, we have the environment, and we have the audience. As we will see, you are the speaker, and in this case, your audience might be the judge, the magistrate, opposite counsel, or the witness. I know that I had Mr. Batanda said they focus on 5 people. For purposes of trial advocacy, we limit it to 4 so that you don't play to the gallery because they are not the primary consumer of your information. And so these are key people when you're speaking to them. And the third element is the environment. Right now, I'm speaking to you at lunchtime. It has an impact on how I communicate and on how you receive my communication. If you've not taken lunch, you're probably thinking about lunch. If you've already had lunch and you had a little bit more, you're probably not paying much attention. But there are those who will pay much attention. We are also talking about the day. Is it a Monday or is it a Friday? Where I practice from now, I left Kampala. In Gulu or up-country stations, if you have judges and magistrates coming from Kampala, then you are a bit worried fixing your case on a Friday afternoon because they will be thinking of going back to Kampala. On Monday morning, they are just arriving from Kampala, and that affects how they receive your communication. And so as a trial lawyer, those are some of the skills that you need to pick out. I mean, those are some of the skills you need to develop in order to pick out what the judge or the magistrate will say. How about the temperature? Sometimes it's extremely hot and it becomes quite uncomfortable. Last year, we had a session in Noya, anti-corruption court. Acting PJ came to Noya, and it was extremely hot. So after the morning session, she came back and said, you can all unrope and we proceed. That's the impact of the environment on the proceedings. Before I revisit these ones, let's go to communication itself. It's divided into verbal and non-verbal communication. And Chris, whose book Joy is going to share, talks extensively about non-verbal communication. When we talk about verbal, and that is what we lawyers like most, but if you go deeper into communication, verbal communication constitutes only 15%. In case you're thinking you had it wrong, no, you didn't. It is 15% of what you communicate. The rest are nonverbal communication. And therefore, it starts from the facial expression. You could see how Justice Batka Turebe was expressing himself in the face. Even Joy, when she was introducing how happy she was able to give us AOB at the beginning. You could see the seriousness with which Semambo was speaking, expressing that you would read that pleadings 8 times. And so the facial expression gives you a clue onto what somebody is saying. If I were in the room, I would be able to pick up some clues on how you are communicating. The next one is the body language. How somebody is seated, what positions are they seated, where are they facing, what are they doing, are they sweating, at what point of the body is the sweat coming out, how is their mouth moving, how is the nose, are they blinking, and at what point are they blinking, how is the forehead arranged. And this is all communication, and you need to pay attention to who is in the witness box and communicating to you. And then we have what we call paralanguage. When we talk about paralanguage, we refer to the tone. Sure, either Semambo or Gerald mentioned about the tone. The inflection is very important, and the speed. How you communicate. The speed is quite important. I could tell that Joy was right in the middle as far as speed is concerned. CJ Meritus was a little bit slow, Batanda was a little bit quick, followed by Semambo. Now, when somebody is communicating, you need to be quick. Please don't judge somebody on the first hearing. And you think you know about that person, and you think you can. I may be wrong to say that Joy speaks fairly comfortably, or the CJ was slow, but you should be able to determine the dominant speed and the dominant tone. I'll take you, for example, if you are in court and you are listening. These days we are deprived of examination in chief because of witness statements. But if you are listening to somebody in examination in chief, you may take that to be their default tone or their default speed. And so when you rise on your feet to cross-examine and you begin to realize that the tone is dropping down or the tone is going up, then you know that there is something to pick up. The person is either getting annoyed, or the person is not telling you an accurate thing, or the person has something to hide, or the person has something that he or she is ashamed of, and you need to know which one is which so that you are able to pick it up. So all this combined form a non-verbal communication. And for the judicial officers, you starting your career as a young lawyer, look at the body language of the judge. Is he just looking at your witness? Is he writing? Has he stopped writing? What is he saying? What is his body language saying? How did he walk into the courtroom? Judges are human beings. They quarrel with their spouses, they have challenges with their children, and yet they still have to come and listen to your case. So how are you going to deal with this judge who doesn't look happy? I am not saying you be subjective all the time, but it's important that you read the person you are appearing before and be able to make your case accordingly. Having differentiated between verbal and non-verbal, we now come back to our audience, and I come back to the judge. I've already said they are human beings, but it's important. How is the judge dressed?
Pardon, sir.
he depicts a serious demeanor or not. You are able to tell from the way the hair is arranged, from the way the collar is appearing, from the suit and everything, you're able to pick a communication from that. That is not conclusive information, ladies and gentlemen. You need to corroborate that information with other pieces of information. Do not make a conclusion only based on how the judge or the magistrate appears. Turn to opposite counsel and look at opposite counsel carefully. How is he appearing? How is he talking? What is his pace of communication? What language is he using so that you are able to understand him? A few names have been mentioned. I have personally met most of those people in court. I've worked with many of them. And again, I need to point out this: communication is an art. It is not a science. You're not born with it. We all develop it. And if you decide to work on it, you can develop it. The unfortunate bit is that we go 5 years in school and no one bothers to teach us about communication. We go for masters, we go for PhDs, but little do we bother to pay and even do a communication training. So it's very important that you work on your own communication as an advocate. When we do trial advocacy course, we now dedicate a day on communication exercises to help our trainees get up to speed with that. It is also important that you pay attention to their gestures. How are they gesturing in court? When counsel is, you may not be able to read much, but when they're standing and their hands are free, you're able to gesture. You as a speaker also adds to your communication. And therefore, we always try as much as possible that you avoid crossing your fingers, touching your pen and keeping to your book so that your gestures can help. Witnesses is another important audience that you need to pay attention to, whether you are conducting examination in chief or cross-examination. As I already said, the tone and the speed in which they speak tells you volumes about what they are saying. And that is where we will look at a bit of the technique in cross and in examination in chief, how you can help and how you can prepare them. I have already talked about environment, and I would like to talk a little bit about you. Joy mentioned at the beginning that the definition of a young lawyer is still being debated. I know in terms of the years in the profession, it should be about 5. In terms of age, something like 35. I'm not so sure about that. But I would like you to picture a young lawyer as a young tree. That is a period of tremendous growth. That is a period of tremendous learning by this person. They are trying to find their feet in the profession. They are trying to learn from everybody, and they are trying to grow. And that is how you should treat yourself. Don't look at a senior lawyer and you want to be like that from the day go. Take your time. As Mr. Sebogenyi would tell us, it's baby steps. It is a marathon, it's not a sprint. So take your time and learn one step at a time. And so when you set out to make yourself a valuable person in the courtroom with the presence known, we always go for the 4 Ks, which I'm sure many of you have heard about. Know the law. I can't emphasize that more than what Mr. Semambo has said. Before you go to court, you should know your law. Sometimes the judges will ask you, counsel, have you addressed your mind to this? And you can't answer. In trial advocacy, we say you do not rise to the occasion. Let me repeat. You do not rise to the occasion. You fall to the level of your preparation. I'll repeat. You do not rise to the occasion. You fall to the level of your preparation. And so you must know the law in and out. If it is negligence, please know it. If it is contract, please know it. The second bit, and knowing the law gives you the confidence. I know Gerald mentioned senior lawyers and how difficult to come across them in court. Don't worry about that. If you know the law, you will sail through. I remember when the Employment Act was just passed in 2006, one of the persons Gerald mentioned, I defeated him in court over that law. I was then fresh from LDC, but I knew the law. And the judges will always look out and be helpful if they see that you are prepared and you are presenting your case. The second person you should know is the judge. In this case, I also mean the magistrate. In the event that you now appear in the Court of Appeal and the Supreme Court, I mean your quorum. Before you appear in those appellant courts, look at your quorum and know that if I'm appearing before Justice Ngonda Ntende, Justice Chirabwire, the CJ, what do they want? What will they look for? There are judges who get very excited when you cite for them their decisions. And so it's important that you get to know that and you do the same. We are human beings. We have feelings and emotions. The best way to do this is to humble yourself and talk to the clerks. How does this judge want his things done? I remember when Justice Chirabwire introduced scheduling memorandum at the commercial court before there was even a law for it. We would go asking, how does the judge want this done? And the clerks are always very helpful. They will give you the clues on what you want. Don't be arrogant to them. Actually, many of them are either students of law or are actually advocates. They will help you a lot. Know your case. By knowing your case, I mean you should know your facts in and out. Sometimes you are just given files by senior lawyers to go to court. Please endeavor to read at least the plaint and the defense if you were ambushed, so that you know what to say. And please read the last proceedings on the file, and you get to understand where you are so that you can pick up from. I always emphasize to young lawyers when I do trial advocacy, make sure that you are on top of your facts. The judges and the magistrates, I will qualify that, not anymore these days. Some of them are also green. They already know the law. There is no way you are going to go to the Court of Appeal or the Supreme Court or before many, many of the High Court judges and they don't know the law. What will be your saving grace is your case and the facts. And finally, no opposite counsel. There are those lawyers who come to disrupt. There are those lawyers who come to adjourn. And there are those lawyers who come to fight for their clients. Know them and be able to deal with them accordingly. Prepare for them. Don't let them take you by chance. Make sure that you know the opposite lawyer and you can deal with them appropriately. And so this is the gist or the crux of courtroom communication. And the moment you master this slide, that is it. When I was preparing my presentation, I only had this until I saw the bit on trial advocacy. And so if you want to master the art of courtroom advocacy, please just look at this slide and that will be enough for you to get going. Having said that, let me move to a few slides to help you with your trial advocacy. And I'll go to examination in chief, which is the most important aspect for you as a lawyer with your witness. In examination in chief, we ask you to tell your story. And in telling your story, it is your witness. And so you use your witness. Now, in most of our civil cases, we are deprived of this because we now use witness statements, and you have to prepare the witness statements and file it in court. All you have to do is to introduce your witness and have him or her get the witness statements admitted. But you can do this in your chambers. The same question you would ask in court are the ones you are going to ask this witness in order to prepare the witness statements. And so your witness is telling your story. One witness might not tell your entire story. Let him tell the part of the story that he or she is familiar with and he is rightfully allowed to tell. Don't bring in hearsay, don't bring in legalese, and don't bring in those big words. Use simple English. As I said earlier, it is your story. If it is a case of collision, or what we usually refer to as an accident, tell the story of the accident. If it is a case of a divorce, tell what this gentleman or this lady has gone through and why the judge should decide in your favor. And finally, make your case. We all know that the case must be supported by the law, which is a cause of action. So from your facts, have you brought out enough facts to make the elements of the cause of action? The second aspect of exam in chief is to ask open-ended questions. If you still do criminal law, and you may, there you still ask open-ended questions. If you are leading your defense, unless you are a prosecutor, then you will ask open-ended questions for the prosecution witnesses. The reason why we emphasize open-ended questions in exam in chief is because they are non-threatening. It is a different thing asking Joy, please tell court what is your name in examination in chief. She'll feel very comfortable telling court her name. In cross-examination, when I ask her, your name is Joy, is that correct? I am not giving her any latitude to explain. I am just telling her to confirm to me. And so use open-ended questions because they make the witness calm down and they are non-threatening, and the witness is able to tell the story from their perspective. Afternoon, use proper organizations. All those lawyers that Gerald mentioned are very organized, whether in the examination in chief or cross-examination. Use chapters. Let's take, for example, a case of negligence. Have a chapter on a duty of care. Have a chapter on the fact that it was the defendant who breached the duty of care. Have a chapter on remedies. Have a chapter on what your witness or your client has gone through. And start, of course, with a chapter on biodata and introduction. And as you move within those chapters, use transitional statements. There is a problem with the spelling there, but they are transitional statements. You transit from one chapter to another. Thank you for telling us about who you are. Can we now look at the accident of the 1st of October 2025? Tell this honorable court which car you were driving on that day. And when you are done with the accident scene, you now tell her, thank you for telling us about the accident scene. Can we now move to the problems that you've suffered? Tell court what injuries you got. And so you use transitional statements to move from one chapter to the others. But in all, have a very good organization of whether it's an opening statement, exam in chief, or cross-examination, and also submissions as well. Let's move to the next slide, which is on cross-examination. Contrary to exam in chief. In cross-exam, you are going to use leading questions. Many people say leading question, the purpose of cross-exam is to destroy the evidence of the other side. Not entirely accurate. Sometimes you want to use their witness to tell your story. And so there is no better way to tell your story through their witness. And you are going to use that witness to tell your story through leading question. Please confirm to this honorable court that it had not rained on the day of the accident. Confirm to this honorable court that you are driving on the right side of the road. Confirm to this honorable court that the plaintiff suffered multiple fractures on his left leg. And so you use that witness to introduce your story to the court. And when you bring in your witness, they will then reconfirm. Or if you started as plaintiff in cross-examination, you are just enlisting information that confirms what has been said in the plaintiff's case. The second one is use short questions. Usually we emphasize one fact at a time. You've probably seen lawyers and prosecutors who then say, can you explain to court what happened? For the prosecutors, sometimes they even sit down and the witness will go on for 15 minutes, for 10 minutes, for 5 minutes. In court, you as an advocate, you are the director of the story. You control what comes out of the witness. And so we suggest to you that you use short questions that is able to direct the witness clearly. The accident happened on Wednesday. It happened at 2 o'clock. It was daylight. You could see the person next to you. There was no obstruction. If you also ask short questions and you are in constant eye contact with the witness and the judge, you are able to control the pace at which the judges are writing. I noticed that much of our courtrooms in Kampala have recordings and some of them up country, but our judges still prefer either to type or to handwrite. And so you control it by the asking short questions, the witness is explaining, and you're focusing them at the judge. Use simple language. The judges already know, they will have time to research about it. Those big words, they are not important. The most important thing is to pass the information from the witness to the court, and that is what the judge is looking for. In some jurisdictions, they are referred to as the trier of facts. And so they are looking at the facts. They will always get the law. Unlike in arbitration, where somebody cannot bring in a law that has not been argued, a judge can bring in authority from any directions, not only what the lawyers have prepared for it. And finally, for purposes of this afternoon, I would like to talk about preparation. That is the previous slide. When I did my clerkship with Katende Sempe, but one of the things I was told is prepare, prepare, prepare. The first 3 rules of trial advocacy is prepare. And if you add the 6 rules, it is prepare, 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 consult, consult, consult. And so preparation is key. When you are preparing for cross-examination, make sure that you know each and every answer to your question. Do not ask a question you do not know the answer. The witness will go away. If you are doing cross-examination, it is like holding a dog. When you are holding a dog, you hold it on a short leash, not a long one, that it can meander and bite other people. And so with cross-examination, make sure you know all the answers and you are directing that person to that answer. Let's go to submissions. Submissions is now where you put in everything. For both exam in chief and cross-examination, you are not allowed to argue. But in submissions, you are now allowed to argue. So the first thing is to state the facts clearly as I said earlier, the facts is what will bail you out, more so as you can at least assume that the senior lawyers know a bit of the law. I'm not saying that is quite accurate, but at least you know your facts and no one can beat you at your facts. So use the evidence, the testimony in court to remind the court of the cause of action and the elements of the cause of action and the reason why the judge should give that remedy you are seeking. Please make use of the exhibits as well. The exhibit speaks more than the oral testimony because the judge can see, they can observe what has happened. Argue the law effectively. Now with with the artificial intelligence, AI coming in with our small notes, I think it was Mr. Sembambo who mentioned that people can now go through the law school without reading the entire law report. Many people look for a paragraph, sometimes even a line. But it was Justice Christopher Madrama who reminded me when I was doing the research for the case of Osotrako in the Court of Appeal. He told me, Julius, do not look for an authority because a paragraph or a line supports your case. Make sure the authority agrees with you on the all fours. And so make sure that you cross-check the statutes and the citations of the cases and even the authorities. If opposite counsel cites an authority, please distinguish them or ask for change of law. The judges can actually change the law if it is the same level. We've had various decisions on summons for directions. And so if it is the same level and the case is not in your favor, ask for a change of law. As an advocate, it is your skills, your superior skills. Any person can talk about the law, any person can talk about the facts, but how you navigate and what Semambo referred to as persuasion. Your persuasion comes from how you are going to marry the law and the facts. And that is the reason why you should win. If you look at the ratio decidendi of any case, it is the law together with the facts. And that is what in trial advocacy we call the theory of the case. What is your theory of the case? Why should the judge decide in your favor based on the facts and the law? Ladies and gentlemen, as we come to the close of our stay this afternoon, if there's anything that you have to take with you, I know Semambo and Gerald have called it humility. In trial advocacy, we call it courtesy. Please be courteous to the judge, be courteous to opposite counsel, be courteous to the clerk, be courteous to your client. Courtesy does not mean humility. I am a Catholic, and humility might take a very different angle. I am very courteous, but very firm, especially where you see that the judicial officer is misled. Be very firm and argue your point and the reason why you should win. Please do not beg. You are there to argue justice, and you are there to argue the law. And finally, St. Carlos Acutis said, we are born as originals, but many of us die as photocopies. We are born as original, and many of us die as photocopies. Do not look for what I do best and want to copy it. As a young lawyer, find your voice and find your personality in the courtroom. Your presence will be felt in the courtroom. Ladies and gentlemen, I thank you very much.
Can I see the clap online as well? And in the room, at least in the room, we can be heard. Yes. Thank you very, very much. That was absolutely, absolutely enlightening, Council Ojok. And he took us through courtroom communication, courtroom presence, and advocacy skills, trial experience. And I think we want to just, if you have a question in regards to this, please, I think you may have to raise your hand and you may ask. Just let me know. Or you can text. I can also see the messages on screen. So let me know. Thank you, Patrick Asiku. You're saying thank you so much, Council, and all the, I think they've given me a full screen, so I'm not able to see the messages. Could you help me split it again? But yes, if you have a question, let us know. You may message it, you may just put it in the message section, because then that is the interface I have on my end. And if you have just joined us this afternoon, welcome once again. This is the very first day of Young Lawyers Symposium 2025, organized by Uganda Law Society, by Praxis Conflict Center Limited, by Bluebell Legal Advocates, and of course by MAMSI, is right behind me. Yes, and it's a privilege, it is an honor to just get this kind of information, to get this knowledge, because I know there is a gap in mentorship. And so when we get people who are experienced, who have gone before us, to just spare their time and come and talk to us and be present, I think if you are wise, then you will not be left the same. And of course, I will do what I have done for the rest of the sessions, give my highlights, because it is very important for a lawyer to have a pen and a paper, or utilize the digital bit and note down something, because you never know when you might need it. And I think the greatest lie I have found is that, you know, when you listen to something and tell yourself, I will remember that. Truth is, half the time, I think 99%, we forget what that was. Or if you do remember, it's just bits and bits of that thing. So I would encourage that every time you have an idea, every time you're in such a space, every time you're in the presence of greatness, or in a space where you think you could learn something, pen and paper is very, very essential. And I think the third slide was very important, sir. Thank you very much. We talked about the pillars of communication, both verbal and non-verbal. And I think my highlight, oh, okay, the bit of the messages is coming on. That's very good. I don't know if I have messages from up that I might need to read. Okay, thank you for sharing. I see you, Gloria. Okay, so I could read as you slide. Is that okay, sir? Who is helping me? Okay. So Pamela, I see you're saying thank you, Council Ojok. Patrick, you're saying thank you, Council. Hannah Opus, you're saying thank you. Who is right after Hannah? Could you scroll down? Sorry. They're up. Are there others up? Okay. We'll get to that probably. But yes, I think on the non-verbals, you were talking about facial expression, body language. You're talking about the tone, the speed. But my highlight was on the forehead, because as you can see, I'm naturally gifted. So when you talked about the forehead, how is it positioned? I stopped a bit, because I needed to see how my forehead is looking. The hair is covering it a bit. It's strategy. But yeah. That was very helpful, that if we take it and put it into practice, I think we'll be better lawyers. And then you also talked about, you said there's a quote that you do not rise to the occasion, you fall to the level of your preparation. And that ties back to something you say towards the end: prepare, 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 and consult, consult, consult. We will remember that. And yes, you have also highlighted the last bit about humility, although you defined it in a different way. But I believe that we are smart and we will do better. So once again, thank you very, very much, Council Ojok, for taking off your time to teach us communication beyond what we see, beyond being basic, but to be really, really intentional about how we show up, about how we prepare, and about how we relate with the clients, with the people around us, and also court decorum. So once again, let us clap for him in the room and online, and appreciate him. Thank you very much, Council Ojok. Okay, so...
Thank you very much for having me.
It's our honor. Okay, so we're going into the last session of the day today. We have skipped the family panel. We're going to have it tomorrow because, as you noticed, that we started a little bit late. So tomorrow we're going to pull the family panel on. But now we're going into our very last discussion, which is from registry to resolution, the full spectrum of ADR Uganda. And we're going to have an amazing lady, the CEO and the brain behind Mamsi. And I can't wait for her to just get on and tell us about it, probably. And also get to I know it's a little bit of, it might be off, or maybe it might be, since we're into mentorship, she might as well just highlight a little bit on what it meant for her to start up her own thing. Because at least from the time I've gotten to know her, I know that she's passionate about writing. And in the room, actually, you can hear the sound of her fingers on the keyboard. She has that fast typing. She has done judgments and all that. So, ladies and gentlemen, I just want to pass this on to Council Zubeda. And in the room, let us please clap. Let us do that clapping on screen as well. Okay. Thank you very much. People are eating. Okay, you clap and eat. Thank you very much. Okay, she's getting up on.
Hello, everyone. Yes, as introduced, my name is Zubeida Namgenyi, and I'm an ADR enthusiast. I am also very passionate about mentorship and empowering young lawyers with the skills they need to thrive within the legal space and outside the legal space. I am the CEO of the Muslim Arbitration and Mediation Center, Uganda. And what we do at the Muslim Arbitration and Mediation Center, Uganda is, of course, push for customized access to justice. So, Joy, I hope at the end of the day you can found a Christian mediation center. There's always space, and I'm sure my co-panelist, Mr. Sekavanja, will be happy to tell you more about that. I'm also the chief editor of the Legal Forte newsletter, a space that allows lawyers to share their stories, learn about law, and basically encourage people to write. I am also an enthusiast for writing, and I was so excited when I heard Mr. Semambo talking about the essence of writing. I feel like writing is at the very heart of what we do as lawyers. And so one of the things I do the most is really push for lawyers to write more, read more. Sometimes it's against their will, but yeah, we'll get there. Then also, I push for personal branding. I feel like if you want to get freedom as a lawyer, you need to invest in your brand. What do you stand for? What do you do? What are you skilled at? And Mr. Batanda was very effective in communicating that. Even within the legal sphere, your colleagues should know as lawyers what you do, so that at the end of the day, if there's a case that I know my colleague is better suited for, I would easily refer the case to the person instead of taking it on myself. So basically, that is pretty much what I do, and I am excited for the ADR conversation. Thank you.
Okay. Don't worry, the panel is formulating. They're coming up. Okay. Ladies and gentlemen online, I think we had missed a comment there. I never get tired of reminding myself. Can I be heard? Yeah. Somebody had said I never get tired of reminding myself of those skills. The information flowing from the symposium is not for young lawyers only, but also for all of us. Thank you, ULS. Definitely agree with you. So ladies and gentlemen, once again, we are on a panel discussion that is going to be talking about from registry to resolution, the full spectrum of ADR in Uganda. And it's going to be moderated by Angom Ruth Julie, who is already here. And we have Miss Anne Namara Musinguzi, we have Mr. Isaac Sekabanja, and of course we have Council Zubeda Namugenyi, who has already introduced herself to you. So, and this is our last session, our last panel for the day. So I want to encourage you to still sit through, have your pens and paper, and let's get to learn more. And this is the Young Lawyers Symposium 2025. Over to you, Ruth.
Thank you so much, Joy. As already introduced, my name is Angom Ruth Julie. I'm going to be your moderator for this session, and I have a wonderful lineup of speakers that are going to blow us away this afternoon. Let's keep it locked. Yes, so I'm going to just delve right into it. So we have Miss Zubeda Namgenyi, who has already introduced herself, but nevertheless, I'm still going to read out her bio. Yes, so Miss Zubeda Namgenyi is an advocate of the High Court of Uganda, a certified mediator, arbitrator, and the CEO of the Muslim Arbitration and Mediation Center, who are one of our partners for this Young Lawyers Symposium. We are so happy to have you. Yes. And she is a passionate advocate for alternative dispute resolution and a firm believer in accessible, people-centered justice. Zubeda holds a Bachelor of Laws from Makerere University, a postgraduate diploma in legal practice from the Law Development Center, a postgraduate diploma in public administration and management from the Uganda Management Institute, UMI, and a Master's of Law in oil and gas from Uganda Christian University. With over 10 years on the role of advocates, Zubeda blends litigation expertise with a deep commitment to ADR. She is a member of the Chartered Institute of Arbitrators and sits on the advisory board of the Africa ADR Network. Wow. Wow. She is also the chief editor of the Legal Forte newsletter. I like how she pronounces it, where she uses her voice to demystify complex legal issues, spotlight ADR developments, and empower the next generation of legal minds to write. I personally have been a beneficiary of that. Yes, and she's very good at what she does. A mentor, writer, and personal development enthusiast, Zubeda is deeply passionate about professional growth, personal branding, and promoting inclusive justice systems in Uganda, Africa, and the world. Let's give a hand clap to Zubeda. Thank you so much for being one of our panelists. Yes. And then right next to her, we have Miss Anne Namara Musinguzi. And if you are interested in ADR, I'm sure you've all encountered this entire panel. Yes, and Miss Anne is not a new face either. So Miss Anne is the founding and managing partner of Namara Musinguzi and Company Advocates, a boutique law firm specializing in arbitration, construction law, and corporate governance. She is a member of the Chartered Institute of Arbitrators, Uganda chapter, and chairperson of the Education and Training Committee of the chapter. She is the editor-in-chief of the chapter quarterly newsletter. She's the director and head of faculty, Construction Law Institute. and she is the editor-in-chief of the Construction Law Institute Yearly Digest. She is a thought leader in the areas of construction law and arbitration through writing articles and participating as a trainer and panelist in trainings organized by CIAB, ICC Construction Law Institute, and ULS. She is an arbitrator and dispute avoidance, and she is on the Arbitration and Dispute Avoidance and Adjudication Board. She's an arbitrator on that board. Yes, and last but not least, we have the only gentleman on the panel. Yes, we are so happy to have you. Let's clap for Miss Anne. And yes, so we have Mr. Isaac Sekabanja. Mr. Isaac Sekabanja holds an LLB degree from UCU, a postgraduate diploma in legal practice from LDC, a master's in law in construction law and arbitration from the University of Aberdeen, and Isaac is a lecturer and the head of Alternative Dispute Resolution at the Uganda Christian University School of Law. Let's give a hand clap to Mr. Isaac as well. Thank you so much, our distinguished panelists, for making the time and agreeing to be on this panel this afternoon. And we're going to just go right into it. So, as already introduced, our panel discussion is titled From Registry to Resolution, the Full Spectrum of ADR in Uganda. So basically, we're going to discuss about ADR and what are the opportunities that you as a young lawyer can tap, or in case you have any interest in ADR, how you can, explore how to come abreast with ADR. So my first question goes to Ms. Zubeda. Yes, Ms. Zubeda, why is ADR often described as the future of legal practice in Uganda? And what does that mean for young lawyers just starting out? Please tell us about that. Thank you.
Well, ADR is described, in my view, ADR is described as the future because it is what the people we serve demand. We are used to this traditional way of resolving disputes, but it is failing. The judiciary has admitted they cannot cope up with the numbers, and yet the judiciary only takes, according to the Hill report, only 10% of the cases in Uganda utilize lawyers and anyway end up in court. So there is 90% of cases that have not even, don't see a lawyer and never make it to court. And yet the judiciary is struggling. So imagine a situation where all the 90% decided to bring their disputes to court. I think the system would collapse. So the judiciary is really acknowledging the fact that they are overwhelmed. The court users, the users of the justice system are not happy. You cannot wait for 18 years to have a court resolved. You cannot wait for 10 years to have a case resolved when you have a business running, when you have family relations that are being severed. So basically, it is not working. So everyone knows the only way is alternative dispute resolution because it is faster, it is more efficient, it is less costly in the long run, and basically it preserves relationship. Thank you.
Wow, thank you so much, Zubeda, for that. The statistics about the Hill report really caught my attention, and it's quite unfortunate that that's how it is. So, Ms. Zubeda, how can a young lawyer who has probably been interested in ADR but has not really had this opportunity to get to learn about ADR, how can this young lawyer transform from being just a courtroom lawyer who is used to litigation and, you know, everything else, probably land transaction, litigation and whatnot, how can they transition into ADR practice?
The first thing I think is basically to understand what ADR is about. Because we spend 4 years in training at law school and then that extra year at LDC trying to learn about law and litigation. So it's going to take some sort of investment in the learning process. But outside that, I will say to you what Mr. Batanda introduced me to arbitration at Petroleum School. When I was starting out as a young lawyer, I asked him, I feel like this is what I want to do, but I don't know how to get there because all the people who were doing ADR at that time were judges, retired judges, Justice Katurevi. You have SIAB, it's a whole institution that is large. You have ICAMIC. But Mr. Batanda told me, right. That is what he told me, right. Because if you want to make headway, make sure your writings get to rooms that you may never make it to. And let your writing be the invitation. Let someone wonder, who is this person? And it is what has worked for me. And when I speak about writing, for instance, I write a lot online. Don't wait to be so clever about the writings. You know, we want to have all this information before you start writing. If you learn about mediation, for instance, what does mediation mean? How is it different from the traditional litigation? That is something I can write about. And if I write consistently about the little things that I'm learning about mediation, Ann Namara, who is in ADR, is going to pick up on that of like, okay, I see this young person coming up, and I think she's interested in this. So the next time there's an opportunity, your name has made it to her desk, and if there's an opportunity, she will easily contact you rather than just sitting back. So write.
Wow, thank you so much. And just to hold on to that thought, you mentioned writing and investing in the learning process, yeah? So is writing the only way of investing in the learning process? Are there other ways that, let's say besides writing, I can get to learn more about ADR?
Yes, there are trainings. There are trainings that SIAB is organizing. We are working on a training program because the complaint has been that training for ADR is very expensive. And so we are trying to create a course that is much more affordable, especially to the young lawyers who are who are I don't want to say broke, but yes. So there are trainings. Then you can also ask, you know, Mr. Batanda emphasized the issue of asking for help. You'll be shocked. Very many people are willing to help you if you ask. Go and see, like if you see something that you like, if you see a lawyer that is representing the sort of lawyer you want to be, go and say, I'm interested in joining this field, but I do not know where to start. You'll be shocked how many opportunities you can get just from making that first ask. Thank you.
Wow, thank you so much. Maybe I can also put the same question to Miss Anne, since she sits on the Committee on Education at, is it SIAB? Yes. Miss Anne, is there something that a young lawyer interested in arbitration who has probably very little idea on how to get started, how maybe CRF is doing something that can help them know more about arbitration, know how to venture into ADR, mediation, how they can just get started? What is CIAB cooking up to, you know, help the young lawyers interested in ADR?
Thank you, Zubeda. Thank you, Ruth. I would like to reiterate what Zubeda has said. You need to be a thought leader. You cannot be seen to be an expert in a field that you don't write about. You need to trumpet your expertise, and one of the ways of trumpeting your expertise is through writing. Zubeda spoke about study. Now, this is something you can't dodge if you want to be an ADR expert, because ADR, at least in my time at campus, and later on at LDC, wasn't taught much. At campus, it wasn't taught. At the Law Development Center, it was 1 week. We had what they called an ADR week. And in that 1 week, you were supposed to understand arbitration, mediation, and all these other forms of ADR in just that 1 week. It was just part of the course. So you actually interface with ADR in the field as a lawyer. So you need to study, and unfortunately, most of the courses don't come cheap. But the fortunate bit of it is that when, for example, you say, I am going to study a course that will make me a member of the Chartered Institute of Arbitrators, what you're getting is more than value for money, because this is a global institution. You will be able to be recognized. It's the platinum standard of ADR practitioners in the world. You can practice as an arbitrator, as a mediator, as an adjudicator, and you're recognized globally, meaning you can get appointed in London, in Paris, in Switzerland, in Nairobi, in Botswana, in Uganda. So that is an investment that the young lawyers we all need to make, because we also made the same investment. But believe you me, you will reap more from it when you're done. Thirdly, what I wanted to add is you need to volunteer, something young lawyers don't want to hear these days. You need to volunteer, come to Chartered Institute of Arbitrators, come to MAMC, come to all these institutions that are doing ADR, and offer your offer your services as a volunteer, even though it might mean doing something that you consider menial. For example, Zubeda may tell you to go and photocopy or get her a cup of tea. The opportunities that are available, first of all, you'll be rubbing shoulders with the ADR experts. Something money cannot buy. Secondly, you'll be chosen upon, you'll be sitting in arbitrations, in mediations, in adjudications, and you'll be learning. Thirdly, when they think of anyone to train or to mentor, because you need a mentor, which is my fourth point, you're not going to get a mentor when you sit back and say, oh, these things are for the senior lawyers. When you're volunteering, you'll easily get mentors, and who does not want to be mentored by the best in the field, really? So young lawyers, just you need to be humble enough to submit to being a volunteer and to submit to mentorship. There's no other way other than those 4 ways that you're going to grow. Thank you. And finally, Ruth had asked about the programs. MAMC, CIAB, Construction Law Institute, which is primarily an adjudication institute and arbitration as well in construction law specifically, organizes programs. Follow them on LinkedIn. The young people are tech savvy. Follow them on LinkedIn, follow them on X, see what their activity calendars are saying. Most of these programs are free meanwhile. Attend a webinar, attend a training, attend an event, save up for the ones that are costly. So attend. You're not going to get anywhere if you don't study, if you don't volunteer, if you don't have a mentor, if you don't write. And then finally, sorry, Ruth, the ADR spectrum is broad. So you need to be known for something. You can't say I'm an ADR practitioner. In what? In banking, in construction law, in investment, in what are you exactly doing? Get a niche and grow yourself in that niche. Thanks, Ruth.
Wow, thank you so much, Anne, for that your wonderful insights. So what I've picked is you have to write. And then you have to invest in education, invest in continuous learning. And that's why we are having these CLEs, continuing legal education, so that you can keep on improving your skills. And she also talked about volunteering. Young lawyers, we are known for not wanting to work for free. So, but it's good to volunteer, because this is when your skills are brought out. This is when you identify some of your strengths, your weaknesses, when you volunteer. And she also mentioned something that I really liked. She said that as you volunteer, you're able to identify mentors that can help you come up. And Ms. Zubeda mentioned how Mr. Batanda mentored her, and here she is today. So thank you so much. So I'd like to go to the next question, which goes to Mr. Isaac. Yes, Mr. Isaac, someone, I have seen a question in the group, but I think I'll come back to questions later. So Mr. Isaac Sekabanja, what are the tangible skills a young lawyer gains by mastering ADR, and how quickly can these skills translate into income and influence?
I hope the question put to me is a bit tricky for one simple reason. You are trying to make money and there is no quick way to making it. So the first skill I'm going to put forward is trusting the process. Invest so well that when it's time for you to fly, you don't doubt your flight. Because oftentimes we want to fly so quick, and then when people come and they're trying to pull you down, you even don't have enough stamina to sustain the arrogance, the insults, those who are just wanting to get a share of what you are trying to build so that they pull you down. So the first thing is invest in the process. But much of the skills that we need have also been talked about by Mr. Batanda. They have also been talked about by Mr. Semambo earlier. They are very pertinent, a kind of skills needed. But for me, in ADR, I will emphasize two skills, or two things that you will have to stand out or sustain yourself in this field. Number one, as I usually tell it to also my students, invest in your exposure. Expose yourself past your being a village star. Many of us are so excited because ndi mwana wa gundi, I'm so and so, so you move around wanting to brag about that. But for you to be a global practitioner, you need to understand that there are people who are better than you across the border. That's when you start saying, how can I get to be that person who is recognized across my village and all over, so that I can bring what you call a gold standard of what I do. That's where things like CIAB come through. If you are into company secretary, that's where things like ICSA come through. You get some of those institutions at a level that can at least put their reputation, can ride with yours, and someone takes you off a profession. The other is investing in your own education. You see, I come from Uganda Christian University. Those universities are not about to collapse because they give tangible knowledge, which knowledge you are not going to get from watching soaps, movies, and reading novels. They are experts in certain fields, and the only way you can cheaply access them is at a university course. Those course outlines are not created just to eat your money. You were a lawyer because someone taught you certain practices of law. So it's important that you expose yourself at that level so well that you don't doubt the level of your intellectual capacity. After you have done that side, please expose yourself at the side of life. What do I mean? Serena was not built for foreigners. Going to Zanzibar, Dubai were not meant for people who come from Europe. They are meant for me and you. The more you expose yourself outside your country, because many of these people represent in arbitration are sometimes billionaires who have global trotted. So if you don't know how people treat themselves across the board, you might stick to your culture, which is a bitter cake. Yet, friends, people are eating bread while walking in where? In Paris. For you, you have to first eat. You first sit to eat. Yet the guy is telling you have a next appointment, can't you eat on your way? So that is the level of exposure I'm looking at. Challenge your culture. There is no gold standard that being a Muganda or being a Mnyankole, it's a best culture. Work with a culture that sustains you in a business environment. We are having workplaces that are lately not even, people don't report to office, but they are working. And they deliver, and the people reporting, and clients are getting results. Now, that is only done by people who have exposure. Those who have refused to expose themselves are stuck with a cloak in. You must come, be physically in, because that is the level of their level of exposure. They think that's how life is. So you as a young lawyer, invest in your what? Exposure, so that when you hit that big area, you have the expertise that take you there. The other is to understand what I call value for money. We as lawyers, we are not taught at the level of our law things that run a business. We don't know things like how people do accrual accounting, cash accounting. We don't know things like ledgers. You have a payables ledgers, you have a receivables ledger. All those things we don't understand. But we worship ourselves in the law. Now, a client comes to you, and this is a CEO of a multinational. People that report to them, HR reports to him, a lawyer, counsel, company secretary reports, project manager reports. So the fellow has become an expert in so many fields by the virtue of the briefs they are receiving. And that is a person you are going to convince to do alternative dispute resolution. Already they have already cancelled themselves out of certain things. So you must give them value for money. Why would they take you as their alternative dispute comforter at that level? So your level of how you understand the opportunity cost of things. Because oftentimes when people do too much litigation, I have been there, I've done it. You clearly see lawyers struggling with the question of how do I tell the opportunity cost of telling my client to get out of litigation? First, because I want fees. So if I conclude this case as a winner, the person will be excited, and then I'll get a lot of fees. But also you are forgetting the longer that dispute takes, the client is looking at value for money. He's looking at, even if I had gotten a little that could have come, I've both gained the reputation, I've managed the reputational risk, but I've also given certainty to my payables. Either I've confirmed a risk which is going to be paid at this amount. The longer you keep me in court, the more I don't know. And we often forget that some of these clients keep on putting us in direct contact with their auditors. And the auditors are going to ask you questions. But just because you didn't do accounting, you don't even try to understand what is this client trying to show me without saying it. That this dispute is something that injures their going concern assessment. So for me, I think invest in your exposure at all levels, academic and social. Thereafter, invest so well to understand value for money by having a business mind. Everything is not about, a good lawyer is not the one that is seen in court in this day-to-day generation. There are lawyers whose job has been negotiating big deals out of what? Court, and they have earned a lot of money, and they don't even interest themselves to come and see the judges. So you as a young lawyer, start small, because whatever I've said is quite big, but start small. Let your peers see you taking an effort where you see a case that can be sorted. It doesn't hurt to be the small voice that informs the client. Can we look at the ways we can settle this? Is it necessary to push this fight past this? That way, you'll get to see the results, and with those small results, you might propel yourself to invest further.
Wow. Thank you so much, Mr. Isaac. So from what you've just said, you've mentioned that you have to trust the process, invest in your own education, expose yourself outside your own culture, challenge your culture, have an open mindset, open to learning. And you said understand value for money and invest in your exposure at all levels, whether academic or social. Many people always they always, they always talk about how lawyers frustrate ADR because maybe they think it's not profitable. They're not able to get quick money, every court appearance. So I want to put this back to you, Mr. Sekavanja. Is ADR profitable? I know you hinted on it, but I like to put that to you and to all, to Zubeda and Anne, because I know right now we need to make money. Yeah, young lawyers need to make money. So is it profitable for me to, go for the mediation option when I know that every court appearance I'm getting some money, in my pocket? Every time I draft pleadings, I'm doing this, I'm filing this, every transaction I have some money. Is ADR profitable? Thank you.
I would say, as I said, understand value for money. He who brings value is paid. And the mistake we make is because we have failed to understand a different way you can provide value to a client, you stuck to the older dege, or you stuck to what you have seen others do. Please feel free, feel comfortable to challenge yourself and take on that uncharted path. I want to tell you, companies, if you study outside the law, they are very happy on mitigating their risk profile. And they will comfortably welcome a person who has that sharp eye and quick to help them mitigate that. It is only those who are so excited to show authority. That's why I said invest in your exposure. Because you might show so much authority that you want to appear to have made a key decision, but in other range you are losing the point of the profitability of the company or whoever is making a decision. So for any lawyer that wonders whether ADR is profitable, for me, I think by the time that question comes to your mind, you haven't exposed yourself good enough to understand how does this work and how do I get the money. So the research I would take back to any person who has that question, either look out for the mentors, or I cannot come here and just tell you it has money. You might tell me that I'm being what? A prophet, what do they call them? A prophet of, you see, I usually tell my students that the new weed is hope. So I don't want to feed you on hope. I want you to take a well-calculated decision that when I take on this, that's how you trust the process. But if you keep on saying, I attended a CLE activity and someone said there is money. No. Please sit down, trust the process, and then with time, you'll get to see the money. Because even the lawyering or the litigation you're talking about, the money doesn't fall from a tree. It simply takes a process. You first have to own your skills. There is LDC after LDC. That is all part of the what? The process. But now you are only going to make the money with the right mindset, which is not about when do I see the money. The money is actually at the end result. First, focus on giving value. The moment you give value, people will pay you without even you asking questions. So focus on what value you deliver, and the rest shall be sorted.
Wow. Thank you so much. I told you we have a wonderful selection of panelists, and I believe we can all testify to that. Yes, so I know, Zubeda, you recently had a webinar on how you can monetize ADR. So I'm putting back the question to you. Is ADR profitable? If so, how is it profitable to a young lawyer who is probably just starting out, who may not have that clientele, who has not yet built up all that clientele and that experience? Thank you.
If you ask me, I would say yes. But it depends on how you look at dispute resolution. If your plan is to squeeze every last cent out of your client and drag this thing on for 20 years, then you will never see the opportunity in ADR, because you're so used to picking the 200,000 and the 500,000 that you get from the court appearances. But actually, what you give your client is a promise of resolution. Most clients, and this has been said severally, when they come to you, they do not care about your credentials, how eloquent you are, and how many sections of law you have. They don't. They come to you with a problem and they want a solution. So the lawyer who can provide a fast solution is going to make the most money. So rather than you thinking about it in terms of, let me drag this thing on for 20 years and hopefully at the end of it I'll get costs, tell the client, I am getting you a solution. If it is a family issue, you are going to have this sorted so that you can maybe reconcile with your wife or get rid of your wife if that is what he wants and move on with your life, because that is what we all want. Number two, I think we miss the point when we work against human behavior. The way we center ourselves as lawyers, I think Mr. Semambo said, we wait for our clients' cases and we use them as a legal adventure. Today, Miss Anne is going to sue me, so I'm sending her a notice of intention to sue. And really, it should be people-centered and you can make money out of it. Because if your track record of resolving disputes is high, trust me, all clients will be running to you. Then the other thing, the webinar, you spoke about the webinar. It was about how to make money out of mediation. And it's unfortunate that some members here didn't attend it. It was such an eye-opener. You know, Nigeria is a way bigger economy, and it has, even its ADR has advanced way faster than us. And the way they do their things is quite amazing. So Mr. Fowler, who was my guest, had the different ways of you earning money for mediation. And he was talking about, of course, training. That is there. Miss Namara here has been, she's a trainer in various capacities. You can train, you can be a mediator, you can be a mediation advocate where you represent your client in a mediation. You can do community mediations. There's a lot of ground to cover. Actually, if you're thinking about it, I told you only 10% of cases in Uganda use a lawyer. So there is an untapped market of 90%. So I do not know why it makes sense for lawyers to insist on squeezing the 10% when the 9% are there. You can actually create your market. So I think ADR is very profitable, and whether you like it or not, we are going ADR. At the new lawyer, the Chief Justice said that the plan is for the judiciary to only entertain 5% of cases. So either you're going to be forced by the court, you're going to be forced by the court. Oh, I've seen instances where courts get clients to mediate behind their lawyers' backs. Yes, because the client is seeking a solution. Me, I'm tired of fighting, and the lawyer is saying no. So what happens is that they go to the registry and say, let's explore this mediation thing, and if it works, that is how actually you shut yourself out of payment. And yet, if you played along, help this client get the resolution, you can secure your payment. Thank you.
Wow, thank you so much, Zubeda. Yes, Miss Anne.
I believe my colleagues have said it all. Just to add that there is no client worth their salt who wants to go to court. And it's worse in the construction space. There is no investor or contractor who wants to go to court and spend 10 years, and yet they have a project, they invested money, they borrowed money from the bank, and they are in court because the project has stalled. So ADR is profitable, as my colleagues said, because at the end of the day, a client is looking for a lawyer who will give them a very quick solution. They're not looking to court. Actually, most of them, we're talking of the big time clients, do not want to go to court at all. They want to settle at the earliest opportunity. So the lawyer of the future is the one who is going to help a client to get a solution. And as you help the client get a solution, definitely there will be money in your pocket, and definitely you'll be known as an ADR expert. It's a ripple effect. You help one client and they will speak your name to another, and at the end of the day, you have you're known as the ADR champion of your time. And tell me, what is more profitable than that? Thanks.
Wow, thank you so much, Anne, for that. Yes, so Anne, back to you. Putting to your question, you mentioned the construction sector, and I know you have expertise in that. With Uganda's booming construction, energy, and commercial sectors, how much of your career growth depends on knowing ADR versus just practicing litigation?
Thank you, Ruth. My answer is your entire your entire career growth depends on knowing ADR, because, like I mentioned, there is no client in the construction sector who wants to hear that, oh, now let's go to court and fight it out for 10 years. And yet, not only have they borrowed, but they had a plan for that project. So if you're going to stall them for 10 years, it will not go down well with them. And the questions that they will usually ask you before onboarding you is, how good are you? Are you an arbitrator? Have you sat in arbitrations? Are you a mediator? Are you an adjudicator? And to make it more specific, there are certain types of contracts that are unique in the construction space. There are clients who will use what we call the FIDIC conditions of contract, and those ones specifically provide for ADR. Unless the parties change the terms, you will never find litigation in a FIDIC condition of contract. So how are you going to help a client? And most of these big projects, at least in Africa, use the FIDIC conditions of contract. So you are not able to help that client resolve their dispute if you don't have knowledge as an arbitrator, as a mediator, as an adjudicator, because the contract is so specific. If the engineer of the project has failed to help you, then the adjudicator has to help you. If the adjudicator has failed to help you, then the arbitrator has to help you. So in order to come an expert, you should be able to know how to resolve these disputes through ADR. So to answer your question, Ruth, your entire ADR, at least in the construction, energy, and oil space, you need to position yourself as an ADR expert. There is no room or there is barely any room for litigation in the construction, energy, and oil sector. Thank you.
Thank you so much, Anne, for that. And I've seen a question in the chat, and it talks about skills. And I just want to put another question to you. ADR isn't just about resolving disputes. It's a networking gold mine. How can young lawyers leverage ADR for connections that really matter?
Thank you, Ruth. In the beginning, I said that you need to occupy space, and you need to occupy space by volunteering. Now, when you volunteer in all these events, sorry about that. When you volunteer in all these events, you get to rub shoulders with the who is who in the ADR space, and as you get to attend these events, you'll see the same faces at the arbitration conferences. You'll see the same faces at the adjudication conferences. You will see the same faces at the dispute board conference. So, like Isaac said, if you don't attend these events, then you're missing out. So, you may say they are expensive. Of course, they are very expensive. But make sure you are in that room. Make sure you are in that room as a mentee. Make sure you are in that room as a volunteer. Make sure you are in that room as an attendee. Because the next time they're looking for an ADR expert in Uganda, your name will automatically come up. Because it's not only about the conferences or the events, there's always a specific time set apart for networking, as we call it. There'll be a dinner, there'll be a cocktail, there'll be some manner of gathering that says you, that is just specifically for networking. And when you go there, don't just be docile and sit. Interact with people, throw around your business card. It would be great at that time to have some little knowledge. So when people are speaking about dispute ADR, you're not stuck. At least you also have something to contribute. So yes, there are a myriad of ways to network in the ADR space, but be present, show up. Show up, occupy the room, even though it is carrying the bag of a speaker. Zubeda is on a panel and she walks in with a bag, carry it for her. She will not forget you. She will get to know your name. She'll give you her business card. And then follow up after that. Send an email, send a WhatsApp, give a call, introduce yourself and how you met with the person. But you must be present. You must be very visible. Because the networking opportunities are there. You must be present in the room. Thank you.
Well, thank you so much, Anne. That was in response to Mr. Bruce Cherere's question. He says, I keep hearing from panelists repeatedly telling us ADR preserves relationships. How does it do that? Let me pose that to Mr. Isaac. How does ADR preserve relationships?
Mr. Bruce, what you're talking about is actually the bedrock of alternative dispute resolution. For those that are properly trained in ADR, they are you get the skill to calculatively harness any opportunity that will help parties preserve that relationship. Because alternative dispute resolution is all about preserving that business that you started. Many people, there are so many statistics that go around saying Ugandan businesses don't see their next birthday. But we fail to investigate that behind that failure to see the next birthday could be unresolved client expectations, where you push them under the bed, then those clients disappear. Or you don't get the proper feedback. When people challenge either your service delivery, you take it as an attack on self. Yet it could be an opportunity to get feedback. So the reality is that when you come to ADR practitioners, they are quick to resolve what is emotional and what is actually important service feedback, which you must get. And we can build slowly but surely to help someone come from the emotional self where they feel like you saying you are not satisfied with their services is an attack on their egos. Because I understand oftentimes some people put in a lot to deliver certain things. So all they want to hear is praise and worship. But at the ADR table, we are very accommodative to use the spotlight. Either you get feedback, and there are also at times some of those relationships that are being spoiled, not by the making of the parties involved, but it could be the background noise. So this is the time where we clear a lot of things. And at times, we as lawyers, we are trained to eat from, what should I call it, from the chaos. Because you pitch parties against others. Because at times, at a certain level of exposure, you think it gives you a bit of mileage to tell the client what they want to hear, not knowing you are promoting intellectual dishonesty. At times you need to tell the client, but I think what we are saying, we don't have evidence to support it. That in itself helps. So at the ADR table, when you are negotiating, we might start with a bit of honesty. That honesty might actually help to remove the misconceptions. And before you know it, we are trained to say, because it's party driven. If a party says, I've forgiven the other, even if you think for you it is a wrong bargain, it is not your duty to tell them, no, you are stooping so low. Why are you accepting that? If for him to preserve peace is accepting to take a low price for their own peace, you are not in control of the factors thereafter. That in itself is enough. We shall not investigate it and then start saying, no, that man is using his either undue intelligence, because the issues at stake, you don't know them. But for them as parties, they know what is common to themselves. If you find a child accepting to take a low bargain from the father, it could be out of respect for the father. You cannot, because you are their litigant, tell them, you could have actually gotten $1 billion. I've done such cases where someone tells the wife tells the husband, why are we fighting so much? This man is telling you to give us 7 million. Can we take it and leave? Me, I'm tired of seeing you loitering in court. And the wife is like, the husband is like, it's okay, let me take it. But you see the lawyer telling you, I drafted pleadings, there is 1 billion in there. And before you know it, the case is dismissed with costs to the person who was going to be given 1 billion, who was going to be given like 7 million. What does that show? You have failed to understand that the parties control this process. For them, if they have made peace with certain things, you should also make peace, because this is not your case.
Oh, thank you. Would you like to say about that?
Yes, I think as lawyers, because of our training, the nature of our training, well, sometimes you're like, okay, the nature of our training just puts us in a place where we want to fight. We want to speak. We want to show our force and our might. And we forget the essence of the whole thing. You really need to kind of unlearn some of those things that we learned about dispute resolution and put the clients at the center. In the beginning, Justice Katurebe was referring to a case of a family where children were fighting with their mother. And when they came in, the mother was calling them Ebyana, and the children were calling their mother Omukazi. That woman is very difficult. Mukazi oyo, very difficult. But because he understood the delicacy of the relationship, he did his best. Rather than just push for the law, he pushed for the relationship to survive. And ultimately, when he was done with resolution, he said, the children knelt down and said to their mother, forgive us. And I think that should be more important than you breaking this family furthermore apart. So when it comes to preserving relationship, I do not think litigation can compete. Because even when it comes to business relationships, you have been dealing with this organization for maybe 10 years. Just because this time there was a problem in delivery doesn't necessarily mean you want to end the relationship. And also sometimes it is that you have dealt so much that you fighting publicly would unravel a lot of trade secrets and basically things that you don't want out there. So you realize at the end of the day that choosing alternative dispute resolution that is private and seeks to preserve the relationship would work better for the clients. Thank you.
Well, thank you so much, Zubeda. Yes, kindly put your questions in the chat or in the Q. We're going to be closely following the chat, so please let's not tire to ask questions. Yes, so we are just concluding, and I'd like to put a question to Miss Anne. What advice would you give a lawyer interested in venturing into ADR and the construction law sector? What should be their starting point? Because I'm seeing Pamela Nalonkuma in the chat. She says that Pamela Nalonkoma in the chat says, I want to study a course that will make me an accredited arbitrator, mediator, and adjudicator. Kindly give us more information on where to do the training in them. So, Miss Anne, what should Pamela's starting point be as a young lawyer who is interested in venturing into ADR and maybe the construction law sector? Thank you.
Okay, thank you, Pamela. That question is very brilliant. As I mentioned in the beginning, you have to invest in yourself and study. And as I said, the platinum standard for ADR practitioners in the world is a qualification granted from the Chartered Institute of Arbitrators. So that is your starting point. The pathway training, the first pathway training is you become an associate member. You become an associate arbitrator or an associate mediator or an associate adjudicator. So you can finish the pathway for the arbitration, then you will embark on the one for the mediation, and then you will embark on the one for the adjudication. It takes long because each ADR spectrum has about four levels: associate, member, fellow, and then the ultimate, which is the chartered arbitrator. So you might want to choose where exactly you want to play from. Do you want to play in the arbitration space? Do you want to play in the adjudication space? Do you want to be in the mediation space? So yes, get a qualification. The Uganda chapter of the Chartered Institute of Arbitrators organizes these courses. Follow us on LinkedIn, follow us on X for our activity calendars. Become a member, become a young member of these institutes. Become a young member of Muslim Arbitration and Mediation Center Uganda. Become a young member of Chartered Institute of Arbitrators Uganda chapter. Come and help your fellow young people, because the young members are doing great in the chapter. They're organizing conferences, and in these conferences you network with people from around the world. They're organizing trainings, they're organizing webinars, they're interacting with the senior ADR practitioners and getting experience, because if you want to be an arbitrator or mediator or adjudicator and you're not out there, you will not get the experience, because people appoint those they know. I'm not going to appoint a stranger when there is Zubeda I know is competent and I've seen her competence. So there's Isaac. And then you should also, like I said, you should serve. Isaac and I sit on the same committee of SIAB, the education committee, and he'll tell you it's lots of work. Imagine doing lots of work but for free. But we have gotten we've gotten to know many people. We've gotten to go places. We've gotten to sit on panels like this. I know if we were not out there volunteering, no one would know us. So we work like we're on salary, yet we're working for absolutely zero. Zubeda, I think, might be running a loss-making entity in MAMC. I'm not sure she gets money from there. But the people she has met are invaluable. The experiences, you can never trade them for money. In the construction space, there are different institutes, but locally we have the Construction Law Institute. Follow us on X, follow us on LinkedIn, follow us on the website, constructionlawinstitute.com. It organizes trainings periodically. It has an annual training every July. Next year, it's going to introduce modules. So we shall have about 10 modules where you will handle every spectrum of construction, from inception, from procurement to dispute resolution. 10 modules. So just follow us. You follow the activity calendars, and it is going to be absolute value for money. And become a member of Construction Law Institute. Go to the website and see how to apply. Become a young member of Construction Law Institute. Go to the website and see how to apply. So that's what I would advise a young lawyer. Upskill yourself. No one is going to want to look at you when you have no skills. Serve, volunteer, get a mentor. And like I said, no one is going to want to mentor you when you're also not adding value to them as a mentee. And you add value to them by serving them and being around all these places where they are. That is how you are going to grow. Thank you.
Wow, thank you so much, Anne. And I love the fact that you talked about the Construction Law Institute, because I know that you conduct free webinars. Just yesterday, there was a free webinar with CLE points, moreover, accredited to it. So please, let's always keep abreast with what's happening. She has talked about their LinkedIn. Let's look up Construction Law Institute. Let's look up the Muslim Arbitration and Mediation Center. Let's look up SIAB Uganda. What's happening? I know they have an upcoming dinner.
No, international conference, the first of its kind in Uganda. It's going to be held in November 13th to 14th. Please come. Please come and attend. The details are there's a website, a dedicated website where you'll find the details, but they're also on social media, on the LinkedIn and X. This is a gathering of all arbitrators and mediators and adjudicators from across the world. They are coming as we promote Uganda as a safe seat for arbitration. Because, as I said, no investor wants to come to a country where litigation is promoted. So we're going to hear from the judges what they're doing about preserving ADR, what happens when they are faced with arbitral awards, are they upholding them? We're going to hear from the CEOs, how do they find this ADR thing? Are the lawyers being shady? Are the lawyers delaying justice? We're going to hear from the private sectors, what can we do better? We're going to hear from the young arbitrators, because they also have their own space. So 13th and 14th, mark your calendar. Please join us at Mestil for the for the biggest event of the year in Uganda in the ADR space. Thank you.
Wow, you had that right from Anne. Yes, Mr. Beda, would you like to speak into this question from Pamela about how a young lawyer can get into the ADR space? To do a course. Yes.
Yeah, we already mentioned training is a must. Because if you want to show up as a professional, you need to be professional first. It's going to back you up very well, and it's also going to open up the opportunities. I have a training. I've studied mediation, and I would like to get a mentor. Or I've studied mediation, and I would like to get the accreditation. So training is a must. Number two, I think lawyers, if you are trying to get into the ADR space, I don't know which social media platforms you're on, but you need to be on LinkedIn. It's where a lot of these things are happening. Like they're talking about the SIAB conference, and they're advertising, they're always posting it on their platform. But if you're not on LinkedIn, then no one is going to, you might miss out on the information. Then also the free webinars. All these, they are free webinars, there's free information out there, but only if you're willing to tap into it. I don't think you're going to find a SIAB advertisement on TikTok. It might not be there. Mam Kwak is not on TikTok as we speak. So I think you need to tap into spaces that promote your professional profile. Number two is ADR is a language that is not only being promoted in Uganda, but it is promoted all over the world. So you need to be in a space that is going to enhance your understanding of ADR from different perspectives. Mr. Sekabanja was talking about exposure. And with social media and the internet, you can be in Uganda and connect with people from different countries. For instance, when I speak about our collaboration with the Organization of Islamic Conference Cooperation Arbitration Center, every time I tell the story, people get shocked. I was on a random Sunday on LinkedIn scrolling, and I see someone that is doing some work in the Islamic human rights. And so when I reached out, I just said, hi, I see you're doing the same work as I am, and I will be willing to learn from you. He asked me, where are you from? He said, and I told him I'm from Uganda. And he's like, oh, okay, I actually met someone from Uganda in a conference, and I think I love Ugandans, and yeah. The next thing I know, he actually handed me the Secretary General's number. Because when we met on a Zoom call, he was like, I feel like I trust you with the work you've been doing. I trust you. I feel like you are really doing great work, and I trust your intentions. So he just literally gave me the number to the OIC Arbitration Center Secretary General. And you might not know, but for us in the Muslim world, the OIC is like the UN of the Muslim world. It has 57 countries. So it brings together all these. This is not something you're going to, many young lawyers are complaining about gatekeepers, but when you really think about it, you're gatekeeping yourself because you're not putting yourself in spaces where you can grow. The world is out there for you to grab, but only if you're willing to take the chance. So please plug yourself in spaces where you can learn and also be humble. I have had my article when I wrote for the SIAB newsletter. Miss Anne edited my paper. And there was that back and forth. Okay, what does this mean? Please cover more detail on this and that. But what that does is that she got to know me better, and I also got to appreciate her better as a writer, as a professional. And so maybe from that one article that I've written with the SIAB newsletter, it can be a reason as to why she can actually recommend me for something. But you're not going to show up in a suit and expect someone to recommend you. Let your work be seen and plug yourself in spaces where you can grow. Thank you.
Wow, thank you so much for that, Zubeda. So as we conclude, and I'm going to come back to you, Mr. Isaac. What is that one ADR skill every young lawyer should master today to be competitive in the next 5 years? I know we've spoken a lot about investing in yourself, putting yourself out there, but what is that one skill that will help this young lawyer stand out and be competitive in the near future? Thank you.
You see, to give you one skill is self-defeatist because I come from multiple backgrounds professionally. I'll tell you I'm a construction law expert, I'm a project management expert, I'm a monitoring and evaluation expert, and then you come and lecture. So skilling yourself cannot be made on one stand alone because there is no one size that fits all. So the first thing I'm going to say, first do a self-evaluation, because some of you are very aloof. So if you just reduce your being aloof to others and then you be a bit more social, you join things like Rotary, you join that car sale in church, you become a volunteer somewhere, you go to ULS, you ask how can I be volunteering with you. You see, that way you might be killing the aloof self. So for me, the starting point is you do a self-assessment, be self-aware. Don't be the kind that seeks validation from others. Many people are going to validate you from the point of what they want to take from you. Oftentimes it's a give and take, but you also need to be sure of who you are and where you want to be. But to crown it all, if I was to tell something that would stand out, at least invest so heavily in your interpersonal skills. So heavily that even when you study things, you don't become a show-off because I have this and that. People need to come and relate with you and feel welcome. So you are that kind of a person that fits in all sizes. But that you are going to do that with a very good interpersonal skills. Those skills, you know, some of them are called Ubuntu Bulamu, which we call Ubuntu, and so many, which are gotten from home. So the interpersonal skills will actually help so much to bring out the other professional skills, because you have to relate with others. Even if we are saying AI is the next thing, AI doesn't have interpersonal skills. And that is something that is going to remain relevant for human beings, where you have a human interaction.
Wow, thank you so much, Isaac, for that. Miss Anne, would you like to also answer that. What is that one skill that you feel is really relevant to make a young lawyer stand out in the near future?
Thank you, Ruth. I would want to propose two. One is a calm personality. As an ADR expert, you will not, we come to ADR with litigation techniques, highly combative. You need to have a very, very calm personality. The other thing you need to have is humility and having a teachable spirit. If you come and you think you are the star, as most young people want to be, then there is nothing you're going to do in the ADR space. You need to come with humility, ready to learn, ready to be rebuked, but knowing that it will help you to grow. Thank you.
Wow, thank you for that. Yes, Zubeda?
I think this is not specific to ADR. Communicating your value. You need to sit with yourself. I've had a lot of people who come to me for mentorship. And usually I send them a 10-question document asking, who are you? What do you want? And there are many questions there. What are your strengths? And at the end of the day, if this was your tombstone, what do you want to be written on it? And most people don't come back because we do not like introspecting. We don't like to look back. The noise takes us. I am watching TikTok. I am seeing Anne fighting with so and so. Those are the things that excite us. You don't want to sit with yourself to know who you are. And without that, you're going to be everywhere. Now, I think construction is the new thing. You run to construction because they said you'll do the course. And then you won't do anything with it. Because many lawyers have a lot of qualifications. But can they convert those qualifications into something meaningful? So if you don't introspect, you will not be able to communicate your value. And if you don't know your value, how can we help you? Yeah? You need to be able to communicate with clarity. Sit with yourself, understand who you are. And for me, I'm a firm believer that God put something special in each one of us. And I've said this to Joy severally. You just need to sit with yourself and understand that. The qualifications would actually be that icing on the top. So learn to communicate your value with clarity. Thank you.
Wow, thank you so much. The discussion has been very enriching. I know our participants that it has been a very enriching discussion. So right now we're going to just have our parting shots, and we can start with you, Zubeda. What are your parting shots and advice to a young lawyer? So much has been said, about so much. So what are your parting shots in this regard for a young lawyer that is, considering venturing into DR and ADR practice? Thank you.
ADR is the future. Whether you get on board or not, this ship is sailing.
Very brief and concise. ADR is the future. Whether you get on it is sailing. Wow, thank you so much. And Miss Anne, what are your parting shots to the young lawyer?
Thank you, Ruth. Let me be a bit more gentle. The ADR is the future. The ship is sailing. Kindly let it not leave you behind. Please join. Please join the ship before it gets too full. Secondly, I would like to once again reiterate the invite from CIAB Uganda chapter for our conference. Come and we continue this discussion 13th, 14th November, Kampala, Uganda, International Arbitration Conference at Mestil. Thank you so much.
Thank you so much, Anne. Yes, Mr. Isaac, what are your parting shots to the young lawyers out there interested in ADR?
My parting shot to a young lawyer is going to be informed by the reality we found when we just started out in ADR. Because I remember when I first did my master's and all that, the ADR space wasn't vibrant as it is now. Why? Because I realized those that came before us invested in building barriers than bridges. So for me, what I'm telling a young lawyer, please invest in building bridges. We have so many ADR practicing institutions. We have MAMC, we have SIAB, we have ICAMEC, Praxis. All those are institutions doing one what? Thing and serving clients that are enough for all of us. So don't sit there and you are lied to that this one is far better than the other. That is trying to be petty. Yours is to give value and go where value is appreciated and given. So build bridges, leave this divisive center which we might be having later in society, exchanging insults and all those things. We need to work more together so that the society where we are getting clients from takes us more seriously. You can't be divided at home and you preach unity outside your home. You are just a liar. So me, when I was starting out, and I still say the same, focus on building bridges. Don't fight unnecessary wars that are going to injure your reputation, but build bridges and work with those that want harmony and are fostering progress.
Wow, thank you so much, dear panelists. And we're coming back right in the chat. In case there are questions, you can feel free, our online audience, feel free to just raise your hand and we can unmute you and allow you to ask your question. But for now, Miss Pamela Nalonkuma says, thanks to all panelists, you have done us well. God bless you. To the moderator, we are grateful. And to my fellow lawyers, thank you for attending. And she has a question for Anne. She's saying, Anne, kindly let us know how much the International Arbitration Conference shall be, so that we prepare in advance. She has asked as a young lawyer. So yes, is there a discount for young lawyers?
There is a discount for young members of the institute, of the chapter. The young members of if you are a young member of SIAB, whichever country you're from, there's a discount. Otherwise, the standard fee for non-members of SIAB is only 550,000. And for the SIAB members, it's only 500,000. For the SIAB young members, it is only 470,000. But please watch out, we're going to be having flash sales where those fees will be massively discounted. Follow us for those flash sales. So you win either way. Thank you.
So young lawyers, I hope Pamela has heard that. Please be on the lookout for the flash sales that is going to be shared shortly. Please follow them on LinkedIn, on their socials. Follow MAMC. And it's no coincidence that this Young Lawyers Symposium is being sponsored by two very, prominent players in the ADR field. We have the Muslim Arbitration and Mediation Center, represented by Zubeda, and we have also Praxis Conflict Center that are our hosts for this Young Lawyers Symposium. And then our other partner is Bluebell Legal Advocates. Thank you all so much for sponsoring this Young Lawyers Symposium. I believe we've got more than value for our money, right? It's been quite enriching discussions from morning till this afternoon. And in case there are no questions at this juncture, I'd like to just conclude this panel and encourage us to stay tuned for tomorrow. The Young Lawyer Symposium is still on for 2 days. Tomorrow we still have a lot prepared for you. Tomorrow we are having a panel on personal branding for lawyers. Please make sure you don't miss. It's going to be moderated by Mr. Samuel Taremwa from Bluebell Legal Advocates. And on the panel, we have Miss Brownie Ebao, we have Miss Zuria Nagadia, and we have Miss Bridget Kusima. Brownie is from National Water and Sewage Corporation, and Miss Zuria is an expert in automation and personal branding. Miss Bridget Kusima is a partner at SM and Company Advocates. And then we shall also have a session on practicing law while maintaining ethics and integrity within a corrupt society. Yes, and this will be by Miss Christine Birabuan Subuga from Praxis. And then we shall also have a panel discussion on financial planning and literacy, financial planning and investment for young lawyers. It's going to be moderated by Mr. Muyaka Alfred. Mr. Muyaka Alfred has also just been nominated as a candidate as a representative for the ELS young lawyers, and he's going to be moderating this panel. On this panel we have Miss Daniel Ayevare, we have Mr. Alex Max Manzi, and Miss Hilda Afekuru. And then finally, we shall also have a panel on tech for young lawyers. What are the opportunities in tech for young lawyers? The topic is Tech Frontiers, Charting New Territories and Opportunities for Young Lawyers in the Digital Age. This panel will be moderated by Mr. Higenyi Simon, who is the founder of AI Lex. He's a young lawyer as well, already into the tech sector. And on this panel, we have Miss Alice Namuli Blazevic from CATS. We have she's a partner at CATS, Katende Sempewa Advocates. We have Mr. Opio Isaac Peter. He's a founder of the Techno-Legal Advisory Center Uganda. He's also a young lawyer who is also already into tech. And then we have Mr. Patrick Lubwama, who is a senior associate at Kasiri Biarohang and Company Advocates. So we also have a panel on balancing family commitments. Yes, how can you as a young lawyer who is, you're managing your career, you're balancing your family, how are you able to manage this? And that will be, it's the title of the panel discussion is the double brief, managing family commitments while building your legal career. And on this panel, we have Mr. Naboth Muhaire, Miss Sania Namugera, and Mr. Emmanuel Echima. This panel will be moderated by Miss Linda Alinda Ikanza. So as you've heard, we have a wonderful lineup for you for tomorrow. So please, please, please ensure we are logged in early. By 9 a.m. we shall be starting, and it's going to be a wonderful, wonderful time. So with that, I'd like to take this opportunity to thank our panelists, Miss Anne Musinguzi, thank you so much, Miss Zubeda Namgenyi, and Mr. Isaac Sekabanja. Thank you so much, our panelists. It has been an enriching discussion. We've learned so much, and I believe that we have many people that are now interested in ADR, many young lawyers. Yes, so with that, we've come to the end of day 1 of our Young Lawyers Symposium, and I'd like to thank you all. I don't know if I should hand over to our MC. Yes, so our MC, Miss Joy, over to you. Thank you.
Very much. Thank you very much, Ruth, and thank you for that amazing panel discussion on ADR. I hope it has been insightful for you. Thank you, colleagues, for staying the course with us from when this started. We started off with a discussion on law, leadership, and legacy, positioning yourself for lasting Relevance by Chief Justice Katerebe. If you missed it, I think there are highlights. The highlight was he shared his story, but talked about the need for you to read, the need for you to preserve a legacy, and to also know why you went to school, why did you study law, and what do you want? With the knowledge that you have, what kind of legacy do you want? What do you want people to say about you? And I like that this question has been popping in different ways for all the panels. And we also had a panel on legal writing for young lawyers, the 360 angle. This was by Counsel Semambo Rashid, and he was very thorough. And he was, I remember, so he said he has OCD, so he cannot stand anything that is not professional, okay? So he challenged you and us and myself and all the lawyers generally that we need to pay attention and not just wake up and do pleadings as we wish, but to best tell a story with our pleadings from where it started, where it's going and all that, and make people feel something. And then we had another panel on winning beyond the law books, mastering the human side of legal practice, soft skills that move the needle. And this was by Mr. Batanda Gerald, and he also did great service with us. And he reminded us that, these are human beings we are dealing with, and you need to learn to, what are those soft skills that you need. And I think he emphasized the importance of, what is it? It's not bargaining. What is the term for it? Yes, you need to learn how to bargain. You need to learn how to show up and stand for yourself and not cut yourself short. And then this is the last panel, and we had, I think, another panel on communication. Yes. So we have had a very, very amazing, insightful time. So once again, thank you very much. They've already taken you through the program and the lineup for the panels tomorrow. My name is Joy E. Thank you very much for being here up to the end. So from us to you, have a lovely evening. See you tomorrow. We start at 9. Au revoir.